Mm. Good afternoon, Bakshi sir. Only the subject for more than 200 students was admitted from studies in various institutions. Various institute म्हणायचं ना? एकच कुठेतरी yes. Various institutions in the last 5 years. Okay? आता इथे आपल्याकडे जो काही GR चा नेट क्वालिफाईडचा डेटा आहे तो 4 विद्यार्थी आहेत. So 4 students qualified in state and national level examination. Set. There are four students.
Good afternoon, sir.
Good afternoon, everybody. Good afternoon.
Sir, I'm Gauri Gulati. So we'll just be starting the session in 5 minutes. We're just waiting for Vimal ma'am to join.
Okay, no problem. Please take your time.
Thank you, sir.
Yeah, good afternoon, everyone.
Good afternoon, ma'am.
Good afternoon, ma'am.
Shall we start now?
Yeah, please.
Good afternoon, ma'am. Good afternoon, Bakshi sir.
Good afternoon, please.
Good afternoon, everybody.
Good afternoon, sir.
Ma'am, with your permission and sir's permission, can we begin with the inaugural ceremony?
Yes, please. Yeah.
Good afternoon, respected guests and all the participants. I, Gauri Gulati, welcome you all to the inaugural ceremony of National Level Workshop cum 1 week faculty development program organized by Guru Angad Dev Teaching Learning Center, a scheme under Pandit Madan Mohan Malviya National Mission on Teachers and Teaching, Ministry of Education, Government of India, powered by Droid Pinal Group, a unit of Arjun Das Gulati Memorial Society, Prayagraj. I would like to continue with the session with a quick introduction about our organizing committees. Pandit Madan Mohan Malviya National Mission on Teachers and Teaching is a scheme launched by the Ministry of Human Resource Development, Government of India. The aim of the scheme is to improve the quality of school and higher education by comprehensively addressing all issues related to teachers, teaching, teacher preparation, professional development, curriculum design, and developing assessment and evaluation methodology, research in pedagogy, and developing effective pedagogy. Many centers, such as TLC, FDC, School of Education, etc. have been opened throughout the country. Guru Angad Dev Teaching Learning Center, GDTLC, was inaugurated on 1st July 2016 by Srimati Smriti Zubin Irani. GADTLC is a leading center of Ministry of Education, Government of India under Pandit Madan Mohan Malviya National Mission on Teachers and Teaching. GADTLC has been created under the Pandit Madan Mohan Malviya National Mission on Teachers and Teaching of the Ministry of Human Resource Development, Government of India, which addresses comprehensively all issues related to teachers, teaching, teacher preparation, and professional development, and thus helps in the preparation of modern age ICT savvy teachers. The center empowers through various basic and advanced workshops for teachers in pedagogy, virtual and blended, and ICT skills. MHRD has also selected GADTLC as the National Resource Center NRC of Chemistry in 2018. Since 2016, it has trained more than 73,000 teachers in the areas of e-learning, blended learning pedagogies, ICT tools, and educational technologies, etc. The core team of GADTLC has the expertise of developing more than 50 MOOCs for SWAM platform of Government of India, and the e-content produced by GADTLC has been rated as one of the best in quality at the national level. Now, I would like to continue with the Joint Pinel Group, a unit of Arjun Das Gulati Memorial Society. The Arjun Das Gulati Memorial Society, which is registered under the Societies Registration Act 1860 with the order of the Registrar of Societies, has catered to the objectives of Joint Pinel Group. The organization is signing MOUs with universities, colleges, and organizations for the welfare and encouragement of young minds in the research and publication. Joint Pinel Group is an initiative taken in the legal field to provide the discussions on minute nuances involved in the intricacies of law in a simple and qualified manner. The Joint Pinel Indian Law Journal on IPR was established in 2019 and DP newsletter in 2019 and Joint Pinel publication in the year 2020 under the banner of Joint Pinel Group, a unit of Arjun Das Gulati Memorial Society, Prayagraj. The Joint Pinel Group is established for the purpose of promoting interest by organizing workshops, refresher courses, faculty development programs, capacity building programs, seminars, debates, and discussions. Not only this, but also the Joint Pinel Group focuses on imparting free education and training to poor and needy students. The group is actively involved in the promotion of legal aid to poor and aggrieved classes of society by regularly organizing free legal aid camps. Now, I would request Mr. Gaurav Gulati, Advocate, Allahabad High Court, to please brief us about the program. Over to you, sir.
Very good afternoon to all our dear participants who joined from all across the nation, and my warm welcome to Professor Bakshi and Professor Vimal Ma'am, who has been a constant support for us and giving us every time an opportunity to organize various events with them. So today we are here at the inaugural ceremony of the 7 days faculty development program and national level workshop. So we will be covering 4 major topics on this workshop. So we will be covering the Right to Information Act, which was an important act, which was enacted in 2005. And the second workshop which we will be covering is the intellectual property rights, which is a very major and a very important concept which is developing and will be a very important and a major part for the teachers who are teaching and also for those who are into patenting and copyright. So the third is a very interesting topic, which is an alternate dispute resolution. alternate dispute resolution is a mechanism where without going to the court, we can resolve the issues outside the court through various methods. There can be arbitration, there can be mediation, conciliation, and there are several other options which can be taken up, and the matters can be sorted out or they can be settled outside the court. So this is one of the major and a leading concept which is coming up in India, and we are like being an advocate. I would because we'll be having more sessions on these topics. So these are the major things which we'll be covering. And the fourth workshop which we will be taking up will be a workshop on public policy and governance. Public policy and governance is also a very important concept which is booming in the country with agenda setting and policy formations. And there are certain other measures of adoption and implementation of new policies, public policies, and governance through which major changes. Like if we talk about the new education policy, it is also a policy which was implemented, and now every school and colleges and universities are implementing their work as per the new policy. So this is how a policy works, and there are certain other things which we will be covering. We will be there are evaluations and policy maintenance. So this is how we will be covering all these topics in these 8 days. So wherein these program will give you an insight of major things which in which it is not for the legal background, it is for also for the multidisciplinary background, because here every teacher needs to know various aspects of copyright, various aspects of alternate dispute resolutions, various aspects of right to information, and policy and governance. So this is how we will be covering major topics here on through these 8 days of this workshop, wherein we have already everyone has already read with the brochures, and they will be getting the resource person who will be taking up the sessions. So this is how this 8-day journey will go on, and we will be taking up things. And when it comes to the for the faculties who've joined us for the faculty development program, there will be we will have their assignments, projects, and MCQs based on these topics, and whatever videos we'll be having, and whatever sessions we'll be taking up, the resource person. So these things will be taken up, and the tomorrow we will be having one session for my e-class, wherein the faculties who joined with us, they will be given an insight how to proceed with the faculty development program. So this is how we will be coming up with these 8 days, and I welcome everyone on this event, and my sincere gratitude to Professor Vimal ma'am and Professor Bakshi sir. Thank you so much. Over to you, Gauri.
Thank you, sir. Now I would welcome our guest of honor, Dr. Vimal Rar ma'am, National Coordinator, Guru Angad Dev Teaching Learning Center. Professor Vimal Rar is a leading women edupreneur in the field of e-learning with a decade of experience in the corporate e-learning world, and is amongst the pioneers in implementing ICT in higher education in the country. She has to her credit many research papers, a patent, books, presentations, projects, and invited talks at local, national, and international forums. She is also managing 3 centers working in the field of e-learning at the national level. At Guru Angad Dev Teaching Learning Center of MHRD, Government of India, she has trained more than around 70,000 teachers, for which she was recently felicitated by Union Minister Srimati Smriti Irani. At Center for E-Learning, SGBT Khalsa College, she has developed more than 50 MOOCs in 4-quadrant format for SWAYAM platform. She is the only chemistry teacher of the country to be awarded the National Resource Center of Chemistry of MHRD, Government of India, for developing ARPIT courses 3 times in a row for all chemistry teachers of India since 2018. The quality of the e-content developed by her in ARPIT courses in chemistry has been rated amongst the best in the country by MHRD. She has been contributing in policy making at national level in various committees like Online Courses Regulations 2018 of UGC, E-Governance Committee, Technical Committee of National Academic Depository at UGC, and Expert Evaluation Committee for National Education Alliance in Technology of AICTE. She has been a governing body member of around 10 autonomous colleges of the country. She is also the member of committee to review the EPG Pathshala project in the next phase at UGC. She has guided development of video studios for many institutions, including for AICTE. She is currently in the committee of AICTE for technical book writing for engineering courses in around 10 regional languages for outcome-based education and NEP 2020. She is also the reviewer of the chemistry book for this initiative. Professor Rar has been conferred with various awards like INSA Best Teacher Award 2020, Edupreneur Award for the by the Minister of Education, Bahrain, Delhi Ratna Award, Edupreneur Innovator Award, to name a few. Her designed MOOCs have been published in one of the 3 best MOOCs from India by the Department of Higher Education and Training, Australia government. A very warm welcome to you, ma'am. I now request Dr. Vimal Rar, ma'am, to address the gathering.
Thank you so much, Gauri, for the kind words, and good afternoon, everyone. Very respected Honorable Professor A.K. Bakshi, sir. Very dear Gaurav Gulati, who is the Director, Droid Penal Group. And most importantly, all dear colleagues and researchers who have joined as participants in this FDP come 4 workshops, which will be clubbed up in the theme of legal education. So I welcome each one of you on behalf of Guru Angad Dev Teaching Learning Center. The center is located at my own premier institution, Shri Guru Tegh Bahadur Khalsa College, Constituent College of University of Delhi. So I welcome you on behalf of my governing body of college as well as University of Delhi. In this national level faculty development program, I request you to mute. Gaurav,
I would request the participant to kindly mute themselves, please.
Yeah, please, if you can. So, thank you. So, this 1-week faculty development program, which is themed on legal education, will be actually a combination of 4 workshops, as told by Gaurav Gulati, that one workshop will be on right to information, another will be on intellectual property right, another one on alternate dispute resolution, and the 4th one will be on public policy processes. So this FDP, first of all, you should know that is coming from Guru Angad Dev Teaching Learning Center. It is a center of Ministry of Education. And we are seeking blessings from Guru Angad Dev Ji, the second of the 10 Sikh Gurus, whose name we have taken to have it in this center. And through a very humble effort as a joint team where Professor Bakshi is guiding us. And I'm thankful to Professor Jaswinder Singh, who is also principal of the college and director GID TLC, where we are taking it as a team and trying to do the capacity building of our fellow colleagues and the younger generation of researchers who are also trying to come into the higher education. This center was inaugurated on 1st July 2016 by the then Honorable HRD Minister Smriti Zubin Irani ji. So few words from her.
आज मैं विशेष रूप से बधाई देती हूँ प्रोफेसर बख्शी को, विमल जी को, जिन्होंने बहुत मेहनत करके इस सेंटर को जीवित रूप में आपके सामने प्रस्तुत किया। ये एक टीचर की ललक उसके उत्साह का उदाहरण है कि भारत सरकार ने दिसंबर 2014 को माननीय प्रधानमंत्री जी के हाथों पंडित मदन मोहन मालवीय नेशनल मिशन को राष्ट्र के सामने प्रस्तुत किया। लेकिन उसमें हमने एक शर्त रखी कि जो भी इस प्रोजेक्ट से जुड़े वो स्वयं एक अनोखा टीचिंग लर्निंग का प्रस्ताव लेकर आए, और उस प्रस्ताव में जो अनोखा हो अथवा वो प्रस्ताव अगर शिक्षकों के माध्यम से आए तो विशेष रूप से हमारा सहयोग ऐसे प्रोत्साहित शिक्षकों को जो दूरगामी परिणाम देख सकते हैं, ऐसे शिक्षकों को समर्थन करने का हमारा प्रयास रहेगा. My teachers and my heartiest congratulations on that.
So I'm thankful to all the officials at Ministry of Education for the continuous support that they are providing us in this scheme. And I'm happy to share that since then we have been working into developing our fellow colleagues as a collaborative effort. There are many programs that which we do individually, which are mostly framed on the digital technologies, the blended learning, how the pedagogies, which are more ICT empowered, like flipped classroom and others, our even faculty induction program, which is a unique flagship program we do. But then there are so many requirements from teachers' point of view, which as a team, I think we have to work and expand. And that's where I think the collaborative effort come, which is, and I'm thankful to Gaurav Gulati and Rohit Pinal Group, who have conducted so many programs. And especially if I talk about looking at the legal education component, we have conducted many successful events. And the idea is that we all have to be continuously learning, because there are so many changes happening in higher education as well as in the requirements which where the students have to be skilled into. So we have to be constantly updating ourselves in our subject, in the various pedagogies that we adopt in the online learning or the blended learning or the face-to-face learning, and also on the various tools and techniques. So with these various events, we are trying to work as a team with all our fellow colleagues. So anyone from across the country, if they have that, okay, in our teaching community, we have requirement of this particular theme where we like to conduct FTP, we will welcome you on that. And in our team, we also have other distinguished academicians, Professor Bhanumurthy, Professor Chadda, and I welcome you on behalf of each one of them. We also have another center, which is Center for E-Learning, where we have the technical and the academic expertise on how to conduct, to have the digital open education resources, MOOCs, and these type of, and happy to share that more than 5,000 modules in 4-quadrant approach we have prepared and completed the EPG Pathshala projects in these 6 subjects. And rather for the law students and the scholars here, I will say the forensic science area out of these 6 subjects is something which you can benefit, and all this content is available on inflipnet.ac.in. We also prepared various MOOCs for Swell platform, and this faculty induction program, which in another 1 or 2 months we are planning. This is compulsory for every new inductee in higher education. This is a 1-month program, and this also we have been conducting face-to-face, and now from last 2 years we are conducting it in online mode. And here if you see the package, this is subject neutral, so all subject teachers, they join here. And here the requirement is, I don't know why this is just shifting, let me go back here. So the modules which have been prepared by Ministry of Education, I am thankful that there were many proposals and ideas called by various institutions, and out of these 12 modules, 8 modules have been taken the way we have proposed, and my college name is on this historical document. So we do this faculty induction program with the mission that, yes, how a newly inducted teacher can be prepared holistically. Not only they know about their roles and responsibilities, their duties, they are accountable, but they're also, in addition, doing the best service in the teaching, learning, assessment process, in curriculum design, using the tools, and also contributing to the society in order to prepare open educational resources which will be useful for their fellow colleagues, and also to guide their students into research. And as they go ahead, they can also be very instrumental in the strategic planning and management of their institution, which now, if you see in NEP 2020 entire institutional development plan, how the teachers will be able to have effective contribution in preparing these documents unless or until they have the understanding of the entire higher education. So I'll request all of you to please, because the fourth workshop is specially focusing on the policy development and all. So although you may be looking it from just a legal perspective, but try to see it from a holistic point of view, that how it can be done so that it helps the entire society and our country. And since then, we have been conducting various face-to-face programs, but since April 2020, we have gone more online. Corona was the reason. But if I now look back, it was a good learning for us because we evolved the models, how the flexible mode of faculty development program can be conducted. And based on various survey, now the input is that at least in faculty development program, we want to continue online because the type of flexibility teachers are getting without taking duty leave from their institutions, they can do their learning as well as act as resource persons, those who are comparatively senior or expert in some area. So that's how we have been now taking it further. So we are continuing with the online mode, although our campuses are open. And the same, I think we have to be looking in our teaching processes, that the face-to-face interaction are there, but what all digital tools can be used for empowering us and empowering the entire environment of teaching learning process. I will say the students can access your material, and this my class which you will be exposed to, maybe those who are slightly new may not be aware, but tomorrow when you are given access on that, you will see that whatever sessions live we are conducting, they will be recorded, they will be given. So those who are on flexible mode, they can benefit from that way as well. And I have also conceptualized this teachers e-kit. So as a group, if you see that there are less resources available in some of the subjects, you can prepare this 4 coordinate modules and the entire paper. And this is recognized for API points, which are then required for our promotion requirement. We also have another center, which is National Resource Center of Chemistry. And here the teachers training in online mode. This was the mode in 2018 pre-corona when this was started, and this is again a rigorous program where the teachers can enroll and complete them on their own. But this is a self-paced, unlike this FDP. In FDP, you are having live session and will be having, so I'll request be more active in the live session, although we are giving you flexibility, because in the recorded one, your queries will not be solved. And especially in this FDP, there are workshops. So I'm sure there'll be so many parameters which will be shown that how the hands-on activity have to be done. And there, if you are not taking part and asking question, it will not be so much useful. So just one way will not be helping. And we also have international collaborations from GAD TLC. And very soon we are also planning one FDP, which will be international FDP, which again will be subject neutral, where on the various pedagogies and how the global methods are there, and especially how UK and India open educational resources, there can be joint collaboration. So we'll be evolving all these in these particular collaborations. So we'll be sharing that information also with you. And please, you and as well as your colleagues, please tell them to join in our Telegram group where you can get all the information. And I'll request, please check at least once a week, because you may be more active in WhatsApp, not in Telegram. But there are limitations in WhatsApp. We cannot have more the number of participants. So this is the Telegram link, and we will be also mailing you some of the other events that we'll be conducting. And coming to this very particular, I think this is a very good initiative. I'll congratulate Droid Prenel Group. And also I'm thankful to all the resource persons who will be joining to have these 4 workshops, which all of these 4 are to be participated is compulsory for the FDP. And in FDP, there will be assignment and projects also, which will be there and the details will be sharing. But what I personally feel that if we look as our role as teachers and is teaching, learning as well as research, but we also have to be using the tools which are there, the better tools from other subjects. Like in management, the case studies, and even in law, the case studies are the good practices which even a science student should be using, science teacher should be using. Similarly, I think this workshop, this FDP, where all these 4 are having a different flavor, can be used in our teaching practices. I think it will be a good way where, Gaurav, you are already having journals where the legal practices, how these can be adopted by other teachers in their teaching learning, that can itself be a good paper for that. So how the RTI can be used in our institution processes, or the intellectual property right. And here I think the digital content production, which is a new area which is coming, the copyright, how we have to be very sensitive towards if we are doing use of OER, then also citations and all. So these are very important and new areas coming up. And as law professionals, I think, yes, alternate dispute resolutions and all become very important, because there's so many number of, even as laymen, we come to know that there's so many cases going on for so long hearing. So if they can be resolution outside, and if we can reduce the in-court hearings and disputes, I think that will be a less burden on judiciary system. So all this is, I'm going to, I think it's going to be really exciting as a learner, and I'm myself also interested in many of these. I'll be there as participant, trying to learn many new things, and I'm sure it is going to be beneficial to all of you. And special thanks to Professor A.K. Bakshi sir for accepting to be a part of this inaugural event, and we would like to hear the words of wisdom from sir also as a guidance, and he's a very motivational speaker. So what we believe is, in whatever roles we are doing in the teaching, research, or otherwise for the students, they are still in the learning stage. We are all lifelong learners, but then I think at different stages, we need some motivation to keep going. And that is what I think we will be getting from Professor Bakshi sir. So thank you so much, sir. And I wish this FDP all the very best. Thank you. Thank you, Gaurav and your team. Thank you.
Thank you so much, ma'am. Now, I would like to welcome our chief guest, Professor A.K. Bakshi sir, Honorable Vice Chancellor, PDM University, Haryana. Professor A.K. Bakshi, former Sri Shankar Lal Professor of Chemistry in the University of Delhi, is presently founding Vice Chancellor of PDM University, Bahadurgarh, Haryana. He has been Executive Director of Tertiary Education Commission, Mauritius, a post for which he was selected through a global selection, and Vice Chancellor of UP Rashi Tandon Open University, Allahabad. Professor Bakshi is also presently Chairman of the National Resource Center of Chemistry of MHRD, Guru Angad Dev Teaching Learning Center of MHRD, and Center for E-Learning, located at SGBT Khalsa College of Delhi University. Professor Bakshi has also been a member of the Standing Committee of the National Mission on Education through ICT of the Government of India. He was also the chairman of the Content Advisory Committee for Chemistry for Sakshat Portal of the MHRD, Government of India. He has also been Head Department of Chemistry, Director of CPDHE, and Director of Institute of Lifelong Learning of Delhi University. He has also been a visiting professor at GGSIP University of Delhi. A double gold medalist and recipient of several awards and academic honors, Professor Bakshi was felicitated 2 times for his outstanding contributions to education by the former President of India, Dr. APJ Abdul Kalam. Professor Bakshi is the author or co-author of more than 180 research and education articles, etc., and 1 patent. He has to his credit 11 books as author or co-author, 51 ebooks and books as editor, chairman, convener of the working group, and 63 e-modules as author and co-author for PG chemistry courses and ARPIT programs of the MHRD. Professor Bakshi has also been a member of National Writing Team for Chemistry, Class 11th and 12th books of NCERT. Professor Bakshi was elected as the president of the section of the Chemical Sciences of the Indian Science Congress Association for the year 2011 and 12. He has also been a member of various committees of national and international importance. He is also one of the first persons from universities in India to have been selected as the member scientist of 3rd Indian Research Expedition in Antarctica. A very good afternoon and warm welcome to you, sir. We are honored to have you. I now request Professor A.K. Bakshi, sir, to address our gathering.
Thank you very much, Gauri, for your very kind words of introduction.
Thank you, sir.
It's indeed a great honor and a privilege to be a part of this inaugural ceremony. And I would like to express my gratitude to my colleagues, Professor Vimal Ra, who is heading Guru Angad Dev Teaching Learning Center, as a matter of fact, because she is the project head, and also Mr. Gaurav Gulati, Director, Deroit Penale Group, for inviting me to be the part of this event. You know, I'm very happy that this 1-week faculty development program come national workshops is being organized by Guru Angad Dev Teaching Learning Center of the Ministry of Education, Government of India, in collaboration with Deroit Penale Group. You know, Guru Angad Dev Teaching Learning Center has been created by the Government of India under Pandit Madan Mohan Malviya National Mission on Teachers and Teaching. The basic purpose of this scheme is to empower teachers and their teaching abilities. Because, you know, if you want to enhance the quality of an educational system, you must raise the competence level of the teachers. Because, you know, the quality of an educational system cannot exceed the quality of its teachers. So we must raise the competence level of the teachers. So this faculty development program has to be viewed from that perspective. It helps you in your career development. Because, you know, whosoever you may be, you are in the field of higher education, you are a teacher, or you are a researcher, or, you know, a very, you know, hopeful for the future, you want to come to higher education. Ultimately, one wants to reach to the top. And for this, one needs to manage one's career. So career management is very, very important. And you know, career management involves 2 things. One is career growth, and second is career development. These 2 are totally different things. So this faculty development program is a part of the career development part, because it will enhance your knowledge, it will enhance your skills, and all this will help you later on in your career growth. Career growth basically means you go from one position to higher. You are assistant professor, you become associate, you become professor. All that comes under career growth. But career development is it raises your competence level at a given position so that you become more and more, knowledgeable, skilled, etc. So, Guru Angad Dev Teaching Learning Center, keeping all these things in mind, has been conducting various teacher empowerment programs. We have conducted hundreds of such programs for the teachers of the country. And as you have been told, more than 75,000 teachers of the country have been trained on different aspects of higher education. And all of them are basically helping the teachers in their development. So this program basically consisting of 4 national level workshops has to be viewed from that point of view. See, if you look at these workshops or the topics of their workshops, they are of interest to anybody, not only to the legal or the persons coming from the law. They could be of interest to anybody coming from any discipline. The right to information is, very much needed by everybody in the country. There must be many, many questions relating to, Right to Information Act. As Gaurav mentioned, this Right to Information Act came in 2005. Before that, we had even the Freedom of Expression Act, that was in 2002. But you can see that how this has brought about transparency and accountability in the various government actions. You can elicit information, but then there must be many questions in your mind. Who can seek information under Right to Information Act? That could be a question in your mind. As you know, we need almost, I think, about 30 days are required to get that information. Then how the scope of RTI can be, extended, and what are the challenges in all this? And whether the information which you get under RTI, can it be used as an evidence in any court? These are some of the questions, and many other questions which must be in your mind. And I'm sure through these workshops, all those questions will be answered. Otherwise, you can get a lot of information just on the web also. Please remember, education is not the learning of the facts, it is the training of the mind to think. So you should be able to think more and more about this act, how it can be improved, how it can be strengthened, whether non-resident Indians can also seek information, etc., under this act, etc., and many other questions. So, from that point of view, I'm sure this is going to be very, very valuable. And the same is for the other workshops. For example, even intellectual property rights. These basically are the legal rights to anyone who creates something new. It is the creation of the mind. That is your intellectual property. And, there are certain legal rights to that creator for a limited period of time, so that, he knows how to use it, etc. This could be under, as Gaurav was pointing out, under inventions or patents or even trademarks, copyrights, etc. So these are very important. But then there are many challenges in this also. So all those will be answered in that workshop. And then we also have, alternate dispute resolution, where, so many courses, so many cases are there in the courts, languishing for years and years. That is why this came alternative dispute resolution, that what could be the other way. It could be through mediation, arbitration, or even neutral evaluation. All those things will be discussed about. And lastly, the fourth one is also very important. And that's basically, about what we call as public policy and government, how the policies are formulated, how the agenda is set, then how they are formulated, then how they are implemented, and then finally how they are evaluated. These are the various stages in any public policy. So I'm sure all these details will be discussed, and these are not only of interest to the persons coming with law background, these are of interest to everybody. So I think it's a very laudable initiative taken by Guru Angad Dev Teaching Learning Center along with Gaurav Gulati, that they are coming out with these workshops. At this stage, I would like to say something more. We are all in the field of education, and each one of us wants to grow in our field and reach to the top. And education scenario is changing very, very fast. World is changing very, very fast. Technologies are coming in a very, very big way. In the light of all that, challenges of education are becoming very, very prominent. Please remember, education is relevant only when it is able to serve the needs of the changing society. And the society is changing. Other day, I was reading a report that our students who are in schools or colleges, by the time they finish their education, in which jobs they will be placed, we do not know, because those jobs may not be existing at present. So this is going to be a big challenge. Then many disruptive technologies like artificial intelligence, machine learning, Internet of Things, they are coming. And just you can very well imagine, if tomorrow we have machines with the same intelligence as you, then why do we need you? That is going to be another challenge. And then all governments all over the world are trying to increase the gross enrollment ratio. More and more students are graduating. Traditional jobs are becoming less and less, but takers are becoming many. So there is going to be a tough competition in future. So you can very well imagine that in the light of all these challenges, the biggest challenge before a teacher is going to be how to teach students so that they can succeed and thrive in the future. So this is a very big challenge in higher education. You may be from any discipline, but the challenge remains the same. So, question is, what will constitute quality education in the 21st century? There is a lot of debate. What we have been having as an education, that is not going to exist in future. Quality education in any subject will ultimately consist of three things, in my opinion. This is what I am sharing with you based on my such a long experience. If you want to excel in your field, you need to focus on three things. I'm talking especially in the context of higher education. One is knowledge. Your knowledge in the subject should be profound, very deep understanding. You should have an in-depth understanding of the topics. So much so that whenever you teach, your teaching should reflect the amount of thinking you have done on the subject. And this knowledge should be disciplinary knowledge, interdisciplinary knowledge, and practical knowledge. And for legal people, these all are very, very important. You should have this. This is one aspect. Second aspect in the 21st century is going to be 21st century skills. These skills are going to be very, very important in future. And it won't be wrong if I say that these skills are going to be the deciding factor for placement in the years to come. So question comes, what are these 21st century skills? These are a set of abilities which we all must possess in order to succeed and thrive in the 21st century. These are learning skills. Learning skills include creativity, critical thinking, collaboration, communication. So these learning skills everybody should have. Then we have literacy skills, information literacy, media literacy, technology literacy. And then finally, we have life skills, leadership quality, flexibility, initiative, productivity, social skills. So, you may ask the question that why suddenly these skills have become so important. These skills have become so important in the modern world because you cannot have machines with these skills. You can't have a machine which is critically thinking. You can't have a machine which is creative, or you can't have a machine which has the leadership quality. So what I mean to say is that all of you, whether you are a student or a teacher or at any level in higher education, you must strive to achieve that. Work hard for that. Some of the leading companies of the world now, they hire people without degrees, provided they have these skills. So world is changing. And the third aspect, the last thing which I want to say is, first I said knowledge, then I said 21st century skills, and the third thing is personality. Your thinking style, your behavior, how you respond to a particular situation. That taken together, knowledge, skills, and personality, these three things taken together constitute competence of an individual. And that is what is going to be the most important. You have to become a competent. After all, what is the goal of education? The ultimate goal of education is to produce a good human being, a responsible citizen, and a competent professional. So competent professional you will be only if you have these three things which I mentioned. So these workshops or these faculty development programs help you in boosting your competence. So these should be viewed from that perspective. You should not just gather information, you should do a lot of thinking on that. Because, it is a very serious drawback in our education system. We focus on well-filled mind. We keep on filling with the knowledge. No, that's not the purpose of education. The purpose of education is not well-filled mind, but well-formed mind, who has done a lot of thinking, lot of, critical thinking, critical approach. Then you will become a well-formed mind. And once you are a well-formed mind, you will become highly creative. And that is what India requires. That is what everybody needs. You come out with new ideas. Otherwise, if you are just accepting what is said, that's not the goal of education. You should be able to contribute something new. So that's why, it is said now that India's future is in innovation and creativity. Creativity is you come out with new ideas, and innovation is you put it into some good product or activity or some practical application. So that is where we need. And even in legal aspect also, you need all these things. So that's what I personally feel I wanted to say in my this address at the inaugural ceremony, that these are the challenges of higher education. And please remember, education scenario was never as dynamic as it is at present. Every day things are changing. Every day things are changing. World is witnessing industrial revolution 4. Even some parts of the world are witnessing industrial revolution 5. Even the concept of success is changing. Now, successful people will not go into traditional jobs. They will create their own jobs. They will work as per their mood, their own working hours. They will work with people all over the world. So the entire scenario is changing. So I think that's basically the thing, our message which I wanted to give you. So once again, I thank Gaurav for inviting me to be the part of this inaugural event, and thanks to Professor Vimal also, who is the guest of honor today. And I'm sure that GID TLC has been doing a great job in the professional development of the teachers. Because professional development of the teachers is a journey and not a destination. You should become more and more developed, and there is no end to that. Anyway, thank you very much and all the best to you. Thank you.
Thank you so much, sir. Thank you.
Thank you so much, sir, for enlightening us with your knowledge. Now, moving towards the successful end of our inaugural, I would request the director of Toit Pinal Group, Mr. Gaurav Gulati, to please take over and to end the session with a formal vote of thanks.
It is always a pleasure being a part of this event with GAD TLC, and it's an honor to host Professor Bakshi sir, Vimal Rar ma'am, and all the participants who joined across the nation. So it's not the end of the session, it is the beginning of the session. So we'll be starting with the knowledgeable sessions from today itself. So thank you everyone for joining for the inaugural session. Now moving towards the technical session, we will be starting our technical session within 5 to 10 minutes, within 5 to 10 minutes. So I would request all the participants to stay connected so that the Venkatesh Nayak sir will be joining with us, who will be taking up the first workshop, which is on right to information. Thank you, everyone.
Thank you so much, sir. And once again, I would like to thank Vimal Ram ma'am and Professor A.K. Bakshi sir, Gaurav Gulati sir, for gracing today's inaugural session. Thank you so much, everyone. And I would like to inform all the participants to stay connected. Our first speaker will be joining us soon, and we will start with our first technical session in just 5 minutes. Kindly stay connected, all of you.
Hello, Gaurav. Are you there? Are you able to hear me?
Good evening, sir.
Good evening. Good evening.
I'm Gauri Gulati, and I'm the moderator of the event today.
Okay. Okay. Hi. Hi.
Yes, sir. So
Okay.
we'll just start the session in 2 or 3 minutes.
Okay.
Still some
No problem.
participants are joining.
Sure.
So we'll start in 2 or 3 minutes.
Yes. Yes.
Good evening, sir.
Hello. Hi. Hi. Good evening. Sorry, my mic was muted. I couldn't respond. So, so do let me know when we can start and we can.
Yes, sir. So Gauri ma'am will be doing the moderation today. So she will be helping you out if
Sure. Sure.
there is.
Thank you. Thank you.
Good evening, everyone. Good evening, sir. We have a resource person, Mr. Venkatesh Nayak, Director, Commonwealth Health Rights Initiative. Welcome, sir. I would request, sir, to proceed with our first technical session of the national level workshop come 1 week faculty development program. Today's topic of the workshop will be right to information. Over to you, sir.
Okay, thank you. Could you just give me some understanding of the profile of our participants at this webinar today?
Yes, sir. Sure, sir.
Just a rough idea as to what their background is.
Sir, all these participants, they are faculties, and
Okay.
some of them are students of various universities and colleges
Okay.
all around India.
Okay. Okay. I mean, that's good to know.
Mm.
Okay. So, very good afternoon to all of you, and ladies and gentlemen. Thank you so much for making time to participate in this workshop, which is being conducted virtually. Because of the pandemic, I think it's difficult increasingly to conduct in-person face-to-face workshops, but this is certainly a very cost-effective and definitely an environment-friendly method of engaging. Now, you have all been informed by Gauri ji that today's workshop is on the right to information, but specifically, I have been asked to share my thoughts with you on two topics. The first is the practical problems that people face in accessing information from public authorities. And the second part of this session, I will talk to you about implementation of RTI Act, dilemma, and roadmap for the future. So rather than make this into a very boring monologue, please pardon me, I have a bit of a cold today because of the changing weather. So I will make a brief presentation for about 20-25 minutes on the two thematics that I explained to you just now. And then we can open up the floor for discussion in relation to those topics. But you are more than welcome to ask questions specifically about the RTI Act's provisions or the rules under it that the governments have made under it, or any case law that has come up in this context. So I'm happy to respond to those as well. It's literally, we can keep it flexible. Let it be an open floor. Now, before I start, what I want to ask you is this, कि क्या आप चाहेंगे कि मैं अंग्रेजी में ही पूरा सत्र को संबोधित करूं पूरे सत्र के दौरान, या फिर आप हिंदी में मुझे बात करने के लिए रिक्वेस्ट करेंगे, या फिर दोनों भाषाओं को मिला के थोड़ा इंग्लिश थोड़ा हिंदी में प्रेजेंटेशन अपना रखूं? आप बताइएगा, व्हाट वुड यू प्रेफर? आई थिंक आई कैन डू बोथ.
सर
हिंदी प्रेफर करेंगे. ओके. कोई है यहाँ पर जो हिंदी जानते ही नहीं है?
Sir, it would be easier for us if you could explain the things in English and Hindi both.
ठीक है. So
because pure Hindi, it won't be difficult for us to understand.
Okay, okay. So we'll do a mix. दोनों भाषाओं में अपनी बातों को रखने के लिए मैं कोशिश करूंगा. Okay. So पहला वाला जो विषय है, टॉपिक है, practical problems faced by people in accessing information from public authorities. इसको लेते हैं. I trust that now that the RTI Act has completed 17 years of existence, many of you would be familiar at least with the basics of the right to information. You may also have heard about the struggle to reach this far. RTI कानून हमारे देश में किस संदर्भ में पारित हुआ, दबाव कहां से आया, किन वजहों से ये कानून लाना पड़ा, इसके बारे में तो आप भली बात ही जानते हैं. Everybody knows that we are perhaps the first country in the world, one amongst a very small number of countries, where RTI law was brought in because of pressure from the ground level. लोगों के द्वारा गांव के स्तर पे सरकारी कामकाज के बारे में जानकारी लेने के लिए लोग इच्छुक थे, विकास काम के बारे में, सरकारी निधि कैसे खर्च हो रही है. When the government says that we are spending hundreds of crores of rupees on people in developmental programs, people want to know how exactly is it being spent. What are the achievements that the government has claimed by spending the money? Because in several of those places where this demand for transparency arose, there was very little to actually see at the ground level. जमीनी स्तर की सच्चाई इस बात का पुष्टिकरण नहीं करता था कि करोड़ों रुपए यहां पर विकास योजनाओं पे खर्च हुए. So RTA comes in that context. People asked, tell us, how have you spent the money that we have paid as taxes? You say in every budget session that I will spend this much money, or our government will spend this much money on this yojana, on that yojana, on this kind of empowerment, that kind of empowerment, this scholarship, that pension, this housing scheme, that health scheme, road construction, school construction, paying of teachers. But despite all of that, there was a lot of allegation about corruption in public spending. When government was saying that I will allocate 500 crores for providing relief to people living in a drought-prone area of Rajasthan or in a semi-arid geography like Maharashtra, several parts of Maharashtra, people wanted to know how exactly was that money being spent. क्योंकि जमीनी स्तर पे तो खास कुछ दिखने के लिए नहीं मिल रहा था. जहां बोला गया था कि सड़क बन रही है या बना दी गई है, कच्चा रास्ता है या फिर टूटी फूटी सड़क है, या फिर सड़क बन भी गया तो एक साल के अंदर बारिश के बाद सड़क की हालत खराब. So people demand a law that would entitle them access to information from government. So what does it mean? It basically means that people were demanding that there should be a law that will actually explain the procedures for us to ask information from government and its various agencies. And that law must also specify in what manner will government agencies give us the information that we ask, within what timelines, in what format. Will the government be required to give information only when people formally write to them with a request? Or is the government required to give a whole lot of information without waiting for people to ask for it? यानी स्वयं प्रकाशित करने वाली जानकारी की कुछ बाध्यता भी है सरकार के ऊपर. इन सारे बातों को लेकर बहुत चर्चा हुई देश भर में, अलग अलग हिस्सों में, और एक आवाज उठकर आई कि हमारा जो जानकारी प्राप्त करने का अधिकार है सरकार से, जो हमारे मौलिक आजादी का एक हिस्सा है, अपनी विचारों को अभिव्यक्त करने की और अपने बातों को रखने की, फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन जो आर्टिकल 19(1)(a) ऑफ द कॉन्स्टिट्यूशन में निहित है, तो उसका एक अटूट हिस्सा है राइट टू इंफॉर्मेशन. सुप्रीम कोर्ट ने 1975 में कह दिया था. फिर 1988 में और फिर 2004 में यह भी बोला कि राइट टू नो इज पार्ट ऑफ राइट टू लाइफ. तो लोगों ने यही कहा कि हमारी जिंदगी से जुड़े हुए बहुत सारे सरकारी कामकाज के जानकारी हमें नहीं मिलती. A lot of spending that the government does, a lot of decisions government takes affects our lives directly, from children up to elderly people. So we need a law that will give us the right to information. कानून आ भी गया in 2005. I will not go into the history, you are all aware. 4 महीने की तैयारी के लिए समय मिला. October 12, 2005 onwards, people started filing information requests, what are called RTI applications. Now, problems crop up from the very beginning. And many of these problems have still not been resolved. मैं एक एक करके कुछ प्रॉब्लम्स जो लोग फेस करते हैं उनको आपके सामने गिनवाता हूं. सबसे पहले लोगों, आम नागरिक जो है, ordinary citizens like you and I shouldn't say you, I should say like myself. I'm not a lawyer. 99.9% of the people of India are also not lawyers. The number of lawyers in the country is a very small subset of the population. So the art of drafting an RTI application, seeking information in a specific manner, is something that perhaps lawyers know very well, but ordinary citizens have difficulties. How do you ask for information? I will give you a comparative picture. Now, Gaurav called me up 3 days ago and said, "So we are organizing this workshop. Will you be able to spare time? Can you please handle at least 2 sessions? You can do a session on the 9th of Jan, and you can do another session on the 10th of Jan. And we agreed that I will do both the sessions today itself. Now here, Gaurav had absolute clarity about what he wanted, because he knew that there is a workshop to deliver. He knew that there is a resource person called Venkatesh Nayak. He also knew that perhaps Venkatesh is an appropriate person to invite, क्योंकि जॉब पिनाल के पहले के जो इस तरह के वर्कशॉप्स हुए हैं उसमें स्रोत व्यक्ति के रूप में वेंकटेश आए हुए हैं, एंड लोगों का फीडबैक तकरीबन अच्छा रहा है, इसीलिए नो हार्म इन कॉलिंग हिम बैक. और ये जो टॉपिक्स जो चुने गए हैं उस पर बोलने के लिए उनकी काबिलियत भी है. सो ही स्ट्रेट अवे आस्क्ड एंड द मैटर वाज फाइनलाइज्ड एंड आई एम इन फ्रंट ऑफ यू नाउ. But when people have to ask information from government, very often the challenge is with drafting the RTI application properly so that government understands, the officer there understands what is the information that this person is asking. All the information that people want are in government files. Very rarely do people actually get to see those government files, even if the matter contained in those files relate to their own personal interests. चाहे उनके स्कॉलरशिप के लिए एप्लीकेशन के बारे में हो, या पेंशन के लिए एप्लीकेशन के बारे में हो, या फिर इनकम टैक्स रिटर्न्स में जो प्रॉब्लम हुआ है कि हमने कुछ भरा, टैक्स इतना जमा किया, लेकिन सरकार कह रही है कि नहीं आपको और ज्यादा देना था, और उसका 143(1) में ऑर्डर आ गया. लेकिन उन्होंने कैलकुलेट कैसे किया, ये फाइल तो इनकम टैक्स एसएससी ने देखा ही नहीं. किसी का राशन कार्ड, बीपीएल राशन कार्ड खत्म कर दिया गया, उनको बस ऑर्डर आई उनके पास ये कहते हुए कि आपके बीपीएल का राशन कार्ड हमने निरस्त कर दिया. नो आइडिया व्हाई, नो आइडिया हु टुक द डिसीजन, नो आइडिया व्हाट इज द प्रोसेस थ्रू व्हिच पीपल हैव टू बी इन्फॉर्म्ड अबाउट द फैक्ट दैट देयर राशन कार्ड हैज बीन कैंसिल्ड. No idea about who moves that file to initiate the process of cancelling the ration card, and who is the final signing authority who has the power to cancel the ration card based on inputs received. खबर ही नहीं, किसी ने कोशिश ही नहीं किया लोगों को समझाने के लिए इन प्रक्रियाओं के बारे में. तो लोग यदि जानकारी मांगने के लिए पेन और पेपर हाथ में लेंगे भी तो मांगेंगे कैसे, सवाल के रूप में करेंगे. So this is where the first problem arises, that people have a problem which they want addressed. The several examples that I gave about scholarships, about pensions, about income tax returns, this subsidy, that subsidy. There is a poor delivery of service or a complete non-delivery of service, and people want to know why. So their questions will be in the nature of why, when, who, why not, how, etc. And this is where the first part of the problem arises. When RTI applications contain these kinds of queries, which end up with a question mark, invariably, public information officers reject the application. 9.9 out of 10 cases, RTI application is rejected, saying, we do not have a duty to respond to your queries. We only have a duty to give you copies of our official records that we hold on file. Now, how does an applicant even figure out कि कौन से फाइल में किस तरह के कागजात हैं, मेरे समस्याओं के बारे में जानकारी जो रखते हैं, वो फाइल किसके पास है, कितना मोटा फाइल है, उसमें कितने पेजेस हैं? इन सारे बातों से आरटीआई एप्लीकेंट बेखबर होते हैं। फिर भी उनसे उम्मीद की जाती है कि सवाल के रूप में जानकारी ना मांगे, रिकॉर्ड की कॉपी मांगे, जबकि इनको फाइल का नंबर तक पता नहीं। So a lot of cases, the single biggest problem that happens is that people ask questions in the form of, they file RTIs in the form of questions and they get rejected. Second part of the problem. We are a country of about 137 to 138 crore people. Government has simply not made the effort to teach everybody the basic procedures that must be observed while using the RTI Act for seeking information. So many ordinary citizens don't know that they have to address their RTI application to a public information officer who is designated under the law. All that they know is that, look, the information that I want is in the SDO's office, or that information is in the district collector's office, or it is available in the agricultural department, or it might be available in the education department, because my RTI application is about education school scholarship that my daughter was supposed to get, but it has not come through despite putting in an application. So they will address it to the head of the department or to any officer whom they know who is functioning in that department. And the RTI application gets rejected, saying you have not addressed it to the correct public information officer. Now, this second problem has a corollary dimension also. इसका एक और हिस्सा है, वो क्या है? कई बार नागरिकों को ये पता नहीं होता है कि हम आरटीआई एप्लीकेशन किसके नाम से भेजें, यानी वो सरकारी अफसर कौन है जिनको पब्लिक इंफॉर्मेशन ऑफिसर के रूप में नामित किया गया है, the one who has been designated. So they keep struggling in whose name should we send, in whose name should we send. I get a lot of those kinds of questions. Sir, इसको किसके प्रति, किसके नाम से लिखना है? So I keep telling them that you don't have to find out the name of the public information officer. That is not required in the law at all. All that you need to do is simply address your RTI application to the public information officer. सेवा में लोक सूचना अधिकारी, और उस विभाग का नाम या दफ्तर का नाम और दफ्तर का पता उतना लिखना है और भेजना है. बहुत सारे लोगों को ये पता नहीं है, जिसकी वजह से आरटीआई डालने के लिए चाहते हुए भी आरटीआई डाल नहीं पाते हैं. Now, to a certain extent, government has created some conveniences in some states and at the central level to deal with this kind of a problem. So they have what is called RTI online filing portal. So now when I explain this, I am getting into the second topic also, which is implementation of RTI Act and what are the dilemmas and what is the roadmap for the future. And this is the roadmap for the future. Minimum requirement is that you have an RTI online portal जहां पर पब्लिक अथॉरिटीज सारे लिस्टेड रहेंगे और बिना पता किए हुए कि कौन पब्लिक इंफॉर्मेशन ऑफिसर किस विभाग में नामित है, you just select the department from which you want the information and you fill up your RTI queries and you pay the fees online of 10 rupees or whatever is the amount that is fixed by the particular state government, and that and click submit. It gets submitted. Then the RTI application is out of your computer. It is now in the domain of the public authority. They have to now make sure that the RTI application goes to the right kind of person, right kind of public information officer. One solution. Another solution that central government thought of, which is a very, very user-friendly solution and which helps people who are on the wrong side of the digital divide. यानी जो लोग इंटरनेट लिटरेट नहीं है उनके लिए बहुत फायदेमंद होता है. वो क्या है? हमारे देश के हर जिले में जो जिला स्तर का जो पोस्ट ऑफिस है, वहां पर एक सहायक लोक सूचना अधिकारी नियुक्त है केंद्र सरकार के लिए. सारे पब्लिक अथॉरिटीज जो उनके दायरे में आते हैं, उन सब के लिए वो एक असिस्टेंट पीआईओ है. और यदि आपको सेंट्रल गवर्नमेंट के किसी भी दफ्तर से जानकारी अगर चाहिए तो उस जिले के पोस्ट ऑफिस में आप जाएंगे, पता करेंगे कि कौन असिस्टेंट पीआईओ है वहां पर जो नामित है, और उनको अपना आरटीआई एप्लीकेशन हैंडओवर करेंगे। 10 रुपए का फीस जमा करेंगे, क्योंकि सेंट्रल गवर्नमेंट में आरटीआई एप्लीकेशन फी 10 रुपए का होता है। जिम्मेदारी उस असिस्टेंट पीआईओ की बनती है कि उसको लिफाफे में डाले और संबंधित आरटीआई पब्लिक अथॉरिटी को 5 दिनों के अंदर रवाना कर दे। very convenient system, but unfortunately it is applicable only to central government. 15 साल पहले जब ये सिस्टम चालू हुआ, 15-16 साल पहले, I am happy to say कि I was part of the discussion group within government. I was not in government, but I was a civil society participant, जहां पर मैंने ये बात रखी कि देखिए सबसे बड़ा सुविधा अगर आपको क्रिएट करना है लोगों को आरटीआई एप्लीकेशन डलवाने के संदर्भ में, तो make sure that post offices become the receiving point for the RTA applications. Central government के लिए तो कर दिया. We said please extend this to the state government also. But that has not happened so far. So there is a problem with regard to even finding out where do I send the RTA application. Next thing. एप्लीकेशन तो हमने तैयार कर दी, फीस जमा करना है 10 रुपए का, किसके नाम से जमा करवाएं? इफ यू गो एंड पे इन कैश, इट इज इजी, यू विल गेट अ रिसीट, यू अटैच अ कॉपी ऑफ द रिसीट एंड यू सेंड योर गिव योर आरटीआई एप्लीकेशन, जमा हो जाता है. बट वेरी ऑफन पीपल लिव इन प्लेसेस फार अवे फ्रॉम द पब्लिक अथॉरिटी फ्रॉम विच दे वांट द इंफॉर्मेशन. तो बाय पोस्ट आप कैश तो नहीं भेज सकते, एप्लीकेशन तो चला जाता है. सो हाउ डू यू सेंड द एप्लीकेशन फी? सेंट्रल गवर्नमेंट रूल्स आर वेरी क्लियर. आप किसी भी सरकारी दफ्तर सेंट्रल गवर्नमेंट का जानकारी वहां से मांगने के लिए आप इच्छुक हैं, तो आप या तो बैंक ड्राफ्ट, या उसी शहर में दफ्तर है तो बैंकर्स चेक, या फिर पोस्टल डिपार्टमेंट से इंडियन पोस्टल ऑर्डर लेकर टू द अकाउंट्स ऑफिसर करके उसको भेज सकते हैं. अब बहुत सारी स्टेट्स ने ये सिस्टम तो बना दिया कि आप बैंक ड्राफ्ट के माध्यम से पे कर सकते हैं, आईपीओ के माध्यम से पे कर सकते हैं, लेकिन रूल्स में ये लिखा नहीं कि बैंक ड्राफ्ट किसके नाम से बनेगा, आईपीओ किसके नाम से भेजा जाएगा. यूपी से अकाउंट्स ऑफिसर, उत्तराखंड से अकाउंट्स ऑफिसर, सेंट्रल गवर्नमेंट से अकाउंट्स ऑफिसर, महाराष्ट्र से अकाउंट्स ऑफिसर, उड़ीसा में, वेस्ट बंगाल में, कर्नाटका में, मध्य प्रदेश में. नो क्लैरिटी. Why? Because within government there is no clarity about how to collect the RTA application fee. It cannot be deposited in the name of the public information officer in most places, क्योंकि पब्लिक इंफॉर्मेशन ऑफिसर के नाम से अकाउंट खुला ही नहीं है. कई सारे दफ्तरों में लोगों से पैसा वसूलने के लिए बैंक अकाउंट खुला हुआ है in the name of the accounts officer. Pretty easy. In the same government, in several other public departments, it will be pay and accounts officer. In another 15 to 20 departments in the same government, the recipient person's bank account name will be drawing and disbursing officer. So in whose name to give, there is no clarity. तो बार बार आपको उसी दफ्तर में फोन करके पता करना पड़ता है पहले कि किसके नाम से हम एप्लीकेशन फीस का इंस्ट्रूमेंट बना के भेजें. सो अगेन देयर इज अ होल लॉट ऑफ डिफिकल्टी इन फाइंडिंग आउट इन हुज नेम should the fee paying instrument be drawn. Same problem with the additional fee payment also. People don't know if they have to send the additional fees in methods other than cash, then in whose name should the instrument be drawn? There are problems. Now let's talk about cash. Cash जमा करना इतना आसान नहीं है. We think that cash is a very easy form of paying fees. No, sorry. You have to fill up a challan in triplicate. और वो चालान आप कई बार जमा दफ्तर के कैशियर के पास नहीं करेंगे, because there is no cashier there at all. You will have to go to the designated bank in which the department has its bank account open. वहां क्यों में लगो. Now, in some states, they say, okay, you can also make fee payment through treasury challan. Invariably, in every state, if you make payments through treasury challan, you cannot pay that in the office where the public information officer is sitting. Why? Because there is nobody who will accept the treasury challan there. You still have to go to the designated bank jahan par treasury account khula hua hai. So your office is in one location, the bank branch where you're supposed to pay through treasury challan is another location. तो यहां से पहले पता करो कि बैंक अकाउंट कहां पे है, उस ब्रांच में जाओ, वहां क्यू में खड़े हो जाओ, जमा करवाओ और दौड़े दौड़े वापस आओ और यहाँ पे जमा करवाओ. Now, until a few years ago, Delhi police had a funny system, because some of my colleagues filed RTI applications on my behalf and I know how that system worked. I don't know if it has changed now, but at least about 5-6 years ago, this was the system. You know, earlier, Delhi police used to be located in Delhi in a separate building, which is called near the income tax offices. MSO building करके बोलते हैं, multi-story, you know, offices के building में. So पहले आपको अपना application ले जाकर पब्लिक इंफॉर्मेशन ऑफिसर का जो स्टेनो या क्लर्क जो बैठता है, क्योंकि पब्लिक इंफॉर्मेशन ऑफिसर इज सीनियर रैंक पर्सन, ही विल नेवर मीट यू, ही हैज गॉट सो मेनी अदर टास्क्स, सो यू विल हैव टू गो टू द क्लर्क और स्टेनो एंड गेट इट इनिशियल्ड. वो एक फ्लोर पे होता है काम. देन यू हैव टू गो ऑल द वे अप टू द 8th फ्लोर जहां पे पैसा जमा होता है. तो वहां जाके क्यू में खड़े हो जाओ, पैसे जमा करवाओ, फिर नीचे आओ एंड उसको दिखाओ टू दैट स्टेनो और समबडी and get them to initial हाँ ये पैसा वसूला गया है, and then go and give it to another desk which is located at another floor, which is the receipt window. This is the complication that people are made to go through while simply filing RTI applications. Just submission जमा करवाने में ये समस्या है. चलो जमा हो गया. कानून कहता है कि यदि जानकारी जो आप मांग रहे हैं वो टोटली या पार्शियली जिस दफ्तर में आपने सबमिट कर दिया उनके पास अवेलेबल नहीं है, तो उनकी जिम्मेदारी है उसको ट्रांसफर करना 5 दिनों में दूसरे दफ्तर में. बट ये कई बार होता नहीं, स्पेशली इन द स्टेट्स, डिस्ट्रिक्ट्स एंड विलेज लेवल होता ही नहीं. करते क्या है, वो बोलते हैं कि जी आपने ये जो हमारे लिए एप्लीकेशन भेजा है ये हमारे पास अवेलेबल नहीं है, आप फला वो दूसरे दफ्तर में एप्लीकेशन भेजिएगा. यानी 10 रुपए यहाँ पे बर्बाद, फिर और 10 रुपए खर्च करना पड़ेगा दूसरी जगह एप्लीकेशन देने के लिए. ट्रांसफर ही नहीं होता. कई जगह होता है लेकिन कई जगह होता भी नहीं. या फिर बोल देते हैं ट्रांसफर के ऑब्लिगेशन से बचने के लिए कि वी डोंट नो वेयर दैट इंफॉर्मेशन दैट यू वांट इज अवेलेबल, सो वी कांट हेल्प यू, सो प्लीज go and find out yourself. How will people find out themselves? It is possible. How? If every public authority were to implement section 4(1)(b) of the RTI Act. What does 4(1)(b) say? 4(1)(b) says give 17 points of information about your functioning to people voluntarily. Don't wait for them to ask for it. How is your organization structured? How many officers are there? What are the roles and responsibilities of your officers? What are their names? What are their powers and functions? What kinds of rules, regulations, and manuals do they use in their work? What kinds of files do they hold in their custody? Electronic and paper-based files. What kind of budget do they receive? How do they spend it? What kind of subsidy programs do they implement? Who are the beneficiaries? What is the methodology for obtaining the benefit of the subsidiary schemes? What kinds of authorizations and permits do those people give? What kinds of consultative mechanisms do they have for interacting with people while making important decisions in the course of their work? All of this information has to be made public once a year, updating it once a year. करते नहीं, लोगों को पता ही नहीं कि हमको जो जानकारी चाहिए वो कौन से विभाग में अवेलेबल है. I'll give you an example. Now, in a tehsil level or a mandal level, depending upon which state you are, that is a sub-district level. Let us say that the local administration is sinking bore wells. Now you want to know in that particular tehsil or taluk or mandal, how many borewells have been sunk, how much money has been spent, how many are functional, how many are not functional. Now, a lot of this information is actually available publicly on central government websites, where the functionality of the borewell is also indicated in real time. But people don't know where it is. I also found out only after 10 years of implementation of RTI that yes, there is a database where I can access this information. So for people who don't know, they will file an RTI application and they will go and give it to the Prant office or circle office, as they call it, at the taluka level. Now the problem is, some borewells, the funding for spending on those borewells, sinking those borewells and maintenance will come from the irrigation department. Some other borewells will be sunk by the Panchayati Raj department. Some other borewells will be sunk by the youth and sports department, youth welfare and sports department. Some other borewells will be sunk by the department that looks after SC/ST welfare, because it's not a problem. Government is designed in such a manner that funding is given to these various departments under various schemes for doing that one thing, sinking borewells in that village. And if this one person wants to know through RTI in one financial year how much money was spent on sinking borewells and their maintenance in which part of my mandal where I'm living or the taluka where I'm living, that information is not available in one place. जो यूथ वेलफेयर और स्पोर्ट्स डिपार्टमेंट ने सिंक किया है बोरवेल्स, वो जानकारी बोलेंगे उनसे जाके मांगो. जो विमेन एंड चाइल्ड डेवलपमेंट डिपार्टमेंट ने बोरवेल्स सिंक किए हैं, बोलेंगे उनसे जाके मांगो. इरिगेशन डिपार्टमेंट ने जो किया, बोलेंगे उनसे जाके मांगो. फिर नरेगा के तहत जो किसी के जमीन पे, किसी के खेत में अगर बोरवेल का काम किया हुआ है या सिंचाई विभाग का कोई काम किया हुआ है, तो बोलेंगे उनसे जाके मांगो. So people very often don't know where to ask the information from. It is not readily available. Nobody is there to guide. So that is also the reason why the RTI application either comes back to them undelivered. जैसे हमारे पास ये जानकारी है नहीं, आप कहीं भी जाके और मांग सकते हैं. या फिर another favorite game, ट्रांसफर बार करते रहे. पहले डिपार्टमेंट ए से डिपार्टमेंट बी में गया, फिर डिपार्टमेंट सी में गया, फिर डिपार्टमेंट डी में गया, फिर हो सकता है कई बार वो डिपार्टमेंट ए के पास वापस चला है. Many such examples have happened where people get frustrated just trying to find out the information that I want, कौन से विभाग के पास ये रखा हुआ है. And let me tell you, ये मेरी मनगढ़ंत कहानी नहीं है. This is not fiction. I have faced this very problem multiple times in the central government, where one department says, I don't have the information. This RTI application is being transferred to department B. Department B says, sorry, I don't have this information. We'll transfer it to department C. And department C will send it back to department A, saying, no, you have this information. We've got several such, experiences also. So this is where, again, people get frustrated very badly. Then comes another way. Supposing, let us say, the information is available with them. Let us take the example of a Gram Panchayat. And this is a real life story. I got to know this story in December 2022 because an RTI activist in that village was murdered in broad daylight. And when I asked for the documents, that person was asking what RTI application had he filed, what information did he get, what response did he get, why did that murder happen, what was so dangerous about RTI. You will be surprised to know. All that this RTI applicant was asking was from the Gram Panchayat where he lives. Please tell us that what all money have you spent on developmental programs meant for shepherds. क्योंकि वो गांव जो है वहां पर बहुत सारे भेड़ बकरी पालने वाले लोग. It's mixed farming वाला village. So there are fields where agriculture happens and farmers also own a lot of sheep and goats. So this person said, please tell me how much money have you spent in this particular financial year in my village. Now that Gram Panchayat has 10 villages. It covers 10 villages. So in my village, You will be surprised to know, and I've seen this with my own eyes. The public information officer replies by saying that, look, the information that you want is in about 45,000 pages. So at the rate of 2 rupees per page, please pay 90,000 rupees and collect the information. And the RTA applicant is simply zapped. अरे मैंने तो इतनी जानकारी मांगी नहीं थी, मैंने केवल अपने गांव के बारे में जानकारी मांगी थी. So he clarifies and he says that, look, I don't want information for the whole panchayat. I want it only for my village. So please look at your records again and give it to me. And then what is the reply? Next reply. The public information officer has the audacity to say that, look, your RTA application is very vague. We don't know what exactly you are asking. But we want to tell you that no such developmental works have happened for, shepherds and all of that in this area that way that you are identifying. Okay, matter does not stop there. Then this RTA applicant is part of a group. That group learns from some knowledgeable person that there is a website exclusively dedicated to implementation of Mahatma Gandhi Narega Act. The Rural Employment Guarantee Act, where every rural household is entitled to receive 100 days of wage labor on payment of wages. They just have to apply with a job card and they should be granted 100 days of wage labor. Otherwise, they should get unemployment allowance. That is what the law says. And under that NREGA, there are various developmental projects that are identified for implementing every year. And when they begin implementation, each developmental work gets a unique ID, and information about the implementation of that developmental project is uploaded on the Narega portal. What is the total value of the project? What is it supposed to do? Is it a watershed project? Is it a road repair project? Is it a road construction project? Or is it a school building wall construction, a compound wall construction project? All details are there. How many laborers were employed in the developmental work? On how many days did they actually go and work there? What was the rate at which they were paid wages? For how many days were they paid wages? What are their bank accounts? What are their needs? All these details are there. So somebody told this group of people, including the RTI activists, that, look, don't sit and waste your time filing RTIs. Just go and look up this website. And believe you me, in that village where the public information officer of the Gram Panchayat said that there are no developmental works, these people were actually able to identify 6 developmental works under NREGA, जिसके लिए पैसा रिलीज हुआ था, खर्च भी हो गया था, यूटिलाइजेशन सर्टिफिकेट भी आ गया था. All information that they got from the NREGA portal. फिर उन्होंने उसके रिकॉर्ड्स मांगे, रिकॉर्ड्स मिले नहीं, डिटेल बिल्स वाउचर्स वगैरह जो है मिले नहीं. फिर उन्होंने उन जगहों पर जाकर जहां डेवलपमेंटल वर्क्स इंप्लीमेंट हुए थे वहां जाकर सोशल ऑडिट किया. They visited the place to cross check whether the work had actually happened or not. The work had not happened. They said check dam has been built, no check dam. They said this drains had been constructed, no drain. They said a pond for collecting water as part of the watershed management program has been constructed, there is no pond. So when these people started escalating this matter, filed a complaint with the ombudsman came and said, yes, works have not been implemented according to what has been explained on the website. And then they escalate the matter further, saying, now recover the money from the panchayat officers who have committed corruption. What is the response of the panchayat's officers? They get in touch with the people who colluded in this corrupt activity, and one fine day, I think it was on the 22nd of December, in broad daylight, they murdered the RTA activist in the field. So one of the biggest dilemma that people face is जानकारी मांगना जो है खतरे से परा नहीं. It is dangerous to life. Today morning, I got a story published in one of the local language media in Karnataka that a Dalit RTI activist was murdered by people who were troubled by his RTI activism because he was trying to expose irregularities in the local panchayat developmental works in another district of Karnataka. Actually, all the information that they are asking, according to section 4.1b, is required to be made public proactively. They don't have to wait for it to be disclosed on application. खुद को खुद बताना है, लेकिन आरटीआई एप्लीकेशन डालने के लिए मजबूर करेंगे, और जब जानकारी मांगते हैं तो इस तरह से वार करेंगे. सो दीज आर द काइंड्स ऑफ प्रॉब्लम्स दैट पीपल फेस. फिर एक और ये जानकारी देने से बचने के लिए जो तरकीबें अपनाते हैं पब्लिक अथॉरिटीज. They say that the information that you are asking, either they will charge 90,000 rupees, that's very common, 90,000, 50,000, 60,000, 70,000, just to discourage the person. इतना पैसा देकर कौन जानकारी लेने के लिए आगे आएगा? Very few people come. So अगर वो चला नहीं तो then they will say, you are asking for information that is too voluminous, therefore we won't give it to you. Now there is no such basis for saying we will not give you information just because it is too voluminous in the RTI Act. No such basis. All that the RTI Act says in section 7(9), which is often misused, is it says that, look, if you can't give information to people in the form in which they want, यानी किसी ने फोटोकॉपी मांगी लेकिन आप फोटोकॉपी नहीं दे पा रहे, किसी ने डिजिटाइज तरीके से सीडी पे जानकारी मांगी, आपने डिजिटाइज किया ही नहीं उसको, बस पेपर फाइल्स के रूप में रखा हुआ है, तो उस प्रारूप में, उस फॉर्मेट में आपको देने की बाध्यता नहीं है. लेकिन ये नहीं कहते कि कानून कि आप उसको रिजेक्ट करें. कानून की मंशा है कि उसके द्वारा मांगे गए प्रारूप में जानकारी नहीं दे सकते तो किसी अन्य प्रारूप में उसको दीजिए. If the files are voluminous, you tell the person to come and say prioritize which specific information you want first, and we will show you the files. You identify the pages and we'll make the photocopies and give it to you after you pay us 2 rupees per page. That they will not do. Straight away they will say section 7(9) is applicable, therefore we don't have a duty to give you information. Now I have only narrated to you some instances of how people are frustrated. There are several other instances also, but I want to move on. But before that, I'll just give one more example, and then I'll move on to the next stage, which is the appeal stage. The other example is some people want file inspection. RTI में क्या कहेंगे? Applicant कहता है कि फला प्रकार की जानकारी जिस फाइल में मौजूद है हमें उसका निरीक्षण करवाएं, which is a very good thing, because then that person doesn't have to be given access to all the pages photocopied. जरूरत नहीं है, वो स्पेसिफिकली फाइल देखकर बताएंगे कौन कौन से पेजेस की फोटोकॉपी चाहिए और वो बना के दे दीजिएगा. Ideally speaking, this kind of a system should work, but होता क्या है? There are many instances where इंस्पेक्शन के लिए तो बुलाएंगे, लेकिन इंस्पेक्शन के लिए जिस तारीख को बुलाया उसके बाद चिट्ठी पहुंचेगी आरटीआई एप्लीकेंट के पास, या फिर उनको बुला लिया और उनको डराया धमकाया सरकारी दफ्तर के अंदर, जैसे पिक्चर्स में, सिनेमाज में होता है ना, बहुत सारे बॉलीवुड फिल्म्स में, टॉलीवुड फिल्म्स में, सैंडलवुड फिल्म्स में होता है, हमने बहुत सारे देखे. गुंडागर्दी सरकारी दफ्तर के अंदर, पुलिस थाने के अंदर, उसी तरह की गुंडागर्दी आरटीआई एप्लीकेंट के साथ की जाती है. फिर मारपीट की जाती है और फिर उसी आरटीआई एप्लीकेंट के खिलाफ उसी सरकारी दफ्तर वाले जिन्होंने मारपीट किया पुलिस के पास जाकर कंप्लेंट लिखते हैं कि इसने हमारे दफ्तर में आकर धांधलेबाजी की, इसके खिलाफ एक्शन लिया जाए. FIR gets filed. That is not all. Bihar is one state. I don't know how many of you are here from Bihar. Bihar is one state where there is this very rampant phenomenon of false cases being registered against RTI applicants. Case after case after case against RTI applicants, 504, 506 दर्ज किया और उनको जेल भिजवाया, अरेस्ट करवाया, मुश्किल से बेल लेके बाहर आते हैं. Hundreds of false cases filed against RTI applicants. And the government does not do anything about them at all. They will only wait for the law to take its own course. And the poor RTI applicant has to run from Thana to court to lawyer's office to save himself. Invariably, those cases they end up in acquittal. अगर ट्रायल में जाते भी, rarely they go to trial. The only purpose is कि इसको जेल की हवा खिलवानी है, अरेस्ट कर लो, होश ठिकाने आ जाएंगे. I am not joking. There are many such examples from across the country. और क्या होता है? One other thing, मारपीट करेंगे दिन दहाड़े. मैंने वो एग्जांपल दिया इसके बारे में, मर्डर के बारे में, 2 मर्डर्स के बारे में कर्नाटका में. राजस्थान में I think about 2 years ago, there was another case. Dalit RT activist asking information about developmental works implemented by the local panchayat. So the local bigwigs, the politicians don't want to give the information. So what do? They attack him and they hammer nails into his legs. बिल्कुल बाबा आदम के जमाने के टॉर्चर के तरीके, ऑल डॉक्यूमेंटेड पब्लिकली। मैं कोई झूठ मूठ की कहानी नहीं बता रहा। आप अगर गूगल करेंगे राजस्थान आरटीआई एक्टिविस्ट टॉर्चर्ड, असॉल्टेड एंड hit with nails, story आपको मिल जाएगी। So this is the manner in which even at the application stage people get frustrated, people get discouraged, people are prevented from asking for information. होता ये क्यों? We will see that in the next session, but now let me go to the appeal stage. Appeal stage में क्या problem है? First appeal डिपार्टमेंट के अंदर, सेकंड अपील इंफॉर्मेशन कमीशन में, ये हर कोई आप में जानता है। इनवेरिएबली द फर्स्ट अपील इज अ वेस्ट ऑफ टाइम। ये मैं नहीं कह रहा, अपने एक्सपीरियंस के आधार पे स्टडी आफ्टर स्टडी इंक्लूडिंग गवर्नमेंट्स ओन स्टडीज आर शोइंग first appeal is invariably a waste of time because the appellate authority always supports what the public information officer says or does. No point of it at all. And जब तक आप first appeal फाइल नहीं करेंगे और उसमें निर्णय नहीं आएगा, you cannot file a second appeal. They will not take it. You cannot go directly to the information commission. सुप्रीम कोर्ट ने उसके ऊपर भी पाबंदी लगा दी। जानकारी यदि चाहिए तो पहले फर्स्ट अपील कीजिए, बाद में सेकंड अपील कीजिए, कंप्लेंट पे नहीं जा सकते। तो people file a first appeal, very often they don't know who is the appellate authority. क्यों? क्योंकि जो 17 पॉइंट्स जिसके ऊपर डिपार्टमेंट को पब्लिक करना है अपने बारे में जानकारी, उसमें पब्लिक इंफॉर्मेशन ऑफिसर की जानकारी और appellate अथॉरिटी की जानकारी भी शामिल, बताते नहीं। बोर्ड पे अगर लिखवा भी दिया तो दफ्तर के बिल्कुल पिछले हिस्से में जहां पे टॉयलेट होता है वहां पर रखी जाती है वो बोर्ड। एंट्रेंस पे जहां पे सबको दिखने वाली जगह है वहां पर नहीं लगता, या फिर बोर्ड ही नहीं लगाते। छोटे छोटे दफ्तरों के तो वेबसाइट्स भी नहीं, so you don't even know who is the appellate authority and people keep struggling just like they struggle to find out who is the public information officer, नाम से फाइल करना है। तो इसमें भी प्रॉब्लम है। आपने आरटीआई एप्लीकेशन फाइल किया, इस तरह के गोल मटोल जवाब आए। मेनी टाइम्स द पब्लिक इंफॉर्मेशन ऑफिसर्स डोंट इवन राइट देयर नेम, दे ओनली ऐसे हमारे यहाँ काकलिपि बोलते हैं ना, क्रोफीट काइंड ऑफ राइटिंग, इलेजिबल सिग्नेचर हो गया, नाम ही नहीं। अब उसके खिलाफ ना तो प्रथम अपील हो सकता है ना सेकंड अपील हो सकता है। कमीशन वाले भी लेने से इनकार करते हैं, बोलते हैं कि हमें नोटिस देनी पड़ती है तो आप पब्लिक इंफॉर्मेशन ऑफिसर का नाम तो बताइए। अरे जब खुद एप्लीकेंट को नाम नहीं बताया गया वो कहां से ढूंढ के लाएगा? उसके लिए एक और आरटीआई फाइल करेगा। सो फर्स्ट अपील में भी यही प्रॉब्लम। सेकंड अपील में तो भगवान बचाए। इनवेरिएबली आउट ऑफ एवरी 100 आरटीआई एप्लीकेशंस दैट गेट फाइल्ड at the application stage, barely 10 out of them will reach the first appeal stage. And out of that 10, and only 10%, यानी एक या दो will reach the information commission stage. फिर भी आज की तारीख में information commissions, many of them are overburdened. Central government में 35,000 pendency, Central Information Commission में, महाराष्ट्र में another 34-35,000 pendency, कर्नाटका में 50,000 cases pendency. All relating to matters where information should have been publicly disclosed by the public authority itself, or where the information officer should have applied his mind and given the information. नहीं देते हैं, and commission में अटके रहो. Sometimes it may take 6 months for the case to be decided. It may take 1 year. In Central Information Commission, it may take 1.5 years. In states like Maharashtra and Karnataka, where pendency levels are even higher, it may take 1.5 to 2 years. What is the use of that information which is not accessible immediately to people? It's useless. And now we look at examples for refusing information. PIO के स्टेज पे, appellate authority के स्टेज पे, कमीशन के स्टेज पे जो भी पर्सनल इंफॉर्मेशन नहीं दी जाएगी। फॉर एग्जाम्पल, अरे किसी सरकारी ऑफिसर का ट्रांसफर पॉलिसी जो सरकार की होती है कि 3 साल के पहले किसी को ट्रांसफर नहीं करना है अनलेस देयर आर वेरी गुड रीजंस, उसको ट्रांसफर कर दिया गया, 1.5 साल में ट्रांसफर कर दिया गया। वो खुद आरटीआई डालता नहीं है क्योंकि उसको पता है कि उसकी नौकरी खतरे में है, अपने बीवी से डलवाता है आरटीआई एप्लीकेशन या किसी दूसरे व्यक्ति से आरटीआई एक्टिविस्ट से डलवाता है कि पता करे कि मेरी ट्रांसफर क्यों हुई। And the response is, oh, this is personal information of officer. It is a matter between the employee and the employer. Therefore, it can't be given to you. Today, even the Honorable Supreme Court of India Constitution Bench has said that this matter is between employer and employee. Nobody has a right to get this information unless you can show whether it is in public interest to disclose. I can even cite the case history. So, personal information is one basis on which many RTA applications, first appeals and second appeals are rejected. I think somebody is talking. Please switch off your mic. Yeah. Or the other problem that people face at the Information Commission stage is this, and this is a common story that I've heard in places like UP, Bihar, Madhya Pradesh, Chhattisgarh, even South Indian states like Karnataka, Tamil Nadu. Date of hearing is fixed for today. The notice of hearing reaches by post less than 24 hours earlier. How will this person plan if he's living in a far-off district to go to the state headquarters and attend the hearing? Central government, it is slightly easier. If a person is not based in Delhi, invariably they will schedule a hearing through video conferencing facility. All that you have to do is go to the district NIC studio in the collector's office, sit there and attend the hearing. Very easy. Some states also have started conducting hearings through VC. But in many places they don't. Invariably, they ask the RTA applicant to come to the office of the Information Commission, but notice does not reach them on time. And then what happens? Because the RTA applicant is not present during the hearing before the commission, many information commissioners say it appears that the applicant is no longer interested. That is why he is absent. Therefore, matter is disposed of. Koi order hi nahi. In cases where the RTA applicant goes and argues his or her case before the commission, pointing out the various ways in which information has been denied or attempts to access information have been frustrated, penalty नहीं लगता, शो कॉज नोटिस तक नहीं लगता. अगर एक कमिश्नर 10 शो कॉज नोटिस भी लगा देता है मुश्किल से, तो एक में भी अगर पेनल्टी लग जाए तो बहुत बड़ी बात. Occasionally there are commissioners here and there who impose penalties according to the law, but in most cases even show cause notice is not issued. और क्या होता है हियरिंग में? क्योंकि हियरिंग अपील फाइल करने के 6 महीने बाद, 8 महीने बाद, 1 साल बाद, 1.5 साल बाद, कभी कभी 2 साल बाद आता है, तो PIO का तबादला हो गया होता है. He's transferred out, so he is not available for the hearing. On whom will you impose penalty? Now, states like Uttar Pradesh have made rules which say it is not compulsory for the public information officer to attend the hearing. तो करते क्या है? चपरासी को भेज देते हैं, सेक्शन ऑफिसर को भेज देते हैं, क्लर्क को भेज देते हैं, FDC को भेज देते हैं. That fellow comes with the file, all right. He has no clue about the case. He was never involved in RTI intervention at all. He was never part of the decision-making process, but he's still there representing the public authority and the public information officer. Commission is frustrated. This fellow doesn't know anything. When the commissioner questions, and I've been party to some of these hearings as an observer, and I know that when they ask questions, why was this information not given? The representative of the public authority has no clue at all. सर ये मुझे बोला गया है कि मुझे रिप्रेजेंट करना है, मैं फाइल लेके आया हूं सर, आप फाइल देख लीजिए. He has no understanding. So these are the millions of ways in which people face problems using the RTI Act to ask for information, which in 9 out of 10 cases should have been made accessible to people voluntarily. यानी सरकार को खुद ब खुद वो जानकारी सारा बताना चाहिए था, वो करते नहीं है, इसलिए RTI एप्लीकेशन फाइल करना पड़ता है. फाइल करने के बावजूद वो इंफॉर्मेशन मिलता नहीं. लेकिन फिर भी बहुत सारे ऐसे किस्से कहानियां हैं जहां पर जानकारी मिल जाती है और लोग उसका इतना अच्छा इस्तेमाल करते हैं दिखाने के लिए कि कानून के मुताबिक सरकार के अंदर कामकाज नहीं हुआ है. Because impact stories are not the subject matter of today's presentation, I am not going into that. But there are n number of stories also, despite all these challenges that I have shared with you. So the success stories of use of RTI in an effective manner is practically the tip of the iceberg. The whole iceberg is about use of RTI by citizens. So the success stories are the tip, 1/10 of the size of the iceberg. 9/10 which is hidden below the sea, below the ocean, those are the practical problems which people are facing while filing RTIs. When women go to file RTIs, औरतों को बोला जाता है, अरे तुम्हें जानकारी की क्या है, तुम तो महिला हो, घर में चूल्हा चौकट उसको संभालो. दलित यदि अगर जानकारी मांगने जाता है, उसको बोला जाता है अपनी औकात में रहो, ये क्या कानून का रट लगा रखिए. आदिवासी अगर आरटीआई फाइल करने जाता है तो उसको बोला जाता है तुम तो अनपढ़ हो, गवार हो, जानकारी लेके क्या करोगे. अब रिलीजियस माइनॉरिटीज के बारे में ना बोले तो अच्छा है. बहुत ही कम रिलीजियस माइनॉरिटीज आरटीआई का इस्तेमाल करते हैं, वेरी फ्यू. किसी ने उनको सिखाने की कोशिश भी नहीं करी, और उनको पता है कि हम जानकारी अगर मांगने जाएंगे बहुत सारी चीजों के बारे में तो मारपीट हमारे साथ हो सकती है, तो हम मांगेंगे नहीं. वेरी फ्यू यूज आरटीआई इन द माइनॉरिटी कम्युनिटी. So these are the very major problems that people face with regard to seeking information under RTI. I am not even getting into the arena of how courts have dealt with RTI. वो शायद अगले सेशन में बात करेंगे हम लोग, या फिर आपके सवाल जवाब के सिलसिले में I will try and address it. But there are problems at the level of high courts and Supreme Court also. एक तो मैंने ऑलरेडी बता दिया कि ट्रांसफर वाली जानकारी भी आप ले नहीं सकते आरटीआई में. सुप्रीम कोर्ट ने उसके ऊपर पाबंदी लगा दी. So there are these problems. Anyway, so I think I've spoken for about an hour now, so I will stop. We still have half an hour. I suppose we can take a break at 5:30. But before that, we have half an hour. So let us open up the floor. I'm sure many of you will have questions. तो आपके मन में जो भी सवाल हो इस पहले सत्र के विषय वस्तु से जुड़े हुए, तो कृपया अपना माइक अनम्यूट करें और सवाल उठाएं. Or if you want to put it in the chat box, I can take a look at the chat box related questions also and respond to it. So Gauri ji, would you like to moderate the session?
Yes, sir. Participants, if you have any questions, you can unmute yourself and ask. Kindly unmute yourself and ask your question, or you can also drop your question in the chat box. Anyone who wants to ask any question?
Somebody has said good session, thank you very much. But this is, and somebody is now saying really nice session, thank you very much. But this is also an interactive session, so please do feel free to speak up. Now, supposing it's quite possible that you may not agree with something that I'm saying or that I've said so far. This is an open space. There is freedom to even voice a different view also. So please feel free to speak up. Just because I'm here as a resource person doesn't mean that you should agree with everything that I'm saying. This is a forum for discussion, so let us talk. So please feel free to talk. Go ahead.
Yes, sir. Hello. Hello.
Yeah, go
Yes,
ahead.
ma'am.
Hello, sir.
Yes.
Am I audible, sir?
Yes, I can hear you. Please go ahead.
Okay, sir. Sir, thank you so much, sir. We got so many information regarding the practical problems, whatever faced by this RTI. But one question I just want to say, want to clarify.
Yes.
Sir, I have, as I am a faculty of law, so I have seen one RTI has came to our department regarding knowing some information about a student. Okay, sir. But whenever I have seen that letter, name is there, but whenever their department want to know about the particular person who has sent it and trying to know, but when they have to trying to trace it, he said, this is not mine.
Okay.
So that type of problem is facing by the institution or by the office. Whoever sending, he is not also clarified. He is about his address or want to know regarding this false information or false address they have given. It is a happening, sir. How can we have to do that?
I agree with you, because I have had some of my own friends who are very well known RTI activists. Like there is one example of a friend of mine who is based in Mumbai. तो उनके नाम से आरटीआई एप्लीकेशन किसी और ने फाइल कर दिया. चिट्ठी जो है पब्लिक इंफॉर्मेशन ऑफिसर की तरफ से जवाब के रूप में उसके पास आई. So he looks at the reply of the PIO and says, "Arey, I never asked for this information."
Yes, sir. That is also happening.
So he said, "I am sorry, I am not willing to give this because I never asked for it." This is not my signature. So I'm not paying for this information. It's a matter ends there. But sometimes you're absolutely right. Address is false, name is false. So in such situations, what do? There is no way you can actually identify those people. Otherwise, you would be able to contact them. So the simplest thing to do is keep that RTA application on record. And on the daily note sheet, you mentioned that we made an attempt to identify this person. We sent a reply, but it came back undelivered because the address is false, or the addressee has not found at that address at all, or the person refused to accept that it was his RTA application. So keep that details of action taken on the RTA application on record under the signature of the PIO, so that tomorrow, because some of them are perfectly capable of going to the Information Commission saying, we filed the RTA application, we never got a response. So at that point of time, you should be able to defend yourself. So keep that file ready and say that, look, on this date, we sent a reply. This is the envelope which came back to us undelivered. Postal Department is saying we can't trace the RTA applicant. Who is the addressee? So that is your proof that it's a false application, and you leave the matter there. Nothing more can be. You cannot even impose a penalty. पता ही नहीं किसके ऊपर penalty लगानी है. Okay, so Mr. Virendra Kumar Thakur, yeah, you're welcome.
Thank you so much.
Yes, Mr. Thakur, go ahead.
Good evening, sir.
Good evening.
I'm Virendra Kumar M. Thakur. I am Assistant Professor of Computer Science and Engineering in GB Pant Institute of Engineering and Technology, Podi in Uttarakhand.
Okay.
I'm also RTI resource person of Uttarakhand Information Commission in Dehradun.
Very good.
Regarding the query that was asked by Madam, I just want to add something. That whenever such information related to students is asked, so PIO can reject that under section 81J, that is a personal information.
Yes.
As far as the credentials of the applicants are concerned, so section 6.2 expressly prohibits that you cannot ask anything about the locus standi of the person or why he wants that particular information.
Yes.
But once you reject under 81J, then the burden of proving that there is personal interest falls upon the say applicant, and the basic test that is given by the Supreme Court in the Girish Ramchandra Deshpande, R.K. Jain, and various other cases like CPIO Supreme Court of India versus Subhash Chandra Agarwal, is that firstly, if the public interest exceeds the private interest, then the information should be given, and if the harm to the private interest exceeds the personal interest, then the information should not be given. So the procedure that is to be adopted in such cases is very long. And in 81J, first a notice under section 11 has to be given. If the person who seeks the information is a parent, then I think the information of students may be given. If the person is unknown, just like the query that was raised about a person who is unknown, so in such cases, it is safe to reject it under 81J. And if the matter goes in first or second appeal, normally there is no penalty in such cases, because the person has to prove the public interest, though not in the application itself, but at the first appellate level or the second appellate level. So in such cases, the burden then falls upon because the word that is used in 19.5 is onus of proof. It is not burden of proof. So it is the onus of proof, and onus of proof, once the PIO has rejected, that shifts to the applicant, and the applicant then has to bring it under the exception to the exemption, that the information has to be given because there is some public interest. So that information, I think, can be safely given under 81J. Even it could be rejected under 81G, that is say harm to life as far as students are concerned, because we as teachers are the guardians of student, and it is also our duty to protect our students. I have handled about 700 RTI cases in my tenure as 13-14 years as PIO, and I have found that such information about students are asked. So first, there are very few instances like this. So in such cases, it is safe to reject them under 81J and let the matter go in first or second appellate stage. So that is the second approach. As far as I would also like to answer the second query that is answered, that is personal interest and social interest. Actually, it is not social interest. The RTI Act speaks about the public interest. There are no definitions as such. There is no definition of personal interest, public interest. But public interest is where that is say bringing transparency in administration, that is public interest. Reducing corruption in public offices, government offices, that is the public interest. As far as private interest is concerned, so intention to harm somebody is private interest. Private interest could be of two persons, either of the applicant himself or it could be of the third party. Third party is defined in section 2N of the Act, that is anybody except the say applicant and the public authority is termed as third party, and third party could even be a public authority. So in such cases, the intention could be either to harm somebody, or it could be say some malicious intent. So if such intention is there, then it is said to be say it comes under say right to privacy, and then the procedure prescribed under section 7781J 11 and 19.2, that is first appeal right, and 19.4, that is third party appeal to the Information Commission. That procedure needs to be followed. So if somebody wants to know in detail, then there is this judgment of CPIO, Supreme Court of India versus Subhash Chandra Agarwal, November 2019. In that judgment, they have told in detail. It was a constitutional bench, minimum 5 judges. There were 5 judges in that case, in that judgment, and in that they have given information about public interest, private interest, and even they have classified or differentiated between the personal information, private information, confidential information, and public information. So these things can be found in detail. That judgment is in 3 parts. So there is one majority judgment. Then there are separate judgments of Justice Ramana and Justice Chandrachud. So in those judgments, these things are given in more details. Thank you so much.
Thank you. So Gauri ji and Gaurav, next time you should actually invite Mr. Thakkar to conduct these kinds of sessions. You have a local resource person. You don't need to reach out to me in Bangalore.
Yes,
absolutely, absolutely. Enlightening and very encouraging of issues that Mr. Thakkar has highlighted. Of course, we can get into an academic discussion about the correctness of the Constitution Bench's majority view judgment, but we'll not get into that right now.
Sure, sir.
Yeah.
So, any other question, participants?
I think in the chat box,
there are questions in the chat box. Yes, sir.
Yeah. So let me take them up one by one. Is there any benefit of enforcing this RTI Act in reality? Of course there is. There are so many benefits. The first benefit is it gives people the voice to formally write to government and expect a response, not just response, but information contained in government files within 30 days on threat of penalty. This is where the empowering nature of the RTI Act comes in. And there are a number of stories. There is a case from Uttar Pradesh decided by the Allahabad High Court a few years ago, Aarti Devi versus one of the oil companies. Now, in this case, what happened was the concerned oil company actually invited applications from eligible women, I think widows of former defense personnel who died in service, for application for petrol pumps and gas agencies, I think. And the allotment process was completed, allotments were made. And Aarti Devi actually found that the agency had allotted one such pump to a woman who had submitted fictitious income details. So she filed an RTI application asking for the income details and all the documents that this lady had submitted. And she was rejected throughout. Everybody said, just like Mr. Dr. Thakkar was pointing out, personal information can't be disclosed. But eventually the Allahabad High Court said, this is a matter where the lady is alleging irregularities in the allotment of this petrol pump. This is a matter of public interest, even though it might be between two people. Now, that is why I keep saying that there can be an academic discussion about the correctness of the Supreme Court judgment in CPIO versus Subhash Chandra Agarwal. It is sometimes misunderstood. In the majority judgment, and particularly in Justice Chandrachud's judgment, it is said very clearly, public interest does not necessarily involve large numbers of people. पूरे गांव के लोग, शहर के लोग, स्टेट के लोग, जिले के लोग, तादाद की यहाँ पर क्राइटेरियन नहीं है. What is of interest is whether it is a matter of public interest, यानी क्या मामला सार्वजनिक हित में है कि नहीं. And there's a beautiful principle that Justice Chandrachud explains in that judgment. Protecting somebody's personal information is not because it is that person's personal right. Protecting privacy, protecting personal information from being misused is in the public interest. हर एक का, भले ही एक व्यक्ति के बारे में जानकारी क्यों ना मांगी गई. And that is a principle that very often public information officers do not understand. And I must also say, in this forum, even information commissioners don't understand most of the time. बोल रहे ये आपका पर्सनल इंटरेस्ट है, ये कोई पब्लिक इंटरेस्ट इसमें है नहीं. This is not true. In the Rafale review judgment, which had nothing to do with RTI, but Supreme Court of India in the review judgment said very clearly, the right to seek justice under Article 32 of the Constitution is a basis for exercising freedom of speech and expression. And therefore, because RTI is a part of freedom of speech and expression, it can be the basis for exercising RTI also, for seeking information. So one person's right to seek justice is in the public interest. Information has to be given. That is why Aarti Devi got her information. Allahabad High Court tak jana pada, lekin unhone de diya. But today, most public information officers, most appellate authorities, and a large number of information commissioners don't even apply this ratio. They think, oh, ये आपका पर्सनल मामला है, नहीं दे सकते. हाई कोर्ट से भी ऐसे कई सारे मामले में बोल दिया, ये आपका पर्सनल सर्विस मैटर है, इसमें कोई पब्लिक इंटरेस्ट नहीं. अरे मुझे इंसाफ के लिए लड़ना है भैया, और इंसाफ के लिए लड़ाई करने के लिए मुझे जानकारी चाहिए, नहीं मिलेगा. So despite all the very pious pronouncements of various judgments, when it comes to implementation, there are serious problems because the ratio, the principles laid down in those judgments are not applied in a practical manner. And I can give a number of my own RTI interventions as examples, but we will not get into that. Let's move on. Let's look at the next question.
Sir, if you permit, may I take up one or two questions, sir?
Can I also respond to them, sir? And then perhaps you can.
Sure. Okay, sir. Sure. Definitely.
Personal interest and social interest, ये तो Dr. Thakur ने already बोल दिया, so I will not get into that. Social interest, by the way, is not even mentioned anywhere in RTI, so you don't have to worry about that. It's called public interest. Are there any exemptions or exceptions to RTI? Of course. Section 8(1), फिर Section 11, फिर Section 24. Exceptions both. But they are exceptions which are most of the time circumstantial in nature. यानी जानकारी देने की प्रभाव, उसका असर क्या होगा. नुकसान पहुंचाएगा तो जानकारी देने से इनकार किया जा सकता है, नुकसान नहीं पहुंचाएगा तो जानकारी दिया जा सकता है. For example, 8(1)(a), our sovereignty, territorial integrity, defense interests, economic interests, strategic interests, scientific interests, relations with foreign states, or incitement to committing an offense. जानकारी देने से ऐसी जानकारी नहीं दी जाएगी. यदि किसी कोर्ट ने बोला हो ये जानकारी नहीं दी जाएगी, या फिर जानकारी के खुलासे से कोर्ट की निंदा होती हो, contempt of court might happen, then there is no duty to give that information. Anything that will breach the privilege of parliament or state legislatures, उनका जो विशेष अधिकार है, गोपनीय रखे जाने वाली बात को कोई अगर मांग रहा है, देने की इजाजत नहीं है. किसी की बौद्धिक संपदा अधिकार, इंटेलेक्चुअल प्रॉपर्टी राइट, जिसके खुलासे से किसी के प्रतिस्पर्धात्मक स्थिति पर प्रतिकूल असर पड़ता हो, कॉम्पिटिटिव पोजीशन के ऊपर. ट्रेड सीक्रेट्स, कमर्शियल सीक्रेट्स देने की इजाजत नहीं है. फाइडेंशियल रिलेशनशिप में जो जानकारी दी जाएगी, लॉयर क्लाइंट के बीच, डॉक्टर पेशेंट के बीच, हस्बैंड वाइफ के बीच, जानकारी देने की इजाजत नहीं है. जानकारी के खुलासे से अगर अपराध के तहकीकात में अगर कोई नुकसान पड़ता हो, मुकदमा के चलाने पर अगर असर पड़ता हो, अपराधी के पकड़े जाने के ऊपर वो प्रतिकूल असर पड़ता हो, जानकारी देने की इजाजत नहीं है. और जैसे ठक्कर साहब ने कहा, किसी की जान को नुकसान पहुंचाने वाली जानकारी, या फिर जो खबरी जो पहुंचाते हैं जानकारी सरकार को, उसको उसका स्रोत, यदि उसका सोर्स अगर खोल देने लायक जानकारी अगर कोई मांगता है, तो वो जानकारी देने से इनकार किया जा सकता है. किसी विदेशी सरकार से गोपनीय करार करके कोई जानकारी दी गई, उसको मना किया जा सकता है. जब तक मामला कैबिनेट के द्वारा निर्णित ना हो जाए, कैबिनेट पेपर्स नहीं दिया जा सकता. लेकिन कैबिनेट के डिसीजन यदि हो जाए, मामला संपूर्ण हो गया है, समाप्ति हो गई है, इंप्लीमेंटेशन बस बाकी है, तो ऐसी स्थिति में कैबिनेट का निर्णय बताना पड़ेगा, निर्णय के पीछे के कारण बताने पड़ेंगे, और उनके जो बेसिक मटेरियल्स हैं वो भी बताने पड़ेंगे. और जैसे इन्होंने बताया प्राइवेट इंफॉर्मेशन, जहां पर जानकारी के खुलासे से किसी के निजता या एकांतता के अधिकार के ऊपर प्रतिकूल असर पड़ता, अनवांटेड इन्वेजन ऑफ द प्राइवेसी ऑफ एन इंडिविजुअल, ऐसी जानकारी देने से इजाजत देने के लिए इजाजत नहीं है। लेकिन इन छूटों के दायरे में आने के बावजूद यदि आप ये दर्शा सकते हैं कि जानकारी क्यों पब्लिक किया जाना चाहिए, करप्शन के पर्दाफाश करने के लिए, जवाबदेही कायम करने के लिए, कहीं पर कोई क्या कहते हैं उसको, अवैधिक तरीके से निर्णय लिया गया हो, सरकारी कामकाज किया गया हो, इलीगल एक्टिविटीज का अगर पर्दाफाश करना है तो वो पब्लिक इंटरेस्ट का मामला है, जानकारी छूटों के दायरे में आने के बावजूद पब्लिक किया जा सकता है। सेक्शन 11 में कुछ ट्रेड एंड कमर्शियल सीक्रेट्स से को छोड़कर बाकी सारी जानकारी पब्लिक इंटरेस्ट में की जा सकती है। सेक्शन 24 ये कहता है कि कुछ ऐसे संस्थाएं हैं जिनको सरकार केंद्र के स्तर पर और राज्य के स्तर पर लिस्ट आउट करती है, जो सिक्योरिटी और इंटेलिजेंस एजेंसीज हैं। करप्शन के मामले और मानवाधिकार के उल्लंघन के मामले जहां पे आरोप लगे, उन आरोपों से संबंधित जानकारी आपको दी जानी चाहिए। और यदि मानवाधिकार के आरोपों से संबंधित जानकारी मांगी गई है इन संस्थाओं में से, तो 45 दिन के अंदर संबंधित सूचना आयोग की इजाजत के साथ वो जानकारी दिया जाना चाहिए। सो ये सारे होते हैं छूटों के दायरे में आने वाली जानकारी। नाउ आई विल टेक द नेक्स्ट क्वेश्चन। Matters pertaining to employer-employee service conditions, termination, etc. should definitely be a secondary concern when it is about RTI, since privacy is primary. How do you think privacy can be harmonized in such cases? Now, this is where you asked me a question, so now I'm getting into the academic discussion. Canara Bank versus C.S. Shyam. Honorable Supreme Court said Girish Ramchandra Deshpande's decision about employer-employee matter is secretive, therefore it can't be given. Absolutely unthought through decision. Why? And I say this with the deepest respect to the Supreme Court. Transfer orders are publicly known. डिपार्टमेंट के अंदर पता है कि किस अधिकारी को कौन से पद से कौन से पद को ट्रांसफर किया गया। आईएएस, आईपीएस, आईएफएस और स्टेट सिविल सर्विसेज सीनियर रैंक के ऑफिसर्स के ट्रांसफर ऑर्डर्स आर ऑल रिपोर्टेड इन द मीडिया। इसमें कौन सी सीक्रेटिव है भाई? कैसे आपने 81J के दायरे में इसको डाल दिया? आई डोंट नो। नाउ इमूवेबल प्रॉपर्टी स्टेटमेंट्स, एसेट जो इमूवेबल एसेट्स का जो ब्यौरा दिए जाते हैं, गिरीश रामचंद्र देशपांडे ने बोला कि ये नहीं दे सकते पब्लिक को। सीएस श्याम में और फिर सीपीआईओ वर्सेस सुभाष चंद्र अग्रवाल में बोल दिया ना नहीं दे सकते, क्योंकि पहले सुप्रीम कोर्ट ने बोल दिया। अरे हैव यू इवन एग्जामिन्ड द ऑल इंडिया सर्विसेज रूल्स दैट रिक्वायर आईएएस ऑफिसर्स, आईपीएस ऑफिसर्स, इंडियन फॉरेस्ट ऑफिस सर्विसेज एंड इंडियन फॉरेन सर्विस ऑफिसर्स टू पुट देयर immovable property return details on a publicly accessible website? No, इसके तरफ ध्यान नहीं दिया। वो छोड़िए, वो ध्यान नहीं दिया। नीतीश कुमार जी की सरकार बिहार में जो है, they have created a specific website for disclosing the immovable property returns of all officers starting from chief secretary down to the second divisional clerk. आप उस लिंक पे क्लिक करेंगे उनके वेबसाइट पे, गवर्नमेंट पोर्टल के थ्रू, you will be able to see how much tax did the chief secretary pay to the income tax department in the previous year. Supreme Court कहती है ये जानकारी प्राइवेट है, 81J में आएगा। So the problem, what happens is this: even Supreme Court is not supposed to know all these things. What happens is people who go and argue these matters on behalf of petitioners often don't do their research properly. As a result of which, what happens? Information that is already in the public domain, unfortunately, because of these poorly thought out decisions of the Supreme Court, whether it is from 2-member bench or 3-member bench or constitution bench, they become the law. तो जो जानकारी ऑलरेडी पब्लिक है, लोग उसको देख रहे हैं, ढूंढ रहे हैं, पढ़ रहे हैं, समझ रहे हैं। महामहिम सुप्रीम कोर्ट ने बोल दिया कि ये जानकारी प्राइवेट में आएगा, और उस बात को लेकर पब्लिक इंफॉर्मेशन ऑफिसर्स निर्णय देना शुरू करेंगे कि ये जानकारी पब्लिक नहीं की जा सकती। So this is where the problems arise. Even in the case law that has developed, there is so much of disparity, and very often public information officers don't know what information to give and what not to give. 1990s का केस है, दिल्ली हाईकोर्ट के डिवीजन बेंच ने बोला कि ACRs पब्लिक किए जा सकते हैं। RTIs के पहले वारिस रशीद किडवाई वाले केस में, अरविंद केजरीवाल के केस में, अरविंद केजरीवाल जी के केस में, जब वो दिल्ली के मुख्यमंत्री नहीं बने थे, सुप्रीम कोर्ट ने जानकारी देना तो, सॉरी, दिल्ली हाई कोर्ट ने जानकारी देने से तो इनकार नहीं किया, वो वहां तक पहुंचे भी नहीं Central Information Commission issued notice to the Department of Personnel and Training saying, please provide us the records so that we can make a decision on whether the ACRs of third parties can be given to Arvind Kejriwal ji. उस पर दिल्ली हाईकोर्ट ने रोक लगा दिया कि आप ये जानकारी नहीं दे सकते. किसको? अरविंद केजरीवाल जी को नहीं, सेंट्रल इंफॉर्मेशन कमीशन को. जबकि सेक्शन 23 कहता है आरटीआई का कि जब तक मामला इंफॉर्मेशन कमीशन के द्वारा निपटाया नहीं जाएगा, कोई भी कोर्ट उसमें दखल अंदाजी नहीं कर सकती. नो स्टे, नो इंजंक्शन, नो प्रोहिबिशन, नो प्लीनरी पावर्स कॉन्स्टिट्यूशन में दिए गए हैं. And Honorable Delhi High Court said, sorry, this information can't be given, and therefore even Commission will not ask for this information. अरे रामराज है या बंदर राज है? कानून का राज है भैया, पहले कानून को तो पूरे पढ़िए. मद्रास हाईकोर्ट से एक जजमेंट आता है डिवीजन बेंच का. मैडम जस्टिस राइट्स कि this particular citizen has asked for information without disclosing why they want the information. Reasons are not given, therefore information denied. क्यों? मैडम ने सेक्शन 62 को पढ़ा ही नहीं जजमेंट लिखते समय. हम लोगों ने हल्ला उठाया कि अरे 62 को प्लीज देखिए मैडम. मीडिया के थ्रू हमने जजमेंट का एकेडमिक क्रिटिसिज्म निकाला और फिर सुप्रीम कोर्ट मद्रास हाई कोर्ट ने सुओ मोटो उस जजमेंट को वापस करके लेकर उस पैराग्राफ को हटा दिया और बोला वी आर सॉरी, वी हैवंट सीन दिस पर्टिकुलर जजमेंट, दिस पर्टिकुलर प्रोविजन ऑफ द एक्ट. अरे हाई कोर्ट जज होने के बावजूद आप कानून के प्रोविजंस को बिना पढ़े जजमेंट दे रहे हैं. तो इसका मतलब ये होता है या तो आप वहां बैठने के लिए probably we have to question whether you are correct, or your judgments are actually being drafted by somebody else who has not read the law. It can be either this or that, nothing else. So therefore today we have a situation where we have some very good decisions that are coming from the courts. At the same time we have poorly thought out decisions that are coming out from the courts. I'm not even getting into information commissions. बहुत complications है. कुछ अच्छे decisions आते हैं, हर 5 अच्छे decisions के लिए 15 बिल्कुल गंदे decisions आ रहे हैं. ये भी है, हर information commission का ये हाल है. Consistency नहीं है, because of which public information officers don't know which route to follow, and very often because there are thousands and thousands of cases, even RTA applicants don't know कौन सा इसको हम cite करें, प्रोविजन को साइड करें. मेरे पास तो एक पूरा पावर पॉइंट प्रेजेंटेशन दिखाने के लिए कि कौन से हाई कोर्ट का कौन से मुद्दे पर जजमेंट क्या आया, उसी हाई कोर्ट का दूसरे बेंच ने कैसे उसका विपरीत जजमेंट दिया किसी दूसरे मामले में, या फिर किसी दूसरे हाई कोर्ट ने उस जजमेंट को उसी मामले में बिल्कुल विपरीत जजमेंट दिया. एक ही एग्जांपल मैं देता हूं. केरला में बोला गया केरला हाई कोर्ट के द्वारा कि कोई भी हिंदुओं के मंदिर आरटीआई कानून के दायरे में नहीं आएंगे. बाजू के तमिलनाडु के मद्रास हाई कोर्ट ने बोला नहीं नहीं, हमारे यहाँ सारे मंदिर जो है आरटीआई के दायरे में आएंगे. यानी बॉर्डर के उस तरफ जाओ, मंदिरों से जानकारी नहीं मिलेगी आरटीआई में. बॉर्डर के इस तरफ आओ, मंदिरों से जानकारी आरटीआई में बकायदा आपको मिलेगी. सो दिस इज वेयर वी हैव लैक ऑफ synchronicity, we have lack of uniformity, we have lack of consistency in the implementation and interpretation of RTI. And that is the reason why what is happening today is public authorities in their training courses take only those judgments which suit their way of thinking, either not to give information or frustrate the citizen. And that becomes part of the training. The positive one, जैसे ठक्कर साहब ने कहा, CPIO वर्सेस सुभाष चंद्र अग्रवाल में जस्टिस चंद्रचूड़ की जजमेंट है, जजमेंट में बहुत ही बढ़िया डिस्कशन है कि पब्लिक इंटरेस्ट में किन किन बिंदुओं पर विचार करना पड़ेगा जानकारी देने के लिए, और किन किन बिंदु विचार योग्य नहीं है. व्हाट इज नॉट टू बी कंसिडर्ड व्हाइल डिटरमिनिंग पब्लिक इंटरेस्ट. कोई उसके ऊपर अमल नहीं है. Nobody even pays attention to it. This is where the problems are. Anyway, I think there is just one more question and then I will stop here and we can perhaps ask Thakkar Saab again to come back. Okay, is section 4(1)(b) mandatorily implemented by public authorities as they continue to avoid? Yes. CBSE versus Aditya Bandyopadhyay केस में सुप्रीम कोर्ट ने बोला सेक्शन 4(1)(b) is a mandatory obligation, हर डिपार्टमेंट को करना चाहिए. 2011 से 2013 तक मैं सेंट्रल गवर्नमेंट के टास्क फोर्स में एक मेंबर था, गाइडलाइंस ड्रॉ अप करने के लिए कि सेक्शन 4(1)(b) डिस्क्लोजर का अमल कैसे करें. Entire chapters of those guidelines I have written and they have been taken on word for word and today they are guidelines for the whole country. 2016 में ये गाइडलाइंस इंप्लीमेंट क्यों नहीं हो रहे हैं, इसको लेकर फिर से चर्चा हुई टास्क फोर्स की, और भी कुछ गाइडलाइंस फिर से निकाले गए कि कैसे इसको इम्प्लीमेंट करना है। एक फैसिलिटेशन सेंटर खोलना है हर पब्लिक अथॉरिटी के ग्राउंड लेवल फ्लोर पर, ताकि लोग वहां पर आए इंटरनेट की उसके माध्यम से जानकारी सेक्शन 4(1)(b) का ले। कोई नहीं कर रहा। व्हाई? देयर इज नो पॉलिटिकल विल। और ये पॉलिटिकल विल क्यों नहीं है, ये मैं ब्रेक के बाद अगले सेशन में इस मामले को मैं उठाऊंगा। द डायलेमास विद रिगार्ड टू द इम्प्लीमेंटेशन ऑफ द आरटीआई एक्ट और व्हाट इज द वे फॉरवर्ड। आई विल स्टॉप हियर। सो इफ देयर इज I think Mr. Sujay John has his hand up. Please ask a question, and then we will go to Thakar Saab because he wanted to add something to what I have said. So we'll give him the opportunity. Mr. John.
Yeah,
if you want to raise the
Mr. Thank you, sir. Am I audible?
Yes, you are audible. Please go ahead.
Sir, I wanted to ask, since most of us are teachers here, is it mandatory or a canon that that RTIs that come to an organization be displayed on their websites?
Okay, excellent question. The guidelines that I talked to you about, which I was part of, there is a paragraph which says very clearly, all RTI applications and replies must be made public, subject to exemptions. Yani, if somebody, for example, has asked for their evaluated answer script, and you have decided to give it to them in accordance with CBSE versus Aditya Bandyopadhyay का ratio, जो student है उसको पूरा अधिकार है to see his evaluated answer script and get a certified copy or photocopy or whatever. Now that RTI application, when you disclose, the application can be disclosed copy. The decision to or give access to that information can be disclosed, but the answer script itself cannot be disclosed. Why? Because Supreme Court has said very clearly that third parties do not have a right to see a student's evaluated answer script until and unless they demonstrate what is the public interest in disclosure. Similarly, wherever there is information that may violate the rights of citizens through disclosure, that you can withhold. But all other information, for example, if they were to ask you, please tell us what is the pass percentage in your education institution for the last 10 years. Just pass percentage. So that information you are anyway giving to the applicant. No harm in disclosing that to the public authorities. I'll give you an example why this is important. There is a tehsil in Karnataka, neighboring Bangalore, where I stay. It's called Chintamani, and it's part of Chikbalapur district. In that Chintamani district, there is one gentleman who runs a bi-monthly Kannada journal exclusively based on RTI information. 5,000 copies are printed every 2 months. It is laptop-like dosas. No copy goes waste. Now, what did this gentleman do? He asked the Department of Higher Education for the pass percentages of all the education institutions in his area, various graduate level courses. He published that information on one side of the sheet. On the other side of the sheet, he printed copies of the advertisements of those very education institutions where they had claimed a certain pass percentage, which was much higher than what the government records showed. He didn't do anything else. He just said, look, this is information that I got under RTI. This is information which the education institutions are publicly disclosing. How did that help? People actually got to know the truth. If the RTI intervention had not revealed what were the actual pass percentages in that particular institution, people would have fallen for the false propaganda that the institution was indulging in order to attract more students. So this is when somebody said, what were the positives about implementing RTI? This is how people have used RTI. Let me tell you, till date, it's been 17 years now, I have not filed a single RTI application related to my personal interests. All the information, I have filed hundreds of RTIs, and in scores of them, I've got the information, I've pulled them out, I've published them, stories have hit the headlines, some of them have gone viral. Not one of them relates to my personal information. Wherever it comes to personal problems with government services, I handle it online. I don't file RTIs. But RTI is, in my opinion, is very important for people who will not be able to find out for themselves. For example, PM Kisan Yojana. How much money has been given to ineligible farmers? I got this story released in January 2021. Until I did the RTI intervention in 2020, everybody thought PM Kisan is a very straightforward scheme. No problem. Everything is digital. Application is digital. Verification is digital. Payment is digital. So there is no corruption. Rajiv Gandhi style. कि 1 रुपया हम बेचते हैं तो 15 पैसा ही लाभार्थी को मिलता है. No such thing. Everything was fine. And then I thought, no. I'm finding stories occasional, from this state, from that state, village level, they are saying eligible farmers are not even enrolled under PM Kisan. A lot of people who are not even farmers are enrolled and they are getting benefits. So I don't know, there must be some gap in this. What exactly is happening? Let us ask. But before filing RTI, I asked some journalists who will report on this. Religiously, who will report Press Information Bureau notices of the government of India whenever PM Kisan achievements are advertised. There is no Venkatesh. It is a very straightforward scheme. No problem at all. पैसा जिनको मिलना चाहिए उन्हीं को मिल रहा है. I was not quiet. I said, नहीं, file करके देख लेते हैं. So I said, give us a list of beneficiaries of who are ineligible. What is the total amount that you have released to ineligible beneficiaries? And you'll be surprised to know. The government actually admitted and said 1,486 crore rupees of PM Kisan benefits have gone to ineligible farmers. They admitted it because they knew that there is a problem. And I made the story public. It went viral. Believe you me, some members of parliament read that story, and in the next budget session of parliament in February, they raised this question. And do you know what the government said? They said the actual figure is not 1,400 crores, it is 2,400 crores. Matter didn't stop there. Last year, 2022, again in the budget session, this question was asked. How much money has gone to ineligible farmers, ineligible beneficiaries? The amount has gone to 3,000 plus crores. Whose money is this? If citizens had not asked this information, MPs would not even have asked this question. This is where RTI is so powerful in not criticizing government. Please don't take it wrongly. It is about holding a mirror to the government and saying, sir, this is feedback from your own records. Please rectify. I don't get paid to file these RTIs. I pay from my own pocket. My savings money is used to pay for the information. And that is not all. I said all these ineligible farmer details, please put this on the website. Because PM Kisan website until then did not have ineligible farmers list village-wise. And believe you me, Appellate Authority actually directed disclosure of this information. They said, yes, this RTI applicant is saying the right thing. This information has to be made public. And they wrote to the National Informatics Center, which maintains the PM Kisan website, saying, henceforth, please disclose this information. And NIC started disclosing the information. Today, village-wise, you will get to know who are the ineligible farmers. What are the numbers? And people have started making use of this information in their village to write to the agriculture department of the state saying, these are the ineligible farmers that you have mentioned. You are still paying them. Please recover the money. Recoveries are going on. This is how the relationship between a citizen and the state gets stronger. And wastage of taxpayers' money is avoided. I'll stop here. Before we take a break, is there anything that Thakkar Saab you would like to add?
Yes, sir. I would just like to take 5 minutes. थोड़ा सा मैं ऐड करना चाहूँगा.
Please बताइए.
Yes, sir. जो questions है regarding this exemptions under RTI Act. So just I would like to give brief some examples. First is there are 10 exemptions in 8.1. That is A, B, C, D, E, F, G, H, I, J, and then section 9. So section 9 relates to the copyright. Section 8.1A relates to information disclosure of which should prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interest of the state, relation with foreign state, or lead to incitement of an offense. So one interesting case was that of Churchgate railway station. So CCTV recording was sought. The CPIO of Indian Railways rejected that, and the CIC upheld that this exemption is right and the decision of CPIO is correct because there were 2611 attacks in Bombay, and therefore CCTV recordings had the only intention of surveillance and it can't be given to public. Another is information 8.1b, that is information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Now, many PIOs are misusing this, just saying that matter is sub judice. So just because matter is sub judice, or just because somebody can go to court, उसकी वजह से इंफॉर्मेशन देने से मना नहीं किया जा सकता. इंफॉर्मेशन तभी देने से मना किया जा सकता when there is stay order or order of court that this information should not be disclosed. Only then it can be say rejected. Otherwise, RTI का intention ही है कि सूचना लेके वो आपके खिलाफ कोर्ट में केस कर सकता है. That is the one of even he can give to press, even he can make representation to the higher authorities, and that's why the act has been enacted. तीसरा जो information disclosure of which would cause breach of privilege of parliament or state legislature. I would just give a hypothetical example that somebody wants to know about budget. So budget details can't be disclosed before it is presented before the parliament or legislature, because that would cause breach of privilege of the House of Parliament. Then we have some other exemption, that is D, information leaking commercial confidence, trade secrets or intellectual property, disclosure of which would harm competitive position of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. Generally, banks reject under 81D and 81E and 81J. One important example I would give, that is hypothetical, that is some student wants question paper of the exam before the exam, then that cannot be given because that would harm the competitive position of the other say interested students who are taking that exam. So that can be rejected under say 81T. E is information available to person in his fiduciary relationship unless competent authority is satisfied that larger public interest warrants the disclosure of such information. So there are some judgments of Supreme Court related to fiduciary information. So say relationship between principal and agent, between say employer and employee, between say guardian and ward, between say doctor and patient, between say client and attorney. So these are some of the fiduciary relationships, and such information can be say denied under section 81E. If his information received in confidence from foreign government, so information received from Switzerland has been denied by the central government that it is received from Switzerland, from Swiss banks, and it can't be given. CIC has ordered, but order of CIC has been challenged. Matter is sub judice before the Supreme Court. So final verdict has not yet come out. As far as G is concerned, information disclosure of which would endanger the life or physical safety of any person or identify source of information or assistance given in confidence for law enforcement or security purposes. There was one case in which one widow made an application to me and gave her information, and then she had asked information about another woman. And that woman's husband asked me that who has asked information about my wife. I invoked section 81G. A complaint was filed against me before Mr. Shatrughan Sinha, Chief Information Commissioner of Uttarakhand, and he upheld that what decision Mr. VM Thakkar has taken is right, and because there is say threat of life to the RTA applicant, therefore this information can't be given. H is information which would impede the process of investigation or apprehension or prosecution of evidence offenders. Generally, police officers deny under 81H, but merely denial is not sufficient, and they should also give a process of investigation or say offenders. As far as I is concerned, cabinet papers including records of deliberations of Council of Ministers, Secretaries and other officers, provided that the decision of the Council of Ministers, the reasons thereof and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. Provided further that those matters which come under the exemption specified in this section shall not be disclosed. I would narrate a very interesting case that is related to Rajdhani Ayog, the capital commission that was formed in say whether the capital of Uttarakhand should be in Dehradun or Gairsand. So in that the chief minister's PIO was fined say there was penalty of 25,000 rupees because this report was tabled before say cabinet, and cabinet had taken a decision that for political reasons it can't be say disclosed because then the party will not get the votes of the people living in the hills. So the Uttarakhand Information Commission, UIC, said that we are not concerned with the politics. The law is that if it has been laid before the parliament and the decision has been taken, then you have to say make that report public. And now the report is publicly available on the website of say many websites on the internet. J is related to personal information. So there is another question related to this, that is say employer-employee service condition termination, etc. So Venkatesh Nayak Saab has already given very good reply, and in fact sir मैंने आपका जो last time FDP था वो भी attend किया था, and you are kind enough to share that compilation of all the High Court judgments with us. So that is very useful to me because I have been entrusted with the task of training about 10,000 officers in the state of Uttarakhand, that is 8,000 PIOs and 2,000 departmental appellate authorities. इसमें कुछ जो कैनरा बैंक वर्सेस CS श्याम वाला केस आपने बताया, that is very good. But इसमें जो 81J के cases है, so there are no binding precedents. Of course, you told that there are say good judgments and bad judgments of say Supreme Court, High Court, and even information commissions. But इसमें what Supreme Court has given is just a taste. So इसका कोई बाइंडिंग प्रेसिडेंस इसमें नहीं होता है. सुप्रीम कोर्ट का वैसे हर जो है वो अपने आप में ही कानून होता है अंडर 143 आर्टिकल, एंड इवन हाई कोर्ट का जो होता है दैट इज बाइंडिंग विद इन द स्टेट. लेकिन एज फार एज द से लिटिगेशन अंडर 81J इज कंसर्न्ड, तो इसमें केवल कोई बाइंडिंग प्रेसिडेंस नहीं होता है. इसमें सिर्फ इतना ही होता है कि पब्लिक इंटरेस्ट आपने साबित कर दिया तो आपको मिल गया, दूसरे ने साबित नहीं किया तो उसको नहीं मिला. सो किसी का भी जजमेंट हो, चाहे वो सुप्रीम कोर्ट का हो, चाहे हाई कोर्ट का हो, चाहे सूचना आयोग का हो, सो इफ इट इज अंडर 81J, then there is no comprehensive list of say what information can be disclosed or cannot be disclosed in such cases. जैसे आपने बताया, how people are even having this say list of say transfer list etc. On WhatsApp, and there is public sharing. So these type of information are public, and there the 81J is actually not say applicable. As far as this 41B is concerned, जो एक और question है कि section 41B can be mandatory implemented by public authority as they are continue avoiding. So 41B में और 41ACD में क्या फर्क है वो हमको समझना पड़ेगा. 41B is binding and the time limit for compliance of that was only 120 days, और वो 120 days हो चुके हैं 2005 में. That means all many public authorities have still not disclosed that. और जो बाकी 3 sections है 41ACD, so these have been left to the resources of the public authorities. और इसके अलावा 42, 43, 44 भी है कि इंटरनेट पर वॉलंटरीली वो डिस्क्लोज करें ताकि किसी को RTI एक्ट के 6(1) में एप्लीकेशन लगाने की जरूरत ही ना पड़े. सो देयर इज एन इंटरेस्टिंग केस बिफोर द सुप्रीम कोर्ट, दैट इज किशन चंद जैन. इनके 2 केसेस है. सो किशन चंद जैन केस में जनवरी 2022 में सुप्रीम कोर्ट हैज इशूड द नोटिसेस टू ऑल द चीफ सेक्रेटरीज ऑफ ऑल स्टेट गवर्नमेंट एज वेल एज पब्लिक और दिस यूनियन टेरिटरीज दैट सेक्शन 41B compliance is very poor, and they have been asked to reply that say कि इसको टाइम बाउंड रिप्लाई करे कि इसमें why they are not complying with section 41B. So this is very interesting case that we need to watch what happens. As far as vacancy say another one is concerned, जो वेबसाइट का है, for example total number of RTIs to an organization in year and what was asked, जो सुजय जॉन का क्वेश्चन है, is the reply of an organization confidential or are they bound to reveal if there is not invasion of privacy. इसमें DOPT का एक सर्कुलर था, डिपार्टमेंट ऑफ पर्सनल एंड ट्रेनिंग, because that is the nodal department for implementation of RTI in under central government. DOPT ने एक सर्कुलर निकाला था कि all public authorities should put on their website all the RTI applications as well as the replies that have been given by them, so that the other people who are interested in finding out the details say need not file an RTI, और RTI में जो एक applicant को जो सूचना दी गई वो दूसरे applicant को डिनाई नहीं की जा सकती, and therefore they should be made public voluntarily. But DOPT के इस सर्कुलर के इम्प्लीमेंटेशन में बाद में प्रॉब्लम आ गई कि that could say harm the say security of the RTI applicant themselves. तो applicant के नाम डिस्क्लोज ना किए जाए, तो इस तरह का बाद में रिस्ट्रिक्शन लगा था. और इसका जो इम्प्लीमेंटेशन है, दैट इम्प्लीमेंटेशन इज वेरी पुअर, बट इट इज अ वेरी नाइस सजेशन बाय CIC. आई फील यदि वो जो इन्फॉर्मेशन ऑलरेडी पब्लिक हो गई तो उसकी स्कैन कॉपी या जो जिस तरह से भी उसको कंप्यूटराइज किया जा सके, because all the say data is first generated on computers and then it is printed. So उस तरह से voluntarily यदि किया जाए so there will be no need of resort to say 6(1), and therefore this is very say practical suggestion. This matter of 41B is before the Supreme Court of India. As far as 41, 42, 43, 44 are concerned and 41ACD are concerned, so that is left to the say resources of the public authorities. So resources है तो वो कर सकते हैं voluntarily, नहीं है तो नहीं कर सकते, but 41B is mandatory. Thank you very much.
Chat box में एक question है about disclosing the total number of RTIs that an organization gets. क्या ये वेबसाइट पे दिखाना जरूरी है कि नहीं? Now the answer is very simple. जो पब्लिक अथॉरिटी होता है अपना संबंधित मिनिस्ट्री या डिपार्टमेंट को हर साल RTI के निपटारे का डेटा भेजते हैं. So how many RTIs came, how many were disposed positively, how many cases rejections were issued, which exemptions were invoked, how much fees was collected, and in how many cases penalty was imposed, how much money was collected by way of penalty. ये सारी जानकारी डिपार्टमेंट को दी जाती है, and department compiles it from all the public authorities under its jurisdiction and sends the report to the information commission concerned. So this is public information already. अगर आप अपने वेबसाइट पे इसको डालना चाहते हैं तो अच्छी बात है. फॉर एग्जाम्पल लोकसभा एंड राज्यसभा दे ऑलवेज डिस्क्लोज एक साल में उनके पास टोटल कितने RTIs आए. सेंट्रल गवर्नमेंट में बहुत सारे ऐसे ये एग्जाम्पल्स हैं पब्लिक अथॉरिटीज के जहां पर टोटल नंबर ऑफ RTIs कितने आए, उनमें से कितनों में जानकारी दी गई, कितनों में जानकारी नहीं दी गई. ऑल ऑफ दिस इज पब्लिक. So you can also do that if you have your own website. There is no problem with that. But replies, What replies are being given? Should an applicant's details, like if they have put in their residential address, telephone number, now these are all subject to confidentiality. So therefore, you may not automatically put them all up, but you might take care. जैसे वो 2013 गाइडलाइंस ने साफ स्पष्ट किया है कि जो पर्सनल इंफॉर्मेशन है उनको काट कर यानी रिडैक्ट करके एडिट आउट करके बाकी जानकारी पब्लिक की जा सकती है. So that is the short answer to your question. Then
ऐसी बहुत सी रिपोर्ट्स भी अवेलेबल है. सेक्शन 25 की जो रिपोर्ट्स है, so these are available, जो which reports have to be given to the parliament or the assemblies under section 25. So these reports are normally found on the websites of the concerned information commissions. But the problem is sometimes the reports, yes, but sometimes these reports are not public, sometimes they are not complete, and sometimes they are not even tabled before the House of Parliament. So implementation of section 25
is a problem. आज तक उत्तर प्रदेश ने सरकार ने एक भी एनुअल रिपोर्ट अपना पब्लिक नहीं किया है, बट इंफॉर्मेशन कमीशन आई थिंक 2 years ago पुट आउट अ रिपोर्ट अबाउट इट्स ओन वर्क.
उत्तराखंड में तो है सर 4-5, यस सर, हमारे पास 4-5 पिछले 4-5 साल की रिपोर्ट वेबसाइट पर है सर. उत्तराखंड में तो
उत्तराखंड का है. उत्तराखंड started off a good practice when Dr. Tolia was the state
chief. Yes, he was the first CIC. Yes.
और फिर बाद में डॉक्टर नपलचियाल आए तो उन्होंने भी अच्छा काम किया. शत्रुघ्न सिन्हा साहब के समय में भी थोड़ा बहुत ठीक हुआ. उसके बाद से देयर आर प्रॉब्लम्स, बट उत्तराखंड हैज डन वन थिंग. उत्तराखंड के वेबसाइट में एज आई चेक लास्ट ईयर ऑन अ डे टू डे बेसिस आरटीआई कितने आए, एप्लीकेशंस, कमीशन में कितने अपील्स आए, कंप्लेंट्स आए, ये डेटा अपडेट होता है.
और सर और एक बात है कि जो 41B के हमारे मैनुअल्स है सर, thousands of manuals are hosted by the UIC website कि जिनके पास अपनी वेबसाइट है या नहीं है, so they are even hosting and they are even assisting the appellate authorities and say public authorities and PIOs for preparing those manuals under 41B. So hundreds and thousands of these are available on
पहला 41B का मैनुअल उत्तराखंड सरकार के हकदारी और देनदारी विभाग ने तैयार किया था.
Yes, it is very good. Yes.
और उसको देखकर हिंदी में था. So we said, can we please borrow a copy of this because this is a model for the whole country.
मैंने तो पूरा प्रिंट किया था.
And the central government used that as a model to say that look, this department has done it, others should also follow. उन्होंने TCS को consultancy देकर वो manual बनवाया था. So there are lots of these examples. Uttarakhand is one of the first states. I remember जुलाई-अगस्त 2005 में हम लोगों ने 2 सेशंस किए थे. 105 ट्रेनिंग ऑफ ट्रेनर्स, ट्रेनर्स ने, मास्टर ट्रेनर्स ने तैयार किए थे आरटीआई में. काफी लंबा चौड़ा वहां पे ट्रेनिंग डिस्कशन वगैरह हुए. दैट इज वेयर वी गॉट अवर अंडरस्टैंडिंग ऑफ आरटीआई आल्सो डीपन्ड. इट इज वन थिंग टू बी आउटसाइड गवर्नमेंट एंड से ये कानून में ये होना चाहिए. गवर्नमेंट के अंदर बैठकर सोचना और सवाल करना कि इसका इंप्लीमेंटेशन होगा कैसे. दैट इज समथिंग दैट वी लर्नड देयर. एंड तैयारी इतनी थी. ऑन द 12th of October 2005 पब्लिक इंफॉर्मेशन ऑफिसर्स जिन सबको ट्रेनिंग हुई थी इंतजार करते रहे कि पहला आरटीआई एप्लीकेशन आएगा हमारे पास. कोई नहीं आया. अगले दिन वेट किया, कोई नहीं आया. तकरीबन 2-3 हफ्ते तो कोई आरटीआई आया ही नहीं ज्यादातर दफ्तरों में. तो सबने पूछने लगे कि इतनी तैयारी करने की जरूरत क्या थी. दैट इज व्हेन वी लर्नड आवर लेसन. इट इज नॉट इनफ टू फोकस ऑन ट्रेनिंग द सप्लाई साइड, वी आल्सो हैव टू ट्रेन द डिमांड साइड, स्पेशली इन स्टेट्स वेयर देयर इज नो पीपल्स मूवमेंट फॉर ट्रांसपेरेंसी. जैसे राजस्थान में था, मध्य प्रदेश में था, महाराष्ट्र में था, तमिलनाडु में, गोवा में, कर्नाटका में, असम में, जम्मू कश्मीर में. वैसे उत्तराखंड में किया नहीं था. So therefore we started focusing more on civil society and media training programs, community level training programs. तब जाके RTIs गांव-गांव से आने लगे. आज की तारीख में तो देश भर में हजारों की संख्या में मास्टर ट्रेनर्स हैं for civil society and government, and because of which its estimates show कि every hour between 13,500 to 15,000 RTI applications are filed across the country. Every hour about 600 to 650 RTIs. और हर साल में कम से कम 50 से 60 लाख RTI applications देश के अलग अलग पब्लिक अथॉरिटीज के पास जाते हैं. This is a huge number for any country in the world. किसी भी अन्य देश में तकरीबन 134-135 देश ऐसे, अभी 138 बन गए होंगे, 138 countries that have passed RTI laws. Some of them are very old, like somebody said Sweden. USA is also from 1966. इन देशों में इतनी भारी संख्या में आरटीआई का इस्तेमाल नहीं होता. इट्स अ बिग प्लस पॉइंट फॉर अ डेमोक्रेसी. कोविड के जमाने में भी 2020 का डेटा हमने निकाला इंफॉर्मेशन कमीशन सेंट्रल के रिपोर्ट से. The fall in the number of RTIs that went to central government in the first year of COVID was less than 3%. People were expecting कि 50% तो गिरे ही, शायद गिर गया होगा, इतने RTIs लगे ही नहीं. बहुत सारे RTIs आए कोविड के जमाने में भी. Now we are waiting to see कि सेकेंड ईयर ऑफ कोविड में कितने RTIs फाइल हुए सेंट्रल गवर्नमेंट में. स्टेट गवर्नमेंट्स में इतना डेटा कलेक्शन पक्का सिस्टम्स नहीं बने हैं. एक आध स्टेट गवर्नमेंट्स पब्लिश करते हैं अपने रिपोर्ट टाइमली. महाराष्ट्र में भी आजकल एनुअल रिपोर्ट आना बंद हो गया. After central government, Maharashtra used to be at number 2 in terms of total number of RTIs filed across the country. Karnataka used to be number 3. ना महाराष्ट्र का एनुअल रिपोर्ट है, ना कर्नाटका का एनुअल रिपोर्ट है. 4-5 साल से आया नहीं. सेंट्रल गवर्नमेंट थोड़ा बहुत डिले करता है, बट यू गेट टू नो कि 1 साल पहले का डेटा कितना होता है. सो दिस इज वेयर मैटर्स आर.
यस सर, हमने लगभग 72 ट्रेनिंग प्रोग्राम्स किए. हमने दोनों टाइप के किए. वी हैव डन फॉर पब्लिक आल्सो. जनरल पब्लिक के लिए तो 2 घंटे के प्रोग्राम्स होते हैं, विच आर अंडर सेक्शन 6, 7, 18, 19 के बारे में उनको ज्यादा बताना होता है. एंड फॉर ऑफिसर्स वी हैव अंडरटेकन 72 प्रोग्राम्स. पेंडेमिक के पहले बहुत हुए 2019-20 में. और ये we have trained about 4,500 officers in those different training programs. So as far as this awareness is concerned, so ये awareness public में भी बढ़ रही है. Sir, final, I have one question for you. May I ask you, sir?
Yeah, please go ahead.
Sir, what is your opinion about this DPDP, Digital Personal Data Protection Bill 2022, and this amendment
टॉपिक बिल्कुल अलग है.
suggested to
शॉर्ट
be
में अगर
very
बताया जाए,
controversial provision.
शॉर्ट में बताई जाए, इट विल किल द
हाँ.
आरटीआई एक्ट. इसको अपोज करना जरूरी है. देयर इज नो रैशनल जस्टिफिकेशन. इट हैज टू बी, द एक्ट शुड बी allowed to remain intact, जैसे जस्टिस शाह कमेटी ने बोला था 2014 में या 2012 में.
आज मेरा भी एक न्यूज आइटम आया है जिसमें कई अखबारों में हेडलाइंस में आया है, जो कल मैंने संडे को आरटीआई मीटिंग में मैंने रेवा मध्य प्रदेश से जो होस्ट होती है, तो जस्टिस BN श्री कृष्ण कमेटी जो है, जो सुप्रीम कोर्ट के रिटायर्ड चीफ जस्टिस थे, उन्होंने अपने जो पहला ड्राफ्ट है जो पर्सनल डाटा प्रोटेक्शन बिल 2018, उसमें इस तरह का कोई भी संशोधन सजेस्ट नहीं किया आरटीआई.
सजेस्ट किया था.
देन देयर वाज जेपी, उसके बाद फिर जेपीसी बिल है. जेपीसी बिल में जो जॉइंट पार्लियामेंट्री कमेटी बनी थी लोकसभा और राज्यसभा की, उसमें भी किसी भी एमपी ने इस तरह का चेंज सजेस्ट नहीं किया. और जो 2019 का जो बिल था उसमें भी इस तरह की कोई बात नहीं थी. और फिर ये जो नया बिल आया है, विच इज जस्ट से स्मॉल, जो 30 क्लॉज का बिल है, इसमें जो 29, 2 और 30 है, इसको पूरे इंडिया से जो आरटीआई कार्यकर्ताओं का बहुत ज्यादा विरोध हो रहा है. और एक अचानक ये कैसे ड्राफ्ट आ गया कि they have completely ignored this report, say recommendation of Justice BN Sri Krishna committee as well as this say JPC committee. ये समझ में नहीं आ रहा है कि किस तरह से ये चीज हो गया. And I hope that say the government would say withdraw that, I mean that एक provision कम से कम हटा लेंगे before this bill is tabled before the parliament in February 2023. Thank you, sir.
ये जस्टिस श्री कृष्णा कमेटी ने भी रेकमेंड किया था 81G को अमेंड करने के लिए. उन्होंने उसमें कुछ और
थोड़ा सा अमेंडमेंट था, बट हाँ, यस, थोड़ा सा अमेंडमेंट था, बट इट वाज नॉट एज ड्रास्टिक एज, मतलब अभी तो बिल्कुल डिस्ट्रक्टिव
उसके भी
कर
आगे
दिया.
निकल, उसके भी आगे निकल गया. जस्टिस शाह कमेटी वाज द ओनली वन व्हिच सेड डोंट टच आरटीआई. उसमें जो जानकारी दी जाएगी वो बरकरार रहनी चाहिए. अनफॉर्चुनेटली गवर्नमेंट ऑफ द डे डज नॉट वांट टू डू दैट, बिकॉज अब लोग पूछते हैं प्रधानमंत्री जी के डिग्री सर्टिफिकेट की कॉपी हमें दीजिए. आप डॉक्टर के दफ्तर में जाएंगे, क्लिनिक में जाएंगे, इंजीनियर के पास जाएंगे, तो सबके डिग्री सर्टिफिकेट बहुत फक्र से वो लोग फ्रेम करके अपने दीवार पे टांगते हैं. यहाँ पर एफिडेविट में इन्होंने मेंशन कर दिया बीए है और एमए पॉलिटिकल साइंस है, लेकिन लोग जब डिग्री सर्टिफिकेट मांगने लगे तो गुस्सा हो गए. सो दैट इज वेयर द प्रॉब्लम अराइजेस. 81J का जो संशोधन का सिलसिला चला आ रहा है, इट्स फ्रॉम दोस टाइम्स एंड दैट्स द मोस्ट अनफॉर्चुनेट. होना नहीं चाहिए. अरे what is the problem if somebody does not have a graduate or a postgraduate degree? That does not disqualify them from becoming a candidate in the elections, getting elected to parliament and occupying the highest office in this country. It is not a disqualification.
Yes, obviously, sir.
It is not. डिग्री है तो बोलिए है, अगर नहीं है तो बोलिए नहीं है. जिंदगी की जो तालीम है, अनुभव है, वो केवल यूनिवर्सिटी से हासिल नहीं होती है.
हाँ जी, मिनिस्टर होने के लिए कोई चीज जरूरी नहीं है.
बिल्कुल. Our honorable prime minister is probably one of the most intelligent and one of the most क्या कहते हैं clever strategists in the country. जिस तरह से उन्होंने ये इंदिरा गांधी जी के बाद जो पब्लिक कैरिज्मा वाला लीडर जो है ये पहली बार आए, दैट इज इनफ। ये डिग्री वाले चक्कर में क्यों पड़ गए समझ में नहीं आता, और इसमें आरटीआई जो है इसमें मुश्किल में पड़ गया। इसमें
Yes, sir.
this
Okay.
is the unfortunate part.
Yes, sir.
Anyway, so shall we
Thank
take a
you.
break
Thank you,
now
sir.
because it's 6 o'clock. I think I've been speaking for too long continuously. 5 minute का break ले सकते हैं क्या? And then we come back for the rest of the session, the next topic.
Sure, sir. Yes, sir.
By requesting everybody, please, session खत्म नहीं हुआ है. We are only taking a short break क्योंकि मुझे और अभी आधा पौना घंटा बोलना पड़ेगा. So please stay on, come back, and we will take the next part of the session, which is implementation of RTI Act, dilemmas or roadmap for the future. So this is what we will deal with. So it is about 6 o'clock now. 6:05 पे फिर से session को restart करते हैं. Okay. So please stay back. Don't leave. Okay, so shall we resume? इजाजत हो तो शुरू करें हम लोग.
Yes, sir.
Okay, so welcome back, ladies and gentlemen. अभी हमारे पास जो 1 घंटे का समय बचा है, so we will use that for discussing the second thematic. Implementation of RTA Act, what are the dilemmas and what is the roadmap for the future? Okay, so now let me count the dilemmas one by one. The first dilemma is a philosophical dilemma. And what is a philosophical dilemma? This is something that many RTA activists will not tell you. But apart from being an RTA activist, I also happen to be from an academic background. तो हम लोगों की तालीम जवाहरलाल नेहरू यूनिवर्सिटी में, जो आजकल बहुत चर्चित है और कुछ नाम भी उसके साथ जोड़ा जाता है, किस तरह का यूनिवर्सिटी है करके, बट एनीवे दैट अपार्ट, लेकिन हम लोगों की तालीम ऐसी भी रही है कि हम लोग थोड़ा सा अपने आप को मैदान से हटकर, पीछे हटकर एक पुनरावलोकन करने के लिए, निरीक्षण करने के लिए हम लोगों की ट्रेनिंग होती है. तो पिछले 17 साल के आरटीआई का जो जर्नी रही है, इसका जो सफर रहा है, इसको हम पीछे मुड़कर अगर देखें तो द फिलोसॉफिकल डायलेमा, देयर आर एटलीस्ट 2 or 3 of them, and that is something that is central to the nature and quality of our democracy. Now, what is that? When I do trainings for people at the civil society level or at the community level, I start with the understanding of the fundamental right to know, जो 1975 से लेकर सुप्रीम कोर्ट ने कई सारे अपने जजमेंट्स में बोला है कि डेमोक्रेसी होने के नाते इन्फॉर्म्ड सिटीजनरी का होना जरूरी है, और वो इन्फॉर्म्ड सिटीजनरी राइट टू नो के बिना बनेगा नहीं. So when I ask people, why do you think there should be a law that actually requires you to get the information that you want? आसानी से क्यों नहीं मिलता? उसका जवाब तो सीधा सीधा दे देते हैं, मांगते हैं लेकिन मिलता नहीं है. अब कम से कम कानून तो आ गया, जानकारी नहीं देंगे तो पेनल्टी पड़ेगा. So then I ask them, okay, fine. Every 5 years, you cast your vote in the elections. You elect your MPs and MLAs and MLCs. MLCs are directly elected. Legislative Council 6 राज्यों में है, 5-6 राज्यों में. You also elect your municipal councillors. You elect people at the Gram Panchayat level, Taluka Panchayat or Mandal Panchayat level, and at the Zilla Parishad level. They are all duty bound to work in your best interests. You pay taxes. They issue a budget. हर लेवल के बजट होते हैं, सेंट्रल लेवल के, स्टेट लेवल के, डिस्ट्रिक्ट लेवल के, पंचायत लेवल के, ग्राम पंचायत के भी बजट होते हैं. पैसा वो खर्च कर रहे हैं, डेवलपमेंट वर्क्स हो रहे हैं. सरकार की अपने डिपार्टमेंट्स हैं, डिपार्टमेंट ऑफ पब्लिक रिलेशंस एंड इंफॉर्मेशन, DIPR कुछ जगह बोलते हैं, इंफॉर्मेशन पब्लिक रिलेशंस. व्हाई डू यू वांट अ सेपरेट थिंग कॉल्ड RTI? You will be surprised to know, and sometimes I get this response even from government officials when I do trainings for them. They say, but we want to know what exactly is the government doing with our money. We don't trust them. वो बोलते कुछ है, करते कुछ. A lot of people think like this. And when I do training of trainers, I ask them, if the basis on which you want a law like right to information is suspicion about what the government is doing, can that be a long-lasting justification for a law of this kind? शक की बुनियाद पर क्या कोई कानून टिक पाता है कि नहीं? दांडिक प्रक्रिया अधिनियम तो टिक जाता है, that's a different matter. Criminal Procedure Code, it is based on suspicion. I mean, how do you know that somebody has committed a crime? There is a complaint or there is some circumstantial evidence, and then police has to investigate it and then prove the guilt of the accused person in court. That's a different way. The way suspicion is the basis, unless there is the police are themselves witness to the crime. Otherwise, it is other eyewitnesses who will come forward to prove the case successfully or unsuccessfully. That's a different matter. But why RTI? इसमें suspicion की क्या basis है? No, it's our money. We need to know. So the first philosophical dilemma that comes out of this kind of interaction is that RTI has come in at a time and in order to plug what is called a gap in the trust deficit between citizenry and the government. And this is a major factor which must be taken into consideration while planning implementation of the RTI Act. Unfortunately, no government, whether UPA which brought in this law or the NDA which has inherited this law or any of the state parties which are in power at the states have recognized this. For them, RTI is a tool so long as they are in the opposition. Har state mein kiya. The whole India Against Corruption movement led by Anna Hazare ji and Arvind Kejriwal ji and Prashant Bhushan ji, what was that all about? That was about trust deficit in the government of the day. Corrupt hai aap, और आपके existing anti corruption mechanisms काम नहीं कर रहे हैं, हमें लोकपाल जैसी institution चाहिए. आज हाँ लोकपाल का क्या हाल है वो, that's a different topic for discussion. We'll not get into that. So the trust deficit is the major philosophical dilemma that every government will face, not just in India, but in many other countries in the world. And you can actually see that happening internationally. We don't have the time to go into that, but from 1945, when the Second World War ended, up to the year 1980, there were barely 6 or 7 countries in the world which had right to information laws. 1980s ke baad, especially after the fall of the Berlin Wall, 1989 ke baad, ek ke baad ek, countries start implementing RTI laws. And why so? Because those countries are witness to popular movements that forced a regime change. Soviet bloc के disappearance के बाद ईस्टर्न यूरोप में नए संविधान बने, नए कानून बने, नई सरकार बनी. उनमें से एक कानून था राइट टू इंफॉर्मेशन लॉ. क्यों? Academics have researched and explained this, that people would not trust their government to act in their best interests anymore. They had never acted ever since they came under the Soviet regime. कम्युनिस्ट ब्लॉक के जब तक हिस्से थे, बेटा बाप के ऊपर जासूसी करता था, वाइफ हस्बैंड के ऊपर जासूसी करती थी और एस्पियोनेज डिपार्टमेंट को बताती थी. Entire files on how families spied on each other were thrown open to the public. Huge amount of trust deficit, and that continues even today. One after the other countries, 138 countries, like I said, have passed right to information laws. In many of those countries, the major argument that is given in favor of passing a law that guarantees the right to seek and obtain information is to say that we do not trust the government at face value. We have to be able to ask information that the government does not disclose to us voluntarily. If this trust deficit is not bridged through political means, implementing RTI will not be successful. Why? Why do I say that? The reason why I say that is in the response of public information officers. 3 out of 5, every 5 public information officers, कम से कम 2 से 3 लोग यही बोलते हैं, सर ये RTI हर तरह के लोग फाइल करते हैं, इसका मिसयूज करते हैं, अखबारों में उसको काट छाट के हमारे सरकार के खिलाफ रिपोर्ट छाप देते हैं. So there is a trust deficit at that level also, that people will not make use of the RTI information in a positive way. This deficit, this gap has to be bridged if RTI has to become successful. And in countries like Sweden, for a long time, that gap had been bridged. Today, again, that gap is widening. There was a time when in Sweden, even today it continues, कैबिनेट मीटिंग होने के आधे घंटे के अंदर कैबिनेट ऑफिस के पब्लिकली एक्सेसिबल स्पेस जहां पर जर्नलिस्ट को आने की इजाजत है, वहां पर जर्नलिस्ट को पढ़ने के लिए कैबिनेट का डिसीजन और उसका बेसिक मटेरियल्स पब्लिक किए जाते थे. दैट वाज एक्सटेंट टू विच उनको. हमारे यहाँ आई एम स्टिल फाइटिंग टू गेट द कैबिनेट नोट रिलेटिंग टू द इकोनॉमिकली वीकर सेक्शंस कोटा ऑफ 10%. Central Information Commission said this information must be disclosed. Public Information Officer gave me access to the document electronically through Gmail, लेकिन Google Drive का पासवर्ड उन्होंने खोला नहीं मुझे एक्सेस करने के लिए. So technically speaking, I have access to information, I can't read it. Trust deficit. This is the first dilemma that has to be bridged. Citizens also have to put in the effort. The political elite also have to put in the effort. You would be very surprised to hear me saying this. कुछ साल पहले लोकसभा में चर्चा हुई आरटीआई के ऊपर. It was not slotted topic. कोई नोटिस नहीं दी गई थी, अचानक से आ गया 0 आवर में. तो एक उत्तर प्रदेश के पार्टी के एक नेता हैं, लोकसभा सदस्य, उन्होंने बोला, अरे आजकल तो एक टांगे वाला भी आरटीआई में 10 रुपए डालकर हमारे देश के जो रॉकेट उड़ाने हैं उसके बारे में जानकारी मांगना शुरू किया है. He was very sarcastic. And instead of being critical of his speech, the rest of the members who were sitting, men and women sitting there, people you and I elected, laughed at what he was saying, approving. But that is not where the story ends. When this discussion was going on, Honorable Prime Minister entered the floor of the House. And he sat there, and after the discussion was over, do you know what he announced? He said, I'm sorry, I came in a little late into the House today. But prior to this, I was at the ceremony where through Sriharikota, ISRO launched a SARC satellite. A satellite that is meant to provide services to all 7 SARC countries. पैसा किसने दिया? गवर्नमेंट ऑफ इंडिया ने. गवर्नमेंट ऑफ इंडिया के पास वो पैसे आए कहां से? नागरिकों से. उस झटके वाले ने, टांगे वाले ने जो टैक्स दिया, चावल खरीदते समय, मैच बॉक्स खरीदते समय, नमक खरीदते समय, उस जमाने में तो वैट था, जीएसटी नहीं था, उसका पैसा था उस सार्क सैटेलाइट के बनाने के खर्चे में जो लगे. उसको अधिकार नहीं पूछने के लिए. इंजीनियर नहीं है, इसलिए वो क्यों ये सवाल करेगा? सो दिस इज द मेंटालिटी. और ये अभी भी अंग्रेजों के राज के जमाने का मेंटालिटी है कि हम यहां पर है माई बाप सरकार, नागरिक हमारे सामने हाथ फैलाए, उंगली सामने करके हमसे सवाल ना करें. This is the second philosophical dilemma, which is the relationship between citizen and the state agencies. This is not on a footing of equality. We are still treated as subjects, and government thinks it is the ruler. Ruler is a very wrong term. They are the government, they are governing. We are not subjects, we are the people who are governed. The preamble of the RTI gets it right. It says purpose of RTI is to make government and its instrumentalities accountable to the governed, not to the subjects. That is a relationship that needs to be understood. If this relationship is not understood, invariably every RTI will be treated by public information officers as an RTI that is coming from a waste fellow, from a busybody. जिसको और कोई काम नहीं है करने के लिए. इम्प्लीमेंटेशन में प्रॉब्लम आता है. इतनी सारी जानकारी हम पब्लिक डोमेन में क्यों डालें? That is a frequent question that has come. Nobody uses it. Arey, how do you know? People may not have a use for it every day. Like they would go to a cinema hall, or like they would watch a program on their mobile phone, a popular TV soap program. But they will have use for it at some point of time or the other. And it does have empowering effect. There are several such examples where information has had an empowering effect on people. I was in this remote corner of Arunachal Pradesh called Lohit district in the year 2001. RTI कुछ था नहीं उस जमाने में, और अरुणाचल प्रदेश ने कोई स्टेट एक्ट भी पास नहीं किया था. एक जगह मैं गया था, वहां पर पहाड़ी क्षेत्र है जहां पर संतरे, इलायची, वो सांबार वाली इलायची होती है ना, छोटी वाली नहीं, बड़ी वाली, जो खाने में इस्तेमाल होता है, मिठाई में नहीं लेकिन कुकिंग में इस्तेमाल होता है, ये आपके सब्जी वगैरह बनाने में, बड़ी वाली इलायची, उसकी खेती होती है वहां पर. और अदरक की खेती होती है. संतरा, अदरक और बड़ी इलायची. सो वहां पर मैं एक स्कूल में गया, वाकरो करके उस गांव का नाम है. छोटा सा स्कूल है, जैसे मैं अपने प्राइमरी स्कूल जहां पे मैं पढ़ा था बिल्कुल उसी तरह का वो दिखता था. बच्चे भी वही काम करते हैं. हम लोग गार्डन में बहुत काम करते थे वहां पर एज पार्ट ऑफ आवर क्राफ्ट्स पीरियड. तो वहां बच्चे भी अपना बगीचा वगैरह बनाते थे. आई वेंट देयर एट दैट पॉइंट ऑफ टाइम and then I talked to the headmaster and everybody and asked how is the school functioning as part of a UN project. And then they told me that, sir, please also visit this community service center which is right next door on the other side of the road. School के बिल्कुल opposite side पे. मैंने कहा क्या खास बात है कम्युनिटी सेंटर सर्विस सेंटर में? कि सर वहां पे इंटरनेट कनेक्शन है और इंटरनेट से हमारे जो गांव के रहने वाले लोग हैं इंटरनेट को एक्सेस करते हैं. So they said, sir, most of our residents in the village are farmers. They grow this santra, ilaichi, and adrak. We don't get a good price here. हमारे commodities के लिए अच्छा market का भाव नहीं मिलता यहाँ पे. So हमें internet से वो मिल जाता है. I said how? कैसे पता है आपको? और आप तो कहते हैं कि यहाँ के ज्यादातर farmers जो हैं वो पढ़े लिखे नहीं है. I said no. वो सारे जो अनपढ़ किसान है ना, उन सबके बच्चे यहाँ पर स्कूल में पढ़ते हैं. तो जब इनकी फसल तैयार होती है रवाना के लिए, they come down from the hills from their कुछ जगह 4 घंटे का रास्ता है, कुछ जगह 2 दिनों का रास्ता है. मोटरेबल रोड्स है नहीं. So they come to the village, sorry, they come to the school, they pick up the child, they go to the community service center because they have a right to access the internet terminal there. और जो टाइम स्लॉट उनको मिलता है वहां पे जाके एक्सेस करके देखते हैं कि देश भर में मार्केटों में संतरे का भाव कहाँ पे ज्यादा है, अदरक का भाव कहाँ पे ज्यादा है, बड़ी इलायची का भाव कहाँ पे ज्यादा है, and they ship their products to those places. So I heard कि अरुणाचल प्रदेश में उगाए गए संतरे they reach within 2 weeks the market in Gujarat. Literally imagine अरुणाचल प्रदेश कौन से कोने में है और गुजरात कौन से कोने में. Now that is where deployment of information technology can actually help people in a very useful and practical manner. This is an example of that. Government has provided this information. The share price, sorry, the mandi, e-mandi करके जो है system, आज की तारीख में e-mandi बोलते हैं, उस जमाने में कुछ और नाम था उसका. That is what government has set up, made it accessible to farmers who are unlettered through community service centers, and the children are there to help their relatives access this information. Now, this is where a positively inclined system based on positivity can actually work wonders. Why should this farmer sell at a much lesser price in Arunachal Pradesh when he can ship it to Gujarat for a much higher price and lead a better life through higher income? It is not just information technology that is helping out. It is information technology that is providing access to information जहाँ पे RTI डालने की जरूरत नहीं पड़ेगी. This is the implementation roadmap that we should have. जैसे आईने के सामने खड़े होकर हम अपना अक्स देखते हैं. We see our reflection in front of the mirror. We don't have to press a button on the mirror to see our reflection. The moment we go and stand there, we are able to see ourselves. Access to information contained in government files should become accessible to people in such a manner. Least difficulty, maximum convenience. That is what is called maximum governance with minimum government. That is the direction in which we need to go. It must be pointed out in training programs, and I'm sure Thakkar Saab would be pointing out in his training programs, that it is in the government's interest to be more transparent. The more it hides the information, the more suspicions will grow. हाँ, कुछ तो कला है, इसलिए तो जानकारी नहीं पब्लिक कर रहे. So therefore, make more and more information public. लोग information का इस्तेमाल कर रहे हैं blackmail करने के लिए. I hear a lot of those complaints. Blackmail तभी हो सकता है जब information is between public information officer and that one person who is RTI applicant. उसको public कर दो, notice board पे डाल दो, website पे डाल दो. एक से ज्यादा लोगों के पास जाएगा. एक आदमी के आके कैसे blackmail कर सकता है? कर ही नहीं सकता. So one needs to think in a much more positive and innovative manner to realize the full potential of RTI. That is the implementation program. And this is where information commissions have to play a very major role. Unfortunately, that is not happening in India for multiple reasons. First problem is systemic problem. Why? Our information commissions do not have any suo motu powers under the RTI Act. बांग्लादेश में देखेंगे information commission का suo motu powers है. श्रीलंका में देखेंगे suo motu powers है. पाकिस्तान में देखेंगे नेशनल लेवल लॉ पे suo motu powers है. नेपाल में देखेंगे suo motu powers है. They can take action on their own. हमारे RTI कानून के तहत information commissions will act only when moved through an appeal, that is second appeal or a complaint. suo motu powers है ही नहीं. यूके में है suo motu powers, स्कॉटलैंड में है, न्यूजीलैंड में है, ऑस्ट्रेलिया में है. बड़े बड़े देशों का अगर मैं उदाहरण दूं तो, लेकिन अफ्रीका जैसे देशों में भी RTI कानून में, घाना में है, किनिया में है, RTI कानून में कमीशन को suo motu powers दिए गए हैं. हमारे कमीशन को भी suo motu powers देना जरूरी है, so that they can start working with government departments and public authorities in a suo motu manner rather than only when an appeal comes to them. You have to promote transparency. That is not happening. Because of which, what is the problem that is occurring? The problem that is occurring is this has become an adversarial intervention. टक्कर वाली वार्तालाप. मैं जानकारी मांग रहा हूं, यानी मेरे इरादे के ऊपर सवाल प्रश्नार्थक चिन्ह, सवालिया चिन्ह उठाए जाएंगे. जानकारी नहीं दी जाएगी आसानी से, क्योंकि जैसे मैंने पिछले सत्र में बोला, lots of methods used for not giving access to information. तो मेरे मन में सवालिया चिन्ह उठेंगे about the objectives and the intention of the public information officer. So ये हो गई adversarial. This is exactly what gets carried to the Information Commission's hearings, adversarial proceedings. This is not what RTI was meant to do. The reason why presence of lawyers is not encouraged in Information Commission says that these are not adversarial proceedings. But today, lawyers come to assess the Supreme Court's PIO in the Information Commission. I have argued against them while supporting some of my friends in their cases. In some cases we won, in some cases we lost. Why? This is supposed to be a dispute resolution mechanism, not like a court. And still, and I'm sorry, now I'm going to give the example of Uttarakhand. I was in Uttarakhand in the Information Commission in 2019, and I saw the manner in which hearings were conducted. Commissioners are sitting on a pedestal, ऊपर वाले platform पे, public information officer and the appellant are standing. They are not even sitting. बैठने के लिए वहां पर कुर्सी है नहीं, कुर्सी है सिटिंग रूम में पीछे की तरफ, खड़े हैं और डेस्क के ऊपर my lord करके आर्ग्यूमेंट कर रहे हैं. This is not what commissions are supposed to do. Information commissions are not courts. This is not realized. Look at the Central Information Commission, a very good example. Even Karnataka Information Commission. हालांकि बहुत सारे प्रॉब्लम्स हैं वहां पर, लेकिन कम से कम बैठने के लिए वहां पर इजाजत है. यूपी में भी मैं गया था टू आर्ग्यू वन ऑफ माय केसेस. खड़े होकर आर्ग्यू करना पड़ेगा. अरे इफ यू आर नॉट गोइंग टू अफोर्ड इवन अ चेयर टू द पब्लिक इंफॉर्मेशन ऑफिसर और टू द appellant inside the room where the matter is being decided, that shows the power dynamic. That is not what RTI is meant to be. This has to change. And I'll give an example of how power dynamic can be removed from the equation. I had filed an RTI with the Department of Economic Affairs about some matter. PIO refused. I filed a first appeal. Normally, first appeals are decided without hearing the appellant. But this appellate authority called me for the hearing, gave me advance notice well in advance. I went for the hearing. Very politely, he was a joint secretary grade officer. He offered me a chair and said, please sit down. And then he said, okay, you can tell me about your case. I explained my case. Then he explained why the information he thinks should not be given. And then, believe it or not, he actually recorded what he said and he recorded what I said in the hearing on the file himself. And then he showed me the file and said, please read this. If you're satisfied, let us both sign it. First and only time when I've actually signed a file noting sheet in a government file. And frankly speaking, it was not just the cordiality of the atmosphere, it was also the convincing nature of the argument that the joint secretary gave me. Why the information should not be disclosed. He did not wholesale reject it. Some parts he gave, some parts he said, these are the reasons why this information can't be given. Believe me, I did not go and file a second appeal. I was so satisfied. Reasons were absolutely on point. I realized that जो जानकारी मैं मांग रहा हूं, अभी मुझे समझ में आ गया है कि इसके पब्लिक होने से पब्लिक इंटरेस्ट को कैसे नुकसान पहुंचेगा. Competitors will make use of that information against the people whose information I'm seeking. I was convinced. Very true. And the manner in which the hearing was conducted, absolutely citizen-friendly manner. If this were to become the norm in all interactions between appellate authorities and citizens, PIOs and citizens, information commissioners and citizens, RTI Act can go a million steps ahead in terms of making our government more transparent. Next problem. So motor disclosure. Section 4(1)(b). Section 4(1)(b) की जानकारी पब्लिक करना जरूरी है. सुप्रीम कोर्ट ने भी बोला है मैंडेटरी है. बट व्हाट इज द डायलेमा? डायलेमा इज सिंपली दिस, एंड ये सेंट्रल इंफॉर्मेशन कमीशन ने सबसे बेहतर तरीके में अपने डिसीजन एक में डाल दिया कि ये सेक्शन 4(1)B की जिम्मेदारी किसकी है इंप्लीमेंटेशन करवाने की, हमें पता नहीं, हमारे पास तो है नहीं। हम केवल अपील में मामले का निपटारा कर सकते हैं, ये डिपार्टमेंट को करना पड़ेगा, which is Department of Personnel and Training. Hearing may Department of Personnel and Training came and said, sorry, this is not our responsibility. The section 4(1) says every public authority shall. So it is the responsibility of every public authority. So who is going to monitor? Till date, it has not been decided. We have, worked to make guidelines after guidelines. 2013 में 2 बार guidelines निकले, एक अप्रैल में निकला, एक नवंबर में निकला, 2016 में निकले। आजकल सेंट्रल गवर्नमेंट के पब्लिक अथॉरिटीज का सेक्शन 4(1)B ट्रांसपेरेंसी ऑडिट भी हो रहा है। कुछ लोग अपने आप को अच्छे नंबर देते हैं, कुछ लोग कम नंबर देते हैं, और वो छप जाता है सेंट्रल इंफॉर्मेशन कमीशन के रिपोर्ट के माध्यम से। बट you still have 12 to 13 lakh RTIs being filed in the central government every year. Technically speaking, what should happen when the government moves progressively towards implementing RTI in a voluntary manner? Number of RTI applications should come down, right? People should have no need for asking for information formally. That is exactly what is said in section 4(2). It says every public authority shall put so much information out in the public domain that public will have minimum resort to the use of this act. कम से कम इस्तेमाल हो नहीं रहा, हर साल आरटीआई एप्लीकेशन की तादाद बढ़ रही है। स्टेट्स में भी बढ़ता रहता है, घटता रहता है, लेकिन इतना बड़ा फर्क नहीं आ रहा। So what we have today is RTI has become a request driven process. एप्लीकेशन लगेगा तो जानकारी मिलेगी, नहीं तो पारदर्शिता नहीं आएगी। केवल उतनी जानकारी आएगी जो सरकार खुद ब खुद पब्लिक करना चाहती है, which is need to know basis, not according to the requirements of 4(1)B, 4(1)C and 4(1)D. 4(1)C and 4(1)D are guiding principles for real time disclosure of information. नहीं हो रहा है। This is where the problem is. Who will build the cat? So when the political executive, मंत्री स्तर के, मंत्री जी के स्तर पर जब सेक्शन 4(1)B के ऊपर अमल नहीं किया जाता, so it is quite possible that it is quite natural that निचले स्तर पे इसके ऊपर अमल ही नहीं होगा। We actually said, we have made recommendations कि every head of the department जब उसका appraisal होता है साल में एक बार, annual confidential reports जो बोलते थे पहले, आजकल annual performance appraisal reports बोलते हैं, उसमें it has to be included as to what this person has done to promote the implementation of RTI in their department, because it applies to all departments. आज तक उसको हिस्सा नहीं, उसको शामिल नहीं किया गया है। लेकिन जब इंफॉर्मेशन कमीशन के वैकेंसीज को भरने की बात आती है, तो एवरी हेड ऑफ द डिपार्टमेंट हु इज रिटायर्ड विल पुट इन एन एप्लीकेशन। सम पीपल वोंट इवन पुट इन द एप्लीकेशन, रिटायर होने के 4 दिन के अंदर या 1 महीने के अंदर अपॉइंट भी हो जाते हैं। तो वो जगह चाहिए, वो कुर्सी चाहिए, लेकिन इंप्लीमेंटेशन के लिए कुछ खास नहीं है। दिस इज वेयर द प्रॉब्लम। डॉक्टर आत्मा, प्लीज म्यूट योर माइक, डिस्टर्बेंस हो रही है। थैंक यू। So this is where the problem is कि RTI today has become nobody's baby except that of the citizen. केवल नागरिकों के लिए RTI महत्वपूर्ण लग रहा है, और लड़ झगड़ के मेहनत करके RTIs में जानकारी निकलवा रहे हैं, जान को जोखिम में डालकर RTI निकलवा रहे हैं। And that is where we have a huge problem कि मौलिक अधिकार के प्रयोग के लिए जान जोखिम में क्यों डालना पड़ रहा है? Why is it dangerous to people's health when they exercise the right to information? Why do I say that? There are about 104 cases of murder of RTI activists still date because of the fact that they used RTI. More than 350 cases of people being physically attacked because they filed RTI applications and asked for information. पिछले महीने हमारे अपने कर्नाटका के स्टेट में एक मर्डर हुई, और अभी 2 दिन पहले एक और मर्डर हुआ है हमारे स्टेट में, दोनों RTI एक्टिविस्ट से, क्योंकि वो जानकारी मांग रहे थे about developmental programs. If the system is not able to protect these people, and the system protects more and more of people who are indulging in corruption, then the trust deficit will only widen. Please do not think of elections जहां पर 60% मेजॉरिटी में कोई सरकार जीत गई, 70% मेजॉरिटी से कोई सरकार जीत गई, या फिर 50% मेजॉरिटी से सरकार जीत गई, तो there is an immense amount of trust between citizens and the government. No, sorry, that is not the only barometer. The other barometer is the number of RTIs that are going in. Ungiven RTIs about NREG implementation, despite the fact that it is one of the most transparent of schemes that is being implemented. Why? Everybody knows there is corruption in the implementation of Manrega. Nothing is being done. लोकपाल तो ठप है, वैकेंसीज फिल भी नहीं हुए, सीबीसी करता क्या है वो भगवान जाने. Annual reports निकालते हैं, but we don't hear of cases where corrupt officers have actually been punished. And today the fun part is corruption का डेटा जो हर साल क्राइम इन इंडिया रिपोर्ट्स में पब्लिश किया जाता है नेशनल क्राइम रिकॉर्ड्स ब्यूरो के द्वारा. पिछले 3 साल में उन्होंने वो कॉलम्स ही हटा दिए जहां पर ग्रुप ए, ग्रुप बी, ग्रुप सी एंड ऑर्डिनरी सिटीजन्स जिनको कन्विक्ट किया गया है करप्शन केसेस में, पहले वो डेटा दिया जाता था, आजकल वो डेटा ही हटा दिया. You won't get data about how many group A, group B, group C, group D and private individuals have been convicted in corruption cases. Data नहीं मिलता. कितने cases launch हुए, कितने cases convict हुए, कितने cases acquit हुए, बस इतना data मिलता है. No more. This is where trust deficit increases. And this is what needs to be tackled on a war footing, because this is not good for society. If citizenry does not have adequate trust in its government, we will go the same way as the USA has gone. पिछले साल जनवरी 6 तारीख को हुआ, पिछले साल नहीं 3 साल पहले ट्रंप के इलेक्शन के हार के बाद क्या हुआ था? सैकड़ों लोग, हजारों की संख्या में लोग कैपिटल हिल को स्टॉर्म कर गए. पहली बार नहीं, वो उस वक्त को पहली बार हुआ था, यूएसए में पहले हुआ नहीं था ऐसे. कल परसों की बात है, ब्राजील में ऐसे ही हुआ है. हुआ क्यों? क्योंकि हारने वाले बोल्सोनारो, हायर बोल्सोनारो की जो सपोर्टर्स हैं, they tried to storm the Brazilian capital where the newly elected government was being sworn in. Trust deficit. I hope to God that I don't live to see the day when that kind of a thing happens in India. We still have peaceful transfer of power in India. उतना तो ट्रस्ट बचा हुआ है, but RTI should be taken as a metric to understand that people's information requests are coming in such large numbers because they do not trust the government entirely. और यहाँ पर केवल एग्जीक्यूटिव का ही समस्या नहीं है, यहाँ पर MPs, MLAs और MLCs की भी प्रॉब्लम है. Why? They do not meet with the members of their constituency on a regular basis to explain to them what government is doing. बस पॉलिटिकल मीटिंग्स होते हैं, पॉलिटिकल रैलीज होते हैं, इंटरएक्टिव मीटिंग्स होते ही नहीं. या तो आप वहां पर लेके जाइए एक पिटीशन कि माई बाप मेरा ये काम कर दो, ट्रांसफर करवा दो, बच्चे को स्कूल में एडमिशन का दाखिला दिलवा दो या कॉलेज में सीट दिलवा दो, इस तरह के रिक्वेस्ट. या फिर पूंजीपति आते हैं सूटकेस लेकर कि सर ये कॉन्ट्रैक्ट हमें दिलवा दीजिए, हमें वो वाला स्कीम का इम्प्लीमेंटेशन का जिम्मा दिलवा दीजिए. यहीं तक है सीमित इंटरैक्शंस. Where have we had a situation where members of parliament have come after a Sansad ka session, sat with their constituencies, with their constituents and said, हम पिछले सत्र में इन मुद्दों पे सदन में चर्चा किया और उन चर्चाओं में इन हिस्सों में इन संदर्भों में मैंने भाग लिए, मैंने ये सवाल किए, मैंने ये वक्तव्य अपना रखा. किसी एमपी ने आज तक बोला है अपने लोगों को? नहीं बोला. How else will trust deficit reduce? You will ask me कि अरे ये आपके विचार ये कहाँ से आ रहे हैं भैया? Why do MPs have to have the obligation of interacting with their constituents to tell them what they have been doing? अरे because there are countries like Kenya जो हमारे मुकाबले इकोनॉमिक डेवलपमेंट में पता नहीं कितना पीछे है, उनको पता नहीं कितने सैकड़ों साल लगेंगे हमारे लेवल तक आने के लिए. उनकी संविधान में लिखा है कि every elected representative of the people has to go back to the constituents and tell them what they did when the respective houses of which their members were in session. काउंटी लेवल पे बताना पड़ेगा, उनके डिस्ट्रिक्ट नहीं बोलते, काउंटी बोलते हैं. वहां पे काउंटी लेवल गवर्नमेंट से और नेशनल लेवल गवर्नमेंट है. एमपीज को भी बोलना पड़ेगा, काउंटी लेवल रिप्रेजेंटेटिव्स को भी बोलना पड़ेगा. That is the extent to which a democracy has to mature to be able to deal with a trust deficit. And I hope in some time we will be able to get to that point. Now, implementation roadmap क्या हो सकता है? RTI should become a priority for every public authority. It should not be seen as a source of headache. It will stop being a source of headache when you make it a priority. You are all from educational institutions. I will tell you my experience of one education institution based in Bangalore. This is a National Law University National Law School of India, University, NLSIU, Bangalore. The present Vice Chancellor is a good friend of mine. A few years ago, he called me and said, soon after he had taken over, Venkatesh, we are getting a lot of RTIs. Can you guide us on how to reduce the number? And I said, okay, tell us what kinds of information are people asking you? And when the PIO sat with me and explained what all RTIs were being asked and what all information they were being requested to give, and they started taking them off. हाँ, ये उनके मांगे बिना पब्लिक किया जा सकता है, ये उनके मांगे बिना पब्लिक किया जा सकता है, ये सेक्शन 4(1)(b) के तहत पब्लिक किया जा सकता है. That exercise has to happen in every public authority. That is how you bridge the trust deficit. You reduce the number of RTIs. If that exercise doesn't happen, RTI will keep on increasing and it will be a request driven process. जो जानकारी आप ऑलरेडी पब्लिक करेंगे, कोई मांगने के लिए जाएगा ही. My own experience I've seen, अगर पार्लियामेंट में कुछ सवाल किए जाते हैं और उनका जवाब दिया जाता है, वो जानकारी पढ़ने के बाद RTI उस पर डालने के लिए कोई गुंजाइश ही नहीं रहती है. There's no space. It's already been answered. It's good. Media has reported. People have seen it. और इंटरनेट पे तो हमेशा के लिए रहेगा. No need to file RTIs on that. So it is in that direction which section 4(2) wants the public authorities to go, that must be charted out. और इन सब चीजों के लिए क्या चाहिए? Resources. You will be very surprised to know. In the initial 3 years of implementation of the RTI Act, central government under UPA 1 did not even spend a single penny to implement RTI except to give funding for Central Information Commission to be set up. Where did the money come from for implementation? Workshops काफी सारे हुए. उसका पैसा कहां से आया? It all came from a grant from the UNDP. उसके बाद जाकर Planning Commission ने बोला कि नहीं, let us have a plan scheme where every year we will set aside some money through the Department of Personnel and Training for the purpose of public education and training of government officers on RTI. जिसके तहत आज के तारीख में 3-3 लाख रुपए या तो कमीशन को दिए जाते हैं या फिर संबंधित इंप्लीमेंटिंग डिपार्टमेंट्स को स्टेट लेवल पे दिया जाता है. और 3 लाख एक स्टेट के लिए कहां काफी होगा? 6 लाख मान लो, कहां काफी होगा ही. सो एक RTI फाइल किया गया मेरे तरफ से डिपार्टमेंट ऑफ पर्सनल ट्रेनिंग में कि बहुत सारे अन्य डिपार्टमेंट्स लीगल लिटरेसी प्रोग्राम्स करते हैं, अवेयरनेस रेजिंग प्रोग्राम्स करते हैं. उनको क्या आपने लिखा है कि RTI को भी उसमें शामिल करें, क्योंकि आपको कोई पैसा खर्च नहीं करना पड़ेगा, अपने पैसे से, अपने बजट के एलोकेशन से वो लोग करेंगे ना. तो देयर विल बी अ रिपल इफेक्ट. डिपार्टमेंट ने लिखा ही नहीं था और लिखे भी नहीं बाद में. Nobody wants to build a cat because everybody wants to keep knowledge of RTI as limited as possible. वो सोचते हैं कि जितना ज्यादा RTI की नॉलेज फैलता जाएगा उतने ज्यादा RTIs आते जाएंगे, हमारे लिए परेशानी होगी. And Supreme Court said exactly that in the CBSE judgment कि 75% of the time of public authorities should not be spent on dealing with RTIs and only 25% set aside for other purposes. और उसको आजकल भगवत गीता के एक श्लोक के रूप में इस्तेमाल किया जाता है. 75%, 25%. Therefore, we can't give you information. I've got so many RTI replies like that from central government. That is not the intention. The reason why you should not be spending 75% on dealing with RTIs is give information to people so that you don't have to deal with RTIs. People will not ask for information. People will read up on the website. People will read up on a notice board, and they will get the information. So until we go in that direction, RTI implementation is not going to be successful. Year after year after year, we will have RTI applications increasing in number, RTI appeals increasing in number, pendency of RTI second appeals in the information commissions increasing in number. So it is high time that everybody at the highest level of government paid serious attention to RTI rather than try to amend it the way Thakkar Saab has pointed out in the data protection bill. Amend करने की जरूरत नहीं है, implement बेहतर कर लो, आपके फायदे में. वोट बटोरने के लिए पैसा खर्च करने के बदले, लेजिस्लेटर्स को खरीदने के लिए पैसा खर्च करने के बदले, ट्रांसपेरेंसी अगर आपने उसके ऊपर पैसा खर्च किया, उसका 1% भी बहुत फायदा होगा. Trust deficit between citizens and government will reduce. Now you're all education institutions. I will give you my own example. I was a student of JNU from 1989 up to the year 2000. So during my PG course, in my center, we would write exams every semester. Our answer scripts were evaluated and our professors would give us a copy of the, not copy, they would give us the original. They would show us the grades. They said, take a look at it. And wherever we got less grade, we would ask them, sir, how can we improve? We never thought कि अरे we are not getting our answer script at all. Grade लेकिन इतना कम मिल रहा है. In one exam I got a B minus. So I asked the teacher कि सर इतना कम कहाँ पे मेरे answers में कमी आती. And the teacher explained. And the next exam I got an A minus because I had improved. So when students ask for information about their own work or their own answer scripts, their own exams, Supreme Court has also said that is primarily for the purpose of improving one's performance. And if a student has been marked or graded wrongly, then the student has a right to seek justice, no? So therefore, transparency helps everyone. Transparency helps build confidence. Transparency helps improve trust. जब तक ये समझेंगे नहीं, RTI will always be seen as a headache. So I'm going to stop here. I think we have another 15 minutes. So if you have any questions further, please feel free to raise them. Or if you would like to express a different view from what I have expressed, please go ahead and speak. हाँ, ठक्कर साहब जी, आपका हाथ ऊपर आया है. Please go ahead.
जी सर, I would just like to add some things. जो आपने बताया कि RTI तीनों विंग्स पर लागू है, that is executive, legislature and judiciary. अब इसमें एक as far as judiciary is concerned, ground reality ये है कि जो हाई कोर्ट के, सुप्रीम कोर्ट के जजमेंट्स की जो कॉपी है, ठीक है, कंप्यूटराइजेशन हो रहा है, many things are available on the internet, we don't need certified copies etc. But certified copy का इतना बुरा हाल है सर कि 36 रुपए फीस होती है और कोर्ट क्लर्क को या एडवोकेट के क्लर्क को 500 रुपए रिश्वत दे कम से कम दिए बिना वो जजमेंट की कॉपी हासिल नहीं होती है. दैट इज द ग्राउंड रियलिटी. जब ये एक कर्नाटका वाला मामला गया था सुप्रीम कोर्ट में, कर्नाटक इंफॉर्मेशन कमिश्नर वाज इम्पोज कॉस्ट ऑफ 1 लाख रुपीस कि हाई कोर्ट के खिलाफ ये मतलब सुप्रीम कोर्ट कॉल्ड इट एन ईगो इशू और वो 1 लाख रुपए जुर्माना किया. अभी जो दूसरे अभी केसेस गए हैं, वन वाज दिस गुजरात हाई कोर्ट, that matter went to the Supreme Court. तो उन्होंने बोला there is no inconsistency और section 22 में जो overriding effect है of RTI Act over the other acts वो मानने से इनकार कर दिया कि there is no inconsistency, both are meant for say providing information and therefore they should comply. और वैसा ही वो ICI वाला केस है, पारस जैन वाला केस है, तो इस केस में भी सुप्रीम कोर्ट ने यही किया एंड देयरफॉर ये इम्प्लीमेंटेशन जो है वो जुडिशियरी में उतना इफेक्टिवली हो नहीं पा रहा है. आई डिस्कस दिस इशू विथ आवर फॉर्मर CIC शत्रुघ्न सिंह साहब इन 2019. ही वाज वेरी डिजेक्टेड कि ये जो ये CPIO सुप्रीम कोर्ट ऑफ इंडिया वर्सेस सुभाष चंद्र अग्रवाल वाला केस था, तो सुप्रीम कोर्ट हेल्ड दैट सुप्रीम कोर्ट इज आल्सो ए पब्लिक अथॉरिटी एंड इट कम्स विद इन द परव्यू ऑफ RTI. लेकिन ही वाज वेरी अनहैप्पी कि सुप्रीम कोर्ट ने इसका डिसाइड करने में 10 साल लगा दिए कि 2009 का मामला था और 10 साल सुप्रीम कोर्ट को केवल ये डिसाइड करने में लग गए कि इट अप्लाइज टू अस आल्सो. और अभी एक राज्यपाल वाला केस अभी भी पेंडिंग है कि वेदर द गवर्नर, क्योंकि कॉम्पिटेंट अथॉरिटी भी है और पब्लिक अथॉरिटी भी है, सो कुछ राज्यपाल का ये कहना है कि वी आर कॉम्पिटेंट अथॉरिटी, वी हैव रूल मेकिंग पावर्स अंडर से सेक्शन 28 और इसलिए हम इसमें नहीं आते. जहां तक फंडिंग की बात है, उत्तराखंड का सिचुएशन मैं बता रहा हूँ कि अब जिम्मेदारी तो है स्टेट गवर्नमेंट की एज फार एज ट्रेनिंग कॉस्ट आर कंसर्न. अब ये काम हमको क्यों मिला उत्तराखंड सूचना आयोग की तरफ से? क्योंकि सेक्शन 26 में जो ड्यूटी है गवर्नमेंट करती नहीं है, दे डोंट हैव द एक्सपर्ट्स. दे आज द उत्तराखंड इंफॉर्मेशन कमिश्नर, उन्होंने फिर जो डॉक्टर रघुनंदन सिंह टोलिया ये प्रशासनिक एकेडमी है नैनीताल में, उनसे पूछा, उनके पास भी कोई एक्सपर्ट नहीं थे. तो फाइनली वन एड वाज पब्लिश और उसमें से फिर हम 4 LLB है, इनको हमको RTI रिसोर्स पर्सन सिलेक्ट किया गया. सो दैट इज द ग्राउंड रियलिटी. क्योंकि उसमें भी प्रॉब्लम ये आती है कि ज्यादा लोग सीख जाएंगे. अभी जो लोग लगाते हैं दैट इज जस्ट 0.5% to 1%. अब जो DPDP बिल की यदि बात करें, नाउ देयर इज अनदर से वेरी इंपॉर्टेंट फंडामेंटल राइट दैट इज गोइंग टू बी गिवन टू द पब्लिक, कि ये जो बड़ी बड़ी मल्टीनेशनल कॉर्पोरेशंस है कि जिनके पास हमारा प्राइवेट डेटा रहता है, दैट इज फेसबुक, ट्विटर, व्हाट्सएप, इंस्टाग्राम वगैरह, तो इनको कंट्रोल करने के लिए अभी जो DPDP बिल लाया जा रहा है, तो इन बड़ी कंपनियों का इतना विरोध है कि जो पहले जो 2 ड्राफ्ट थे दे वर इन द फॉर्म ऑफ माइनर क्रिमिनल लॉ, लेकिन अभी जो तीसरा ड्राफ्ट जो 2018 और 2019 के बाद जो 2022 का बिल लाया गया है, इट इज जस्ट इन द फॉर्म ऑफ से सिविल लॉ. और ये भी एक लीगल राइट बनाने की इसमें जो कोशिश की गई है, तो इसमें भी प्रॉब्लम ये आ रही है कि पेनल्टी तो है बट देयर इज नो इम्प्रिजनमेंट, सो उसका जो डेटरेंट इफेक्ट है वो उतना नहीं रहेगा। पेनल्टी भी ठीक है, 250 करोड़ है, 500 करोड़ है, विच इज वेरी ड्रास्टिक एज कम्पेयर टू द से दैट गिवन अंडर आरटीआई एक्ट की, जिसमें मैक्सिमम सॉरी आईटी एक्ट की, आईटी एक्ट 2000 में मैक्सिमम 5 करोड़ है। 5 करोड़ से ज्यादा भी है तो देन मैटर गोज टू द से सिविल कोर्ट इंस्टेड ऑफ एपेलेट ट्रिब्यूनल। और आईपीसी के फाइन से यदि कंपेयर करें तो आईपीसी का तो अभी भी बुरा हाल है, जो 150 साल पहले के रेट है। एक ज्वाइंट पार्लियामेंट्री कमेटी ने रिकमेंड भी किया था कि कम से कम इसको 50 गुना किया जाए, बट देयर इज सो मच रेजिस्टेंस। अब तो मुझे लगता है कि अमित शाह जी जब नया आईपीसी और सीआरपीसी लाने की बात कर रहे हैं तो वो यदि आ जाएगा तो हो सकता है कि उसमें कुछ इंप्रूवमेंट हो, अदरवाइज देयर इज नो डेटरेंट इफेक्ट। 510 में पब्लिक प्लेस में शराब पीकर दंगा मस्ती करना, अभी भी उसमें 10 रुपया फाइन है। इतना तो पुलिस रिश्वत भी नहीं लेता ये रेट से, जो मतलब दैट इज द ग्राउंड लेवल रियलिटी ऑफ आवर क्रिमिनल लॉ। तो जो जस्टिस मलिक कमेटी थी उसके ज्यादातर रिकमेंडेशन तो इम्प्लीमेंट हो गए, बहुत सारे 2009 में, 2013 में जो निर्भया गैंगरेप केस के बाद 2014 में क्रिमिनल लॉ अमेंडमेंट एक्ट में हुआ, उसके बाद 2018 में कुछ हुए, तो काफी सजेशन तो इम्प्लीमेंट हो चुके हैं, बट फिर भी जो डेटरेंट इफेक्ट है वो उतना नहीं दिखता। और मुझे लगता है कंप्लीट रिवैम्प की जरूरत है, जैसा आईपीसी और सीआरपीसी को पूरा नया बनाया जाए तो उस तरह से करते हैं तो ही ये मतलब कुछ कम हो सकती है। क्योंकि उस टाइम जो फॉर्मर अटॉर्नी जनरल थे सोली सोराबजी साहब, उन्होंने कहा था कि जो ये जो कन्विक्शन रेट है इन इंडिया बहुत 6%, 7%, सीबीआई के केस में 60-70% है, एंड द क्रिमिनल जस्टिस एडमिनिस्ट्रेशन इन इंडिया इज ऑन द वर्ज ऑफ कोलैप्स। और इसलिए ये जस्टिस रवि मलिक कमेटी, सॉरी रवि मलिक तो खैर हमारे जो वो तो उनके बेटे जस्टिस मलिक जो थे कर्नाटक हाईकोर्ट के चीफ जस्टिस, उनके बेटे थे, ही वाज आवर एक्टिंग सीजे इन उत्तराखंड। तो जस्टिस मलिक जो थे उन्होंने ये जो उस टाइम रिकमेंडेशन दिए थे 2003 को, लाल कृष्ण अडवाणी जी जो होम मिनिस्टर थे, तो उन्होंने काफी अच्छे सजेशन दिए थे, मोस्ट ऑफ देम हैव बीन रिकमेंडेड। बट एज फार ये जो फाइन का जो ये है, इट इज सो लेस कि कोई उसका डिटरेंट इफेक्ट क्रिमिनल लॉ का इंडिया में नहीं है। इवन जो पार्किंग ऑफेंस जो उसमें है उसमें फाइन उससे ज्यादा है, और उसका ये है, तो पुराने कानून को बदलने की बहुत जरूरत है ताकि इसका कोई डिटरेंट इफेक्ट हो और सोसाइटी में क्राइम कम हो। थैंक यू सो मच।
जी जी, आज के अखबार में आया है, टाइम्स ऑफ इंडिया में शायद कल छप भी जाएगा, कि कुछ सिविल केसेस और कुछ क्रिमिनल केसेस इतने पुराने हैं जो अभी भी मजिस्ट्रेट कोर्ट के सामने या ट्रायल कोर्ट के सामने चल रहे हैं, उस जमाने के जब हमारे आज के कोई भी सुप्रीम कोर्ट जज पैदा भी नहीं हुए थे। कैन यू बिलीव? इतने पुराने केसेस हैं। दैट इज द रियलिटी एज फार एज द क्रिमिनल जस्टिस सिस्टम एंड द सिविल जस्टिस सिस्टम इज कंसर्न्ड। आवर वरी इज आरटीआई भी कहीं उसी दिशा में चले ना जाए with the increasing pendency that is happening. I hope government will wake up and take these matters seriously and make sure that RTI is implemented in letter and spirit in the coming months, because that is what is crucial for any government to win the confidence of people. Any other questions?
मेरा इस बारे में थोड़ा अलग है as far as these arrears और pendency is concerned, क्योंकि इसमें एक जज ने अपनी रिपोर्ट में कहा था कि इतनी ज्यादा पेंडेंसी है कि इट वुड टेक अबाउट 266 ईयर फॉर ऑल द लिटिगेशन टू एंड। एक ने कहा था कि इट वुड टेक अराउंड 400 इयर्स फॉर, इतना ज्यादा पेंडेंसी है। बट मैंने एक जज का व्यू पॉइंट ये भी पढ़ा था कि मीडिया ओनली हाईलाइट द नेगेटिव थिंग्स, वो ये नहीं देखते कि इफिशियंसी इज 90%, मतलब जितने केस फाइल होते हैं उसका 90% में डिस्पोजल हो जाता है। उस चीज को तो कोई हाईलाइट करता नहीं है, कोई बताता तक नहीं है। और जो 10% जो पेंडेंसी रहता है, और खास करके जहाँ पर 10-20 साल से ज्यादा हो जाता है, तो ऐसे केसेस को इतना ज्यादा हाईलाइट कर लिया जाता है जैसे कि हर केस में ऐसा ही होता है, तारीख पे तारीख, तारीख पे तारीख, इस तरह से होता है। दे डेलिबरेटली से प्रोजेक्ट द नेगेटिव व्यू ऑफ द जुडिशियरी। ऐसा नहीं करना चाहिए। इफिशिएंसी इज आल्सो ए पैरामीटर कि कितना डिस्पोजल है, और उस तरह से यदि देखा जाए तो ठीक है, लिटिगेशन बहुत ज्यादा है और वो कंप्यूटराइजेशन उतना ज्यादा नहीं है इंडिया में। और एज फार एज लॉ ऑफ टॉर्ट्स इज कंसर्न, वहां तो ऐसा है कि सुबह केस फाइल करो शाम को डिसीजन आ जाता है। हमारे यहाँ पर उतना इम्प्लीमेंटेशन नहीं है, लेकिन फिर भी कोशिश हो रही है। और ये जो कंप्यूटराइजेशन और ये सब हो रहा है, इवन जो वीडियो कॉन्फ्रेंसिंग वगैरह हो रहा है लिटिगेशन का वगैरह, तो आई थिंक दैट इज अ गुड इनिशिएटिव। और बीइंग ए कंप्यूटर इंजीनियर सिंस लास्ट 32 इयर्स, मैंने तो देखा है कि जहाँ जहाँ पर कंप्यूटराइजेशन होता है तो करप्शन रिड्यूस होता है। अब ये जो ऑनलाइन एफआईआर का मामला आया है, कल जस्टिस प्रशांत सॉरी ये सीनियर एडवोकेट प्रशांत भूषण साहब का एक केस आया था, जो चार्जशीट भी फाइल किया, मतलब आरटीआई में पब्लिक किया जाए, वो उन्होंने आर्ग्यू किया था। तो उसमें भी है कि राइट्स ऑफ अक्यूज वर्सेस राइट्स ऑफ पब्लिक इंटरेस्ट, ये वाली बात जज के सामने, मतलब 2 जज बेंच के सामने सुप्रीम कोर्ट में आई थी कि चार्जशीट को भी क्यों ना पब्लिक कर दिया जाए, क्योंकि एफआईआर का इतना आसान हो गया है कि एफआईआर सर्च करके अब कोई भी एफआईआर हमको बड़ी आसानी से मिल जाती है। तो एफआईआर जो है जिसमें अनसब्सटेंशिएटेड एलिगेशंस भी हो सकते हैं, वो चार्जशीट जब की जा सकती है, तो चार्जशीट विच इज एज ए रिजल्ट ऑफ से इन्वेस्टिगेशन बाय द पुलिस ऑफिसर्स, उसको पब्लिक क्यों नहीं किया जा सकता। दैट वाज द आर्गुमेंट यस्टरडे इन सुप्रीम कोर्ट। और मुझे लगता है कि ये ट्रांसपेरेंसी की दिशा में धीरे धीरे आगे बढ़ते जा रहे हैं, और ये जो वीडियो कॉन्फ्रेंसिंग जो हो रहा है जुडिशियल का, आई थिंक दैट इज ए ग्रेट स्टेप टुवर्ड्स द ट्रांसपेरेंसी। थैंक यू।
बिल्कुल। तो अभी चैट बॉक्स में मैंने एक सवाल देखा डॉक्टर रूपा मंगलानी जी से। पहले तो वेरी गुड इवनिंग टू यू मैम, बहुत सालों बाद फिर से आपसे मुलाकात हो रही है। तो उनका सवाल यह है कि डिसिप्लिनरी एक्शन का प्रोविजन जो है कि बार बार आरटीआई कानून को कोई पीआईओ अगर उल्लंघन करता है उसका, तो उसके खिलाफ अनुशासनात्मक कार्रवाई का
की जा सकती है या नहीं?
रिकमेंडेशन देने जी सेक्शन 20 सब में ये प्रोविजन है। इसके बारे में डेटा है कि वेल
जी
it all depends upon how the data is collected. सेंट्रल इंफॉर्मेशन कमीशन के रिपोर्ट्स में कुछ डेटा तो मिल जाता है, लेकिन वो केवल रिकमेंडेशन जो दिया गया, we never get to know कि कितना वो रिकमेंडेशंस के ऊपर इम्प्लीमेंटेशन हुआ है. So that is where the problem is. Data is not collected. But if you want to say anything else on this, ma'am, please go ahead.
या थैंक यू सर, बहुत ही अच्छा प्रेजेंटेशन था हमेशा की तरह वेंकटेश जी आपका, और बहुत शुक्रिया आपका। बहुत सारे आपने अक्रॉस द स्टेट आपने कुछ डायमेंशंस रखे। सर मेरा केवल यही कहना है, क्योंकि राजस्थान की उस सरजमी से जो एक्ट उठा था राजसमंद और देवडुंगरी के लोगों ने, तो मैं उस दौर को देख चुकी हूँ, और मैंने जिस शिद्दत से उन्होंने वो शुरुआत की थी, और आज 15-16 साल बाद जो उस बच्चे की हालत हुई है, तो मुझे ये कहना है कि ये टीथिंग एज भी खत्म हो गया और टीनेजर भी खत्म हो गया। तो बस यही कहना है कि आपके जैसे लोग जो है सनशाइन एक्ट को बचाए रखें, इसी उम्मीद के साथ सर। थैंक यू।
थैंक यू। आई थिंक सनशाइन एक्ट को बचाए रखने की जिम्मेदारी और बाध्यता हम सब नागरिकों की है, क्योंकि हमारा ये कानून, सरकार इसको मानता नहीं है कि उसका अपना कानून, जैसे इनकम टैक्स कानून को मानता है, जीएसटी कानून को मानता है, सीआरपीसी कानून को मानता है, पीनल कोड अंग्रेजों के जमाने के कानून है, लेकिन सरकार इसको अपना मानता है। आरटीआई कानून को मानेगा नहीं, सरदर्द मानता है। तो इस सोच को बदलने की जिम्मेदारी हम और आप सबकी है।
बिल्कुल, लोकतंत्र की इमारत बुलंद रहे सर।
एंड एक्चुअली आई हर्ड समथिंग वेरी इंटरेस्टिंग अबाउट 16 years ago इन पंजाब पुलिस एकेडमी फिल्लौर में। आधे दिन का ट्रेनिंग करने के लिए उन्होंने टाइम दिया था, तो हबीबुल्ला साहब सब वगैरह सबको लेके हम लोग गए थे। और वहां पर ट्रेनिंग में उनके एडीजीपी ने बोला कि देखिए, ये आरटीआई हम लोग कहते हैं कि सरदर्द है, इतना खराब कानून आ गया, हमारे काम में दखल अंदाजी देने के लिए नागरिकों को खुली छूट मिल गई है। सो इज दैट हाउ वी शुड बी डीलिंग विद? एंड ही सेड, लेट मी एक्सप्लेन। ही सेड, व्हाट इज द साइज ऑफ द पंजाब पुलिस फोर्स? इट्स अबाउट 90,000 पीपल।
या
Let us take into consideration all our family members. So that will be in the range of about 4 to 5 lakhs.
So,
and he said that, look, we 90,000 people are in government, but the remaining family members are not in government. They are all consumers of government service in some type of the other. When they come into difficulty, they will use RTI. We 90,000 people are not going to be in service all our lives. We will retire at some point of time. After that, we also become consumers of government service. We will run into difficulties because of poor quality or non-delivery of government service. We will be forced to use RTI. So if that is the case, why should we be resistant towards RTI? Was the question that he asked. And I thought that was a very telling statement. That if one recognizes that today I am in government as a custodian of the public power, and I have access to information as a custodian of those government files, not as the owner, not as an author, then implementation of RTI will become very easy.
So
that thinking which should be improved, so which we should work towards, and that is where teachers like you have a big role to play.
सर इसी पंजाब में एक ट्रेनिंग के दौरान एक पीआईओ साहबान जो सबसे ज्यादा आरटीआई को भला बुरा कह रहे थे, जब ट्रेनिंग का ब्रेक हुआ तो उन्होंने आकर मुझसे पूछा कि आई वांट टू यूज आरटीआई फॉर माय डॉटर, कैन यू हेल्प मी फॉर दैट? तो राजन कश्यप साहब ने कहा कि ये बात है। तो राजन कश्यप पंजाब के कमिश्नर थे, तो उन्होंने कहा हाँ अब ये चल निकलेगा।
बिल्कुल। I have had information commissioners approaching me after completing their tenure and saying के साहब हम तो RTI फाइल नहीं कर सकते, आप हमारी मदद कर सकते हैं क्या?
Sir, great.
And these kinds of situations also. So see, ultimately RTI ऐसा कानून है संविधान की तरह, कभी ना कभी किसी ना किसी के काम जरूर आएगा. And the funny part was this, उत्तर प्रदेश का स्टोरी है. शिक्षा विभाग ने वैकेंसीज का एडवर्टाइजमेंट किया. जैसे हम आमतौर पे होता है, लाखों की संख्या में एप्लीकेंट्स आए, उन्होंने फिर कुछ एलिजिबल कैंडिडेट्स को छांटे. और यूपी में तो वही डाउट होता है, किसी ग्रेजुएट ने या पोस्ट ग्रेजुएट ने जो डिग्री सर्टिफिकेट लगाई है वो जेन्युइन है या फर्जी है. तो डिपार्टमेंट ने क्या किया, उन सबको बंच किया यूनिवर्सिटी वाइज और सबके कॉपी निकाला और हर यूनिवर्सिटी में 10 रुपए के RTI एप्लीकेशन फी लगाकर भेज के पूछा, कैन यू प्लीज सर्टिफाई वेदर दीज आर द ओरिजिनल. So this is how RTI has been of use to people.
And in Rajasthan, interdepartmental RTIs को अप्लाई करते हैं, एक डिपार्टमेंट को दूसरे से मांगनी होती है, तो बजाय वो कागज की कार्रवाई करने के, they used to file RTIs.
Exactly. So that is where the power of RTI becomes very evident. What kinds of people have filed RTIs? Please look at this. स्वर्गीय अरुण जेटली जी ने RTI फाइल किया था when he was in the opposition. स्वर्गीय जसवंत सिंह जी ने RTI फाइल किया था when he was in the opposition. स्वर्गीय मनोहर पर्रिकर जी एज लीडर ऑफ द ऑपोजिशन गोवा में RTI फाइल किया था, जिसका जिक्र अभी ठक्कर साहब ने थोड़ी देर पहले किया कि गवर्नर पब्लिक अथॉरिटी है कि नहीं. उस मामला उनके RTI से निकला बाहर और अभी तक वो रिजॉल्व नहीं है. लेकिन एक बार सरकार में आ जाते हैं तो सोच बदल जाती है, रवैया बदल जाता है. दिस इज व्हाट नीड्स टू चेंज इफ, लाइक आई अगेन रिपीट, ट्रस्ट डेफिसिट लोगों के बीच में और लोगों के और सरकार के बीच में अगर कम करना हो और वो संबंध अगर सुधारने हो, तो पारदर्शिता एक बहुत ही महत्वपूर्ण औजार बन सकता है उस संबंध को सुधारने के लिए.
जी सर, पैराडाइम शिफ्ट इज नीडेड. थैंक यू सर.
सर उत्तराखंड में ऐसे भी केसेस हुए, एक डिस्ट्रिक्ट कलेक्टर ने भी, यहाँ पर DM ने भी RTI फाइल की थी, एक डिस्ट्रिक्ट जज ने RTI फाइल किया, ऐसा भी केस हुआ है. जहाँ भी अभी इम्प्लीमेंटेशन की बात हुई, जो 20(2) के बारे में सवाल पूछा गया, डिसिप्लिनरी एक्शन में इम्प्लीमेंटेशन की प्रॉब्लम सर ये आती है कि इंफॉर्मेशन कमिश्नर हैज ओनली द रिकमेंडेटरी पावर, तो रिकमेंड वो कर देते हैं, उसके बाद फिर मैटर डिपेंड्स अपॉन द एम्प्लॉयर वेदर टू टेक एक्शन और नॉट. एंड इफ द एम्प्लॉयर डजंट टेक एनी एक्शन तो फिर कुछ नहीं होता है. वैसे ही वो पेनल्टी वाला भी है. यहाँ पर करीब 1,43,00,000 रुपए पेनल्टी का जो है वसूली का मामला था. उसमें मुझसे एडवाइस मांगा गया था. आई वाज आल्सो एडवाइजिंग द CIC एंड द ICs इन 2019. उसमें ये जो मामला था, इसमें करीब 572 जो केसेस थे उत्तराखंड सूचना आयोग के खिलाफ, वो नैनीताल हाईकोर्ट में केसेस गए थे. आई प्रिपेयर्ड कॉम्पेंडियम ऑफ दैट, लगभग 95% काम पूरा हो चुका है. तो सुप्रीम कोर्ट के जजमेंट का तो RTI एक्ट के केसेस का कॉम्पेंडियम मैंने बनाया ही है. हाईकोर्ट में 4 तरह के केसेस थे. कुछ ऐसे थे कि जहाँ पर कोर्ट ने स्टे लगा दिया है और फिर वसूली रुक गई है. कुछ ऐसे है कि जहाँ पर उन्होंने अपहोल्ड किया है कि पेनल्टी सही है और जो PIOs थे उनकी जो रिट पिटीशन थी उसको डिसमिस कर दिया. जनरली MS केस होते हैं, मिससेलेनियस सिंगल जज के सामने. और दूसरा कुछ ऐसे केसेस थे कि जहाँ पर उन्होंने ये पेनल्टी जो है वो गलत मानना और क्वैश कर दिया. और कुछ मामले ऐसे थे कि जहाँ पर कॉम्प्लायंस कर दिया गया, कि जहाँ पर पेनल्टी को चैलेंज नहीं किया गया, बट उसके बाद भी कुछ लोगों ने कर दिया क्योंकि इसकी कॉपी ट्रेजरी ऑफिसर को भी जाती है. कुछ जगह पर नहीं होता है. जनरली जो होता है कि जो RTI कंप्लेनेंट है वो फिर से एक RTI लगाता है कि ये जो पेनल्टी की गई वो वसूल की गई या नहीं, और इसके बारे में RTI लगा के जानकारी हासिल करता है. अब जहाँ पर इसमें पार्टी बनाने का क्वेश्चन है, तो मेरी CIC साहब से डिस्कशन हुआ था इस बारे में, शत्रुघ्न साहब से, कि वाई से प्रभावी रूप से इसकी पैरवी आयोग करता है. उन्होंने कहा कि RTI क्लब वालों ने ही एक RTI लगाई थी कि लीगल एक्सपेंस आपका कितना होता है, और ये पाया गया है कि जितना वसूली करना है उससे ज्यादा तो ये एडवोकेट्स की फीस वगैरह हो जाती है. तो हम उसको किसी भी केस की पैरवी नहीं करते अनलेस इट इज ए कंटेम्प्ट केस, या जहाँ पर कोई व्यक्तिगत कोई ये हो, जैसे CIC साहब का भी अपॉइंटमेंट चैलेंज किया गया था शत्रुघ्न सिंह साहब का 2016 में, एंड दैट वाज ऑफ कोर्स अप्रूव्ड बाय द हाई कोर्ट कि दे आर एक्सपर्ट्स इन पब्लिक एडमिनिस्ट्रेशन एंड से उनको मतलब IAS ऑफिसर होने की वजह से उनको पब्लिक सर्विस और प्रशासन के एक्सपर्ट माना जा सकता है. दे आर नॉट डिस्क्वालिफाइड. लेकिन दूसरे फील्ड से भी
सबसे पहला RTI केस हाई कोर्ट के द्वारा जो डिसाइड हुआ था आपके टोलिया साहब के अपॉइंटमेंट को लेकर ही हुआ था.
हाँ, ये हाँ ये वो भी चैलेंज किया गया था।
सबसे पहला केस था वो,
इवन ही वाज चीफ सेक्रेटरी, यस कि
बिल्कुल,
ब्यूरोक्रेट
बिल्कुल।
को क्यों बनाया जाता है, तो चीफ सेक्रेटरी थे और वो केस उनके
और
फेवर
वो
में डिसाइड
कौशल
हुआ
साहब ने
कि
उसको चैलेंज
ब्यूरोक्रेट
किया
आर
था
नॉट।
RNP की तरफ से।
हाँ यस
Yes,
वो केस सबसे पहले हुआ था, और बाद में नमित शर्मा केस आया सुप्रीम कोर्ट का, बाद में नमित शर्मा का रिव्यू जजमेंट आया सुप्रीम कोर्ट में। और फिर ये जो
और आज की तारीख में ये
implementation की
कहता
जो
हूँ
बात है,
कि नमित शर्मा जजमेंट का रिव्यू मांगकर हम लोगों ने बहुत बड़ी गलती करी। CHRI भी उसमें इंटरव्यू था, हमारे नाम भी उसमें मेंशन है, और आज की तारीख में कहता हूँ कि आज अगर फिर से इस तरह का केस आए, हम जाके सपोर्ट करेंगे वो अग्रीमेंट, वो जजमेंट, क्योंकि कमीशन का हाल जो हम
अभी
देख रहे हैं
एक्चुअली भारत,
आजकल, इट्स नेसेसरी कि
हाँ
वहां पे जुडिशियल मेंबर को लेके आए, कम से कम प्रोसेस तो
हाँ
ठीक ठाक
वो
चले।
मतलब नहीं, उसका उसका एडवर्स क्रिटिसिज्म केवल यही था कि जज जो है वो अपने मतलब पोस्ट रिटायरमेंट रिहेबिलिटेशन को देखकर वो कर रहे हैं, इस तरह का एक क्रिटिसिज्म था उसके अगेंस्ट में, नमित
हम
शर्मा
लोग
केस
तो
के
बिल्कुल
अगेंस्ट में।
हैमर
लेकिन
एंड
वो रिव्यू
टॉन्ग्स
में
उसके
उन्होंने वो
खिलाफ थे।
करेक्ट कर दिया।
We made the
हाँ उन्होंने ये कहा कि दैट इज नॉट
strongest argument.
लेजिस्लेटिव इंटेंट।
Today I will not do that. Yeah. Today I will say no, वो
हाँ
चलने दो, डबल मेंबर बेंच बना दो, जुडिशियल मेंबर प्रिसाइड करे, एंड कम से कम प्रोसेस तो ठीक होगा कमीशन से।
हाँ
टाइम से
प्रोसेस
नोटिस तो
ठीक
मिले।
होगी, कई लोगों का तो नॉलेज भी इतना कम होता है कि किस तरह के जजमेंट वो दे रहे हैं, खास करके राजस्थान का तो बहुत ही बुरा हाल है। और इवन सेक्शन 17 में भी कुछ RTI कार्यकर्ता कंप्लेंट वगैरह कर रहे हैं, लेकिन वो बिना सुप्रीम कोर्ट के इंटरवेंशन के उसमें कुछ हो नहीं सकता।
सही बात।
और जो इम्प्लीमेंटेशन का मामला है, तो इसमें वसूली का पावर एज सच उसमें दिया नहीं गया है, जो 18(3) में सिविल कोर्ट के पावर दिए गए हैं उसमें ऐसा नहीं है। दूसरी प्रॉब्लम ये
लेकिन
आती है कि
एक्चुअली
जो जनरल
आपको
कॉजेज
अगर मैं
एक्ट
बता
18।
दूं, कर्नाटका
हाँ
में एक अच्छा इन्होंने सिस्टम बना रखा है, पेनल्टी का ऑर्डर निकालते हैं और साथ ही डायरेक्शन देते हैं AG's ऑफिस को कि इसको काटे unless PIO informs you that he's got a stay on the order. स्टे अगर नहीं है तो काटना पड़ेगा हर महीना तनख्वाह से, एंड दैट इज वर्किंग।
हाँ सेम प्रोसीजर यहाँ पर भी है। यहाँ पर जो उत्तराखंड की 2013 की जो नियमावली बनी हुई है, सो अंडर दोज रूल्स प्रोविजन ये है कि पहले 3 महीने कोई डिडक्शन नहीं होता, बिकॉज दैट इज द अपील पीरियड गिवन टू द PIO। और यदि 3 महीने में हाईकोर्ट में रिट नहीं होती है, कॉपी ट्रेजरी ऑफिसर को होती है, और ट्रेजरी ऑफिसर हैज टू डिडक्ट एंड इन्फॉर्म द कमीशन अबाउट ड्यू कंप्लायंस। तो इस
और
तरह का
वो
प्रोविजन
रूल्स
यहाँ
हमने
पे है
बैठ के
नियम।
फाइनल किए थे उत्तराखंड भवन दिल्ली में, कोटिया साहब के साथ।
अच्छा सुरेंद्र सिंह रावत वाज द, वो जब
एंड
ये
ही वाज द
GAD
सेक्रेटरी
थे,
वो भी आए हुए थे।
हाँ सेक्रेटरी GAD थे, बाद में फिर वो आयुक्त बन
2012
गए
के
थे
बहुत ही खराब रूल्स बने थे ना उसके बहुत लंबी स्टोरी है आज की तारीख के लिए। आई थिंक इट्स नॉट वेरी टॉपिकल। ऑलरेडी गौरव इज टेलिंग अस कि टाइम निकल हो गया है, सो वी शुड बी ब्रिंगिंग दिस सेशन टू अ क्लोज नाउ। सो
मैं जो PIO था तो सर लगभग 80% केस तो मैं अपने लेवल पे निपटाए, लगभग 14% मेरे खिलाफ फर्स्ट अपील हुई, और लगभग 6% केसेस मेरे खिलाफ 46 केसेस सूचना आयोग में हुए। तो लगभग सभी CIC और IC के सामने अपेयर हुआ हूँ, और सभी सूचना आयुक्तों की मैंने डांट भी खाई है, तो उसके लिए बहुत कुछ सीखने भी मिला है।
ओके, थैंक यू
सर।
सो ओवर टू यू गौरी जी।
Thank you so much, sir. It was indeed a very enlightening session. Thank you so much for sparing your precious time for us and the participants. So this is the formal end of our first technical session. And we will again see you all tomorrow for the next session at 4 p.m. Thank you so much, sir.
Thank you. Thanks
Thank
to
you, sir.
everybody. All the best. Take care. Good night.
Thank you.